one of a kind of program where dignitaries across all the spheres are participating in this conference, revolving around one of the most crucial themes of the present time, that is, the legal dimensions of global trade at the rate 2047. Under the exemplary leadership of our Honorable Prime Minister, Sri Narendra Modi ji, as India aims to become a developed economy by 2047, global cooperation is of utmost importance. And to capitalize it, ease of justice is crucial. Emphasizing the importance of legal system, I would like to quote our Honorable PM's word, Nyaya Moolam Swarajyam Syat, meaning justice is at the root of independent self-governance. And without justice, even the existence of a nation is not possible. Therefore, today, we will be covering broad contours of role of legal system in envisioning the aim of Vikasit Bharat, regulatory reforms required in the sector, adoption of innovation and dissemination of best practices in India's judicial system. Given the fact that legal sector is an intrinsic component of all the other sectors, SEPC takes an immense pride in being a binding thread tying different facets of the sector, such as legal practitioners, law firms, industries, academic and government institutions. And for supporting this initiative of ours, SEPC extends a heartfelt thanks to Ministry of Commerce and Industry, Ministry of Law and Justice, our Honorable Chief Guest, Honorable Attorney General for India, Dr. R. Venkataramani, Dr. Lalit Bhasin, in initiating this entire program, Chairman, SEPC, Mr. Karan Rathod, Mr. Rakesh Sharma, Chairman, Legal Sector, SEPC, for successfully executing this program, our knowledge partner and lead partner for the program, Saraf and Partners, other supporting program partners of the program, our media partners, and none less to mention, our eminent speakers and delegates who have spent time from their busy schedule for this program. Let's give a huge round of applause for everyone, please. Due to AG's occupancy in some other program, we are beginning with session 1, post which we'll have our inaugural session, please. So, without delaying it further, to begin with session 1, I would like to tell that this session will delve around the rules and regulatory framework for liberalizing the sector, its impact in the global scenario. For this, I would like to call upon stage, please, Mr. Mohit Saraf, founder and managing partner, Saraf and Partners. Sir, please, let's welcome him with a huge round of applause. In the sequence, I would like to call other esteemed panelists for the session. Mr. Srinivas Kotni, founder and managing partner, Lexport. Sir, please. Mr. Justice Zakiullah Khan, former judge, High Court of Allahabad. Sir, we welcome you here. Mr. Sumesh Diwan, managing partner, Lex Favios. Ms. Bhitika Anand, founder and managing director, Legal League Consulting. Mr. Kirit S. Javali, Barrister at Law and Advocate, Supreme Court of India. We welcome you all on the dais, please. Honorable Clifford Andre, Member of National Assembly of Seychelles, will be joining us virtually in a while. Now, I would like to hand over the stage to Mr. Mohit Saraf, the moderator for this session. Sir, please, you may kindly introduce the panelists and begin with the session. Thank you.
Thank you very much. I think let me first introduce Justice Khan. He's had over 36 years of practice, and actually he's gone through all. He's been an advocate. He has also been I would say, then magistrate and judge of the UP Judicial Academy, then the Principal Secretary Law for Government of UP, and finally the judge of Allahabad High Court and also Lucknow Bench. So I think we are very lucky to have Justice Khan with us, and he'll give perspective and in the entire legal opening up. There are a lot of challenges, so he'll give a judicial perspective, and particularly I think how the arbitration sector will evolve with opening up of the Indian legal market. Clifford Andre is not joined till now, okay. Then let me introduce Kirit Javali. He's actually did a law from UK. He ran a law firm in India, and now he's a counsel practice, and he's run a law firm for over 20 years. Very, very seasoned lawyer. He'll give perspective both from India side, from an advocate side practicing lawyer, and also from a UK bar about opportunities and challenges. Then we have Bitika Anand. She's one of the first person in, I would say, who advocated to all the managing partners, particularly a lot of firms in India were family-run firms and not professionally run, and she advocated how to make these firms professional. So we have Bitika with us, and Justice Lalit Bhasin is there, and he's been, I think, sir, you should join here, because I think this is an area which is close to your heart, and I think we should get your perspective as well. You are all close to me. Then I have Sumesh Devan. He's a managing partner for Lex Favius, again a law firm with over 25 years of experience on the corporate and on securities market side. And I have Srinivas Kotni. He did not send his CV, so I don't have proper, but he's been running a law firm, very, very able and a strong corporate lawyer. I've known him, but I just don't have the CV with him. So with that, I think the more important part is that every year, every time people call us from the UK, the English market, the American market, and says, are we close? And I said, yeah, we are very close. I said, I hope you don't tell me it's just a year away. And this has been going on for years now. I would say somehow we have not been able to open up the legal market. And that's, in my view, also gives us a great opportunity. And I would say, particularly if you look at the service sector in India, the last year, the revenue number, the total export from India on the revenue side was $250 billion. And obviously, a Minister of Commerce is very aggressive, wants the service sector to grow up like crazy. So he gave a number of $1 trillion, which is like 3 times the size by 2030. And large part of that has to be supported by professionals. And I believe legal industry, both export and import, and particularly I think when you export and import is more often, I would say it's you can look at Indian legal market as Indian law firms as import substitution. So I would say that's a great market, and there's a great opportunity to grow up. But I would say, let me go to you, and you have seen the movie for a long time, both from the UK and from India. So why don't you tell your perspective, particularly in light of Balaji case and the present BCI rules, and what do you see, and what are the perspective really? Walk us through the the regulatory framework, and then we can add and we can get into discussion.
Sure. Thank you, Mohit, for the kind words and question which you posed now. First of all, I'd like to thank SCPC for the kind invitation, and happy to be here, and I'm sure we'll have a very fruitful session. And so coming straight to the question, I think the Indian, ever since I was doing law, and I was fortunate to do law in the UK, and this was way back in 1992, and that time India had just opened up, the Indian economy was opening up, and liberalization took place in 1991. And there was a lot of buzz that the Indian market is huge and there's a lot of potential. And last 20 years, 25 years, I've been hearing that the market is opening up. So whenever I used to visit the UK and meet with law firm partners, the buzz was, again, when is it opening? When is it opening? And things are going to happen. But obviously there were bottlenecks as we went along, and 2 steps, 10 steps were taken and then 5 steps backwards. But we've come a long way. In terms of the litigation side, there were always some cases which were initiated. It started with, in 1995, in the Bombay High Court, which culminated in a different way. The issue there was whether foreign law firms can open up a liaison office and practice law on the non-litigation side, which was the issue in Bombay High Court. And Bombay High Court said it was wrong on the part of RBI to give the license for a liaison office. And the question was also the practice under Section 29 of the Bar Council, on the Advocates Act. The question was whether the phrase practice in terms of the profession, what does practice really mean? Does practice mean only appearing in courts or also on the litigious side? I think that was sorted out also subsequently in a case known as the A.K. Balaji case, which was filed in Madras High Court. And there it was clarified that law practice is not limited to only appearing in courts. It is also advisory and opinion-related work. So that point was also sorted out. And the question then really arose why these cases were filed, whether foreign lawyers can appear or law firms can appear and register, do practice in India. And that was a whole dilemma which has been there for many years. Essentially, the position now, after the Supreme Court passed the order, was that foreign lawyers can fly in and fly out. And as long as you do not spend more than 60 days, you can provide advice on foreign law and on international legal issues. You can also advise and represent their clients on international commercial arbitration, those seated in India. So there has been progress. Then we've come up with the BCI notification in March of 2023. That is where the challenge is now, where we are placed. And I'm also informed that there's a writ which has been filed in the Delhi High Court and which is coming up for hearing on April 24th. So we are very well positioned to understand where we are going to go forward. But that is primarily whether the Act permits the BCI to issue such a notification. So as we speak, there is a lot of action which is going to happen. But I think the way forward is definitely there's a lot of opportunity, and we should not lose the opportunity in terms of going forward and keeping with the globalization process. Thank you.
Thank you, Kirit. I think just to give you an idea, in 2018, the Supreme Court felt that any practice of law, both litigation and non-litigation, is part of advocate and can only be done by advocates in India, and except people who can fly in and fly out. And when the thought process was, and as per the RBI rules, if you are not situated in India or you don't live in India for more than 180 days, you are not tax resident for the purpose of income tax. And therefore, law firms and lawyers flew in and did a lot of legal work in India, and they understood that the limitation was 180 days. But what really the Supreme Court said, that really the rules have to be framed either by the government of India or by by BCI. And then we had 2023, BCI came up with the rules, and it is largely based on reciprocity and registration, really. So every law firm, international law firm or an international lawyer as long as the lawyer practicing in particular jurisdiction, they provide reciprocity to Indian lawyers, they can actually practice and they can apply for registration. That is really the large part of it. And therefore, to that extent, when you apply for registration, you obviously pay fees and you get part of the disciplinary proceedings of BCI. And that also, again, when you do that, then typically, as all corporate and business lawyers will say, what do you get in return? And I think what you get in return is more restrictive than it used to be pre-2023. So today, you virtually can practice a limited part of it, and if you are not registered, your dates have come down from 180 days to 160 days, pure 60 days. So really, there's a lot of challenge, and I would say Kirit was very kind that it said that 10 steps forward and 5 steps backward. I probably would have said 10 steps forward and 20 steps backward. That's where we are. But again, having said that, I think if you look at India as a country, and Ministry of Commerce is organizing this interesting seminar, I think every sector has opened like that. And from a $1 trillion economy in early 2000, we are $3.65 trillion. And no sector has opened up so quickly. I would say whether every area, defense, if you remember, offset commitments and things like that. So really, I think we all in India understand challenges, and we are all geared up to build opportunities out of these challenging environment. Justice Khan, let me ask you, particularly I think since you're very active on the arbitration side, and foreign lawyers now will be permitted to practice, particularly on the arbitration side, on international arbitration, and if we can get your perspective.
Thank you very much, Rohit, for introducing me. And as far as the development is concerned, we are basically here to discuss about the developing economy. And the developing economy is one of the major thing that one should follow. And for this, it is necessary that legal terms should also be liberalized in such a way that the other person should come in and we should also go there. That is the two step forward and two step backward, what the other speaker said, that this is one of the basic essential of the development. And since there are a number of layers in the arbitration, say arbitration field, mediation and conciliation, they sometime the foreign liars come and we entertain you. As a High Court judge, I remember, as one or two cases, there was the opinion of some foreign liars, and then we regarded that to be important, and we took it for granted, and we acted on that, and we ultimately we gave him the concession to act like that. And this should be the practice in the other countries also, that we should be given our liars should be given certain things. As far as the Bar Council is concerned, Bar Council has given certain rights and has given certain concessions, and I think that all the concessions should be given, more and more concessions should be given, because in order to development is sole development is not possible unless until we participate in a event. We can't enrich the development side, and for development to grow more and more, we need to be we need to associate with other persons, other countries, other liars also. And if we are confined to the India or Indian scenario only, then we will not be able to do things. Recently, one of the persons, I remember that he came to me that he has entered into contact with some US firm, and US firm has given a verdict that my rights are to be taken away. Then he said, what's your opinion? Can you give me an opinion that in Indian courts I can sue? Then examined the entire detail and said that, and they barred specifically the jurisdiction is barred of the Indian other courts, except the courts at Florida and all that, where I don't remember exactly the state. Then I just said that the legal principle, legal norms are same on whatever be they. May it be United States, may it be, because we are guided by the Anglo-Saxon tradition. And Anglo-Saxon tradition says that the legal norms should be obeyed throughout the world. and that gave rise to the natural law of principal justice. Whatever may be the rules and that. So I said that why, if he has barred your jurisdiction, the jurisdiction of Indian court, it doesn't matter, because the contract took place at India, and you are enjoying the benefits in India, and you are giving just money, share the money to the United States. That is, yeah, everything is in India, every aspect was done in India, so how can you be debarred from filing the suit in India? So he filed the suit, and Delhi High Court entertained it, and then after, he didn't meet me, and therefore I couldn't know what happened. But in fact, the Delhi High Court entertained, and Delhi High Court issued notices. Similarly, whenever there's an arbitration and other things, in arbitration, there's a section 34(3) of the arbitration, that is, the award should be taken for, award should be executed or not, or award should be set aside. In those proceedings also, this matter should be taken away and should be considered, and the person who has given the arbitration, sometimes they are the foreign liars, sometimes they say that we have been at the receiving end and we have not been given opportunity. Then they must be given opportunity, because an award is not the thing that one should keep itself. The award is a simultaneous process, and so many persons are the part of it. And whenever they pass the award, that means that a matter has been settled and a right has been settled. And for creation of right and creation of other things, it is necessary that the person, more and more participation should be there, and more liberalization should be there. And whenever it is a matter of question that whosoever participate, that should be the Bar Council should be lenient, and the government of India should frame such rules, and otherwise, and also we expect other countries to frame similar rules and similar laws, so that we may also participate there, and we may also put our grievances there, because this is a worldwide thing, and you can't say that if a commercial thing is going on this country, then this goes to overall the world, and into the entire world. There should be one thing, and it should not be. It should not be followed, and the matter that everyone should follow these norms, and everyone should go through it. It's necessary, and it's necessity of life and necessity of the time. And therefore, for being a developed economy, we definitely need for liberalization, and we need for others to cooperate and others to participate in.
Thank you, Justice Khan. I think the very good perspective. I think, again, important part, as Justice Khan said, that there has to be a lot of, I think everybody should have a right for audience. Unfortunately, I think the BCI rules actually talks a little bit different thing, and I must point it out, that foreign law firms are not allowed to hire Indian lawyers. And if they hire Indian lawyers, they will actually be paralegal. So they can't even practice as an advocate. So that's probably a little bit of a different regime. But having, I think, in the era of diversity, Bitika, we should come to you first. Third, maybe not first, but third, and get your perspective, because you interact with a lot of Indian law firms and global law firms. And how do you see, what are you hearing? It's been almost a year now since the rules have come. The application form has not come. There is as Kirit said, that there is a litigation going on in Delhi High Court. What are you hearing, and what is the level of interest on the opening of the legal market?
Thank you, Mohit, and also thanks SCPC to give me this opportunity to talk about my experiences. So I have been now engaging with a lot of Indian law firms of all sizes. So it's not only very large law firms or mid-size, or they're all startups, people who are, now starting law firms also. So the general feeler, and also with international law firms, the general feeler that I have got from all the firms is that they are looking for the opening up. Obviously, no doubt, some of the things which Mohit said, and a lot of professional bodies, whether it's BCI, whether it is, Bar Council or SILF and all, they have, discussed the challenges that are there. But in spite of that, I think because this topic has been now discussed for such a long time, I feel the Indian law firms are pretty prepared for it. prepared for this change, because see, human nature is like that, and I think lawyers are unique in their, the way they work. So I think they're all prepared for, if this happens, what opportunities are there for them and how they will deal with the challenges that are there. So, and I also feel that to bring this change, to have this change, that it is necessary to take that first step. Obviously, dialogues are needed, discussions are needed. There's a lot of exchange of notes. 2016 was the year when a lot of communication happened between various professional bodies, state bar councils, whether it was, to bar councils, all these, I mean, I'm not going to name them, I don't even remember, but it really, was discussed at length, and somehow it didn't happen. So also one more thing is, I feel that other than Indian law firms, even international firms are looking forward to it. The other very important point is that in 2014, when the new government came, a lot of sectors opened up, which I think Mohit also mentioned, and Kirat also mentioned that, but those sectors which are opened up, a lot of funds came in, the capital was infused into the country, and if we say, look at those sectors, whether it's defense, they have boomed. They are perfectly fine. So that change at that time also must have bothered the domestic players, right, in the market. But it has done so well. So if you look at any change, if you look at liberalization, also the meaning of liberalization is to relax the norms and this thing for the overall economic growth. And I feel that if it is done properly, I'm not saying do it ad hocly, the dialogue should happen, but to a limit. All the agencies, all the bodies who are involved, whether it's the apex body, whether it's the government, they should also have some sort of a common view, because it doesn't put India in a right perspective with the international world. Because I do hear comments that it comes up, when is it happening, now it's not happening. It doesn't, like India doesn't have a good picture, like it doesn't look nice. That is one. And secondly, while I was talking about the privatization and all that, so Indian law firms are also going through a lot of change now. It's not what it was 25 years back. Look at the technology. So there is also disruption happening amongst the Indian law firms. There is technology coming. There's a lot of competition. Fees are not what they could charge when the recession was not there before 2004. It was all on hourly basis. But now it is mostly lump sum. I could be wrong. I'm only giving through my experiences, the firms I've interacted with. And and also, I would say good talent to do those high-end, transactions and all. There is a dearth of good talent. What I feel is, if in any way, I'm not saying what is the way to do it. Like LLP is not allowed in India as of now. If it is allowed, then if some way the funds can be infused, we can see the entire Indian ecosystem, whether it is training institutes, whether it is education, whether it's good universities, whether it is, educating, bringing processes and systems in your law firms which are not there. If you look at in that way, obviously it is, and I think in 2016, Bar Council and SILF agreed and welcomed the foreign law firms into India. But there are certain challenges, and I think those challenges should be discussed internally, and every of these different professional bodies should come to the same conclusion, and then go to the higher authority or whatever way it can be then decided. Deciding 1 year, I think Mohit said, like, deciding in one, taking it off in 1 year, it doesn't. I can share my very personal experience. I was flying down to London in 2016, and by the time I landed, I think the Bar Council, withdrew maybe these rules at that time, when the SILF had also presented the notes to the ministry, and maybe Lalit Bhasin ji would remember more because they did it, and also the Bar Council also gave new rules at that time. And also, I think Department of Commerce also presented a draft note on the roadmap of legal services to the interministerial group in January 2016. So a lot happened in 2016. After then, again, there was a lull. There was a lot of talk of fly in, fly out, and foreign law firms doing allowing international arbitration in India. So that is what my experience is.
Thank you, Bitika. I think a very interesting point that every sector which has opened up have led to a lot of modernization, growth. I think in 1991, we were a $500 billion economy. Today, we are $3.5 trillion. So I would say 7 times in this period. So obviously, investments have grown, and investments have led to productivity increase and profitability and growth. But I think one challenging phase, and I'm not saying that that should be the reason why you should not open up, but one challenging phase is that investors and third-party funding is not permitted in legal industry. And like in the defense, you can invest. Here you cannot invest, so lawyers have to invest. So that's a little bit challenging. But I remember that when I was a kid, my dad used to tell a joke, and I still remember that he told me, it was because my grandfather was a lawyer, so he was telling a joke about my grandfather. And he says basically in a village, one lawyer came and there was no practice, and then one more showed up and the practice started booming. And then 5 showed up, and then it multiplied. So I would say that's really what it is. So I think more lawyers come, practice grows up. I think that's an important part. And I really believe that really, for me, opening up a legal market really means our fees going up, I would say. I think that's the way I look at it as an opportunity for me. And I feel that we should probably, being a third world country, we work very hard and get paid like third world. But I think with opening up legal market, we'll work like a third world and get paid more than the first world. And that's an opportunity in my view, clearly. So I would say, Srinivas, why don't you give your perspective? You run a law firm, give your perspective about opportunities, and how do you see how ready you are? How do you see this entire opening up legal market and what it poses to you?
Mohit, first of all, let me introduce myself. I've given my CV thrice to the team, so unfortunately it did not reach you. I'm sorry for that. I run this boutique law firm, Lexport, for the last 24 years. Before that, for about 6 years, I was working for larger firms as an intern and an associate. I started very young, at 26.5 years age. So I was not as experienced as you guys were when you started on the entrepreneurial note. So I have grown with the system. So my take is a bit radical in that sense, that fearless, just do it. Because we have to have method to madness. We need to have systems in place, like Bitika has very eloquently stated how one can make a legal practice a very challenging and a profitable one. And you also spoke about the limitations. Because today, you very well understand that running a legal practice is just like running a business. You need human capital, which is most vulnerable, very, very unpredictable, and very expensive. If you want best lawyers, you will have to pay. If you pay peanuts, you get monkeys. I mean, it's as good as that. I mean, you have to train them well. For training, there's a lot of expense. You have to do all this branding and all these efforts to make yourself visible. Those are expenses. To run a nice office, that's an expense. So why don't we accept that there is we are like blindfolded men in a dark room. We don't recognize the elephant. So we need to address the problems on the face of it and understand that it is a business, and then start our whole journey towards that. So opening up, we have seen how our country was before 1991 and how it is after globalization. Every sector is getting opened up. So though there may be emotions, there may be issues, initially teething issues, but eventually you'll fall in line. And at the end of the day, we talk about competing with the world. When we are competing with the world, when we want, of course, reciprocal arrangements, even the Act talks about it, so it has to be there. But we need to take the challenges head on and train ourselves better. It's not good at all that the mushrooming kind of law schools coming in. It has to be quality oriented. Like five-year law programs, the national law schools, or the universities which are focusing on quality legal education. So fortunately, many intelligent kids are coming into the profession. So we have to give them an environment of competitiveness and competence. And as you said, more the lawyers, better the competition and better the quality, and we are going to improve with that. I think that's my take on the issue. We have seen how 1990s liaison office was not being permitted, right? And eventually we agreed for some kind of a modified version of, welcoming foreign law firms and foreign lawyers, though it is a limited manner. But of course, if they don't allow us, we won't. And we have a WTO structure, we have the agreement on services. We have to follow that eventually, whether it is goods or services. And legal services are one of the services. We can call it noble services, but then you know very well how noble the services are, right? So, legal services authorities are all, in the junk. Who goes, you and me are not going and then helping the poor man out there. So it's a commercial enterprise. Let us first understand it and then work on that. And we need investment, we need growth, we need the modern outlook.
Thank you, Srinivas. I think we have right now from beautiful Seychelles, Honorable Clifford Andre, who's zoomed in, and delighted to welcome you. And just to give you a little bit introduction to Honorable Andre, that he is one of the premier lawyer of that country. He's trained in the UK, have been practicing over 20 years, and he's also a parliamentarian. So really, he regulates, and he works on enacting laws. And we in India also have a lot of very famous lawyers who are also parliamentarian. And I think our earlier our law minister, Arun Jaitley, and then he became a foreign finance minister. He was also a lawyer and a parliamentarian. So I would say, and Andre, I understand that in Seychelles, how do people like you work? I can't understand if you have such a beautiful beach resort, then work must be a really challenging. So I'm sure you must be really motivated to look into these boring papers and argue and make laws. But otherwise, if I was there, I probably would be sitting in the beach. But thank you very much for joining us. And I understand it's early morning, so you still have a day for the beach. So give us your perspective, particularly I think how foreign law firms open shops in Seychelles, and how had it impacted local domestic lawyers in Seychelles? I think that will be an interesting perspective where I understand a large Indian community has a lot of resorts and business interest in Seychelles. So give us your perspective, and how have you seen the market evolve in Seychelles? And I think we can relate to that and understand how it has happened, and it eventually will happen the same way in India.
Okay, good morning, everyone. Good morning, Mohit. It is a pleasure to be part of the panelists and sharing the experience from the Seychelles perspective. I, having been introduced, I've studied in UK. And yes, it is early morning on a Saturday morning in Seychelles, but that's no issues. So after my studies, I came back to Seychelles. In fact, when I was doing my studies, I was in the military. So I've studied in India as well, military law in India, and given me a perspective, and I know how India is. So from the Seychelles side, the constitution initially did not allow foreign lawyers to come in. We had to have a vigorous debate, recent years, in fact, to allow foreign lawyers to come in. But foreign lawyers are restricted to non-litigating aspects. So they do not litigate in court. However, if they are to litigate in court, they need to have a special permission under the license of a local lawyer for a specific purpose and for a duration that is detailed and given by the court, by the Chief Justice. It needs to be an application made to court where the Chief Justice will hear the matter, or another judge, but will give a time frame for a specific case. And after that case ends, the permission ends. If it is to be renewed, it will be renewed in another capacity, in another case, for a specific reason. So, but we do have foreign lawyers in Seychelles having non-litigating roles, like in the International Corporate Service Provider, which is offshore. So you have foreign lawyers, but what they do is they link up with a local Seychelles lawyer. But if it is for International Corporate Service Provider, they will provide these services without having to every time and again renew that permission. So for other, like if we have financial legal services, and someone from India comes in with the specific qualification in respect of financial legal issues, they will be able to open a firm, but with a Seychelles lawyer, so that they will provide the services that comes with it. But in that respect, a Seychelles lawyer would partner with an Indian firm or an Indian lawyer in the capacity that the business is coming from India as well, or coming from elsewhere, and the expertise required is specific with regards to India, Indian customers, if you want to say, so that the business will be growing and growing and growing. We are having this. We are having a number of businessmen. In fact, we have a lot of businessmen from India. We have Mr. Siva from India who invested in properties, in real estate, and he's in Seychelles. So not in Seychelles, he's in India, I believe. Sometimes he's in England. So we do perform those services for those clients as and when they require. So it is something that we are opening up to, but we need to have the interest also from the legal sector in India. You see, it's opening up, so we need to get the services. And should there be any interest, in fact, if I can share with you, is that we're having some Indian lawyers who are working with the Attorney General, because this is state-owned. We're working with Attorney General, and then when they go back, they do partner. I mean, I have one who's partnering with me, who wants to partner with me when he goes back. So we will be having business on both fronts. And it is also like, if for the Seychelles lawyer there's a case, we can send the brief or the research that is required to be done, because it may be easier to do the research from your side, and the research is done, and the case laws and everything are sent to us, and we can use it. Being from Seychelles and having the beach, let me know when the time is to. I have the time for me to stop, so I can wrap up. Yes, we are being in the Seychelles and having the beach so close to us is no negative impact to us as the Seychelles, because we are used to it. We know that tomorrow the beach will be there, the day after the beach will be there. However, if someone comes from India and seeing the beauty of our country, we want them to work and use the beach during the weekend. So hopefully they will do this. As stated, I am also a member of parliament, so I spend a lot of my time. In fact, I am the chairperson of the Scrutiny of Bills Committee. It allows me to go through the bill that is coming to the Assembly. So I have the opportunity to ensure that every law that is coming, I have a preview of it prior or during the stage that it is being drafted by the executives, because our system is different. So our system is those that are in the executive are not in the parliament, and those that are in parliament are not in the executive. So We only have one person who links between the executive and the parliament to see about their laws. But we as a parliament, we can, even if we come from the same party, we can reject a piece of legislation that comes before us and allow this legislation to go back to government, or if in the drafting stage we are called in early, we do put our viewpoints and it is taken into consideration. Sometimes the bills are withdrawn and reworked on so that it becomes something that is more effective when it comes back to parliament and it is enacted and it goes to the people for implementation or to the respective entities for implementation. So to wrap up, the Seychelles is opening up, but not for litigation. Not for litigation for the time being, maybe later, but for the time being, not for litigation, but for other professional services. So anyone with professional capacity to assist can come approach a lawyer. I am available, and we can cooperate to see how from India, if it's coming to Seychelles, how we work, from Seychelles, if it goes to India, how it works. So the door is opening, despite the fact that it is not opening that fast, but we've had a lot of foreign entities coming in. We do have Appleby in Seychelles. We do have other legal firms, well-known legal firms that are operating in the Seychelles. So this is the Seychelles take on the Indian perspective as to how you can come to the Seychelles. So if there's any questions later, I am happy to respond. However, my contacts are with the organizers, so anyone can get in touch with me easily.
Thank you, Clifford. I think this was very helpful. Like India, I think basically the litigation thing is kept out of the box. What is permitted is non-litigation, advisory, and non-property related. I think even property related is outside. So I would say similar thing. In Seychelles, you probably give license to practice. In India, we have moved away from licensing, Raj, since 1991, so no more licenses, except the BCI will issue license and registration. And again, similar issues, like in India also, like what I heard from you, the reciprocity is very important. So there, the Chief Justice also, I understand from Seychelles, that if we feel that the person is competent and in the regime he practices, there is a reciprocity, he'll be permitted. So I think it's a similar structure, but yes, obviously not same, but I think similar thought process. But there's a lot of interest in India, as what Bitika mentioned to us. International players are interested in opening an office in India, practice Indian law and foreign law, depending on the regulatory regime. And in India, right now, the partnership with foreign law firms and lawyers and Indian lawyers are not permitted, but you can employ them and they can work as paralegals. So that's a little bit different. But I think let me come to you, Sumesh, and really talk about really the opportunities and challenges. What you see, you've been running a law firm. How do you see it from your perspective?
Yeah, hi everyone. Thanks Mohit, thanks organizers. It's a pleasure to be here. So to begin with, we see it as a big opportunity because I know there's been whole conversation about challenges Indian law firms face and how there is not a level playing field. But that discussions will continue to carry on. But it's, I personally believe, and that's the pulse of I will see most of the law firms now. Everyone feels it's time the foreign law firms should be given access to come in, because it will lead to opportunities for all. To begin with, we as law firms, so I've been running so I was a partner with the larger law firms, and 9 years back I set up my own firm. So I've seen both sides from the perspective of, the larger law firms and a mid-sized firm. So, but when we see, coming back to the question of foreign law firms, the foreign law firms to begin with have a lot of interest. So when last year when the regulations came in, we got a lot of conversations and calls from foreign law firms. But again, things not been moving in our direction as they would like. And again, from the chat, I say, there is a great prospect. We have to see that, if the foreign law firms or the regulations are liberalized, it's not to the, I would say more than the foreign law firms, it's the Indian legal sector which would benefit. because there will be a huge investment coming in. And then these foreign law firms, when you see examples of Singapore market or a Chinese market, Singapore is a beautiful example where the domestic firms and foreign law firms coexist. So in fact, most of the European and US law firms have now made Singapore as their Asian hub. And they bring in not only investment, but we bring in expertise. Because I think we are at a stage where the law schools are mushrooming. You have a new law school every morning. There are so many lawyers who are not finding employments, they are not finding jobs, and we don't have access to a technology or expertise. So I think bringing in a foreign law firm, obviously there will always be a debate about how it would have an impact on existing firms. But say again, obviously all my co-panelists and BCI regulations are very clear that first of all, it does not impact the litigation lawyers. So that perspective is completely out of the question. Of course, they will not come and practice, on a dispute side. But again, on the advisory side, so I would like to say, because the biggest challenge and the biggest opportunity for all of us is that once you have a foreign law firm coming in, they will bring in a lot of technology, a lot of expertise, and obviously also there will be outsourcing of global legal work. Because right now, when we work on a cross-border transactions, let's say we recently worked on a transaction where a company, an Indian company acquiring an Australian company, and the Australian company was held by a Singapore entity. So, when you're doing multiple jurisdiction work, then you have to go and pitch to each firm in each jurisdiction. Because those foreign law firms coming in here, they would be absolutely what has happened to the Singapore market. You will see a lot of legal work coming in here. So when I say investment, it will be a huge, not only job creation, where a foreign law firm would typically not only invest and grow the market, but they would also look at bringing in or outsourcing more business to the market here and entail, benefiting all of us. So I think it's of course, there would be more dialogue and discussions required, but I think it is a scenario where it's time we move ahead because, restricting foreign law firms is not helping anyone. I believe it's harming more the existing legal players because as Mohit also rightly said, we are all at a back foot where we are not billing what we expect us to bill. We are all on a, when we see our billing rates in comparison to a Singapore or any Asian law firms, we find that, it's ridiculous to see we are not even billing a fraction what we bill. And that will also give a big boost because we are not retaining talent. And also, on the lastly, I think there's been a lot of things that Indian lawyers can't practice overseas, but there I differ. Because I have a lot of friends and a lot of people I've known. You can go to UK, pass a solicitor exam. You can go to New York bar, pass an exam or a California bar exam. And those guys have dual qualifications. So a lot of Indian lawyers have gone overseas. They are working with foreign law firms. They have dual qualifications. We don't have a system. So absolutely, the Bar Council doesn't allow a foreign law firm to come and give a bar exam and start practicing as a dual qualified lawyer. So these are all issues which need a deliberation, and definitely I think it's time we take a step forward and help the entire legal fraternity grow.
Thank you, Sumesh. I think what you just said is that it makes a lot of sense, commercial sense, and we'll all benefit. And we have actually Mr. Bhasin here, and he has been forefront of the opening up the legal market, and as Bitika said, since 2016, and we cannot let him not share his perspective because I was wanting him to get a perspective of all the panelists before I invite him. And Atul Sharma, you are one of the beneficiary of this opening up in a different way. So you will be the next because we would like to hear your perspective. Mr. Bhasin.
Thank you, Mohit. Honorable Justice Khan. Who is stopping whom? No one has addressed, you see, this basic question. No one has addressed the issue, although it was mentioned in the passing, that the Supreme Court has said only Indian citizens have the right to practice in India. Therefore, to overcome that, what steps have been taken excuse me, by our legislature to make a simple amendment in the Advocates Act that subject to regulations and subject to permission by the Bar Council, foreign lawyers can also practice in India. Therefore, the entire discussion is academic. Till we cross this threshold bar, the Supreme Court judgment will stare us, you see, in our face. And as Kirit has rightly pointed out, that is the issue which the High Court will decide now. That how can BCI frame certain rules, you see, which go against the letter and spirit of the Supreme Court judgment. They say foreign lawyers will come here, but if they commit some professional misconduct, that will not be decided by the Bar Council of India. It will be decided by the regulatory authorities of their jurisdictions. And reciprocity, what are we talking of? Baker and McKenzie have got hundreds of offices. So reciprocity with which jurisdiction? And US. Each state has got its own autonomous regulatory system so far as legal practice is concerned, because within the United States, you cannot practice from one state, you see, to another unless you fulfill certain requirements and all that. Therefore, the issue here is we are not opposing. We means that I represent the Society of Indian Law Firms as its president. I also, as the immediate past president of the Bar Association of India, we have supported, you see, the Ministry of Commerce when, as Bitika said, when a presentation was made to an inter-ministerial group that foreign lawyers should be allowed in a phased sequential manner. And as Sumesh has said, Singapore model is the best model to be followed. Phased sequential entry, not just open up the doors. But even those doors you can't open up till you overcome the Supreme Court judgment. Therefore, the idea is, you see, that we should, if at all the authorities are willing to do so, the law ministry, now of course elections are there, no one is going to do anything. They should just make a simple amendment. We want foreign lawyers to come here, but they cannot set up their law practice because Supreme Court bar is there, and that eventually will prevail. Therefore, any rules made by the BCI are of no consequence at this point of time, and I can tell you, I know it personally also, I've got documentary proof that they have kept these rules in abeyance. They made a statement in London, you see, that we are keeping these rules in abeyance till we decide, you see, the issue of how and in what manner. And we have given them the draft regulations also. Therefore, as a profession, we welcome, you see, foreign lawyers to come. It will lead to a good, healthy, what I call cooperation and competition between our professions, you see, and their professions. It will give our young lawyers also, you see, to learn from foreign jurisdictional laws. It will help. But then you can't just say because other sectors have opened up, you also open up. Other sectors are business and commercial sectors. You can't compare, you see, a service sector like legal profession with others. Someone cast a doubt, you see, he said whether we are a noble profession or not. I think we are still a noble profession. As our ministers, they gave up their lucrative practices, whether it was Arun Jaitley, Ravi Shankar Prasad, Kapil Sibal, Chidambaram, they all gave up their lucrative practices to do service for the country. So we are a service-oriented activity. We can't say, okay, businesses have opened up, let foreign investment also come in. Like in UK or in Australia, you are having listed companies. Law firms are now listed companies also. So where are we heading for? So let us, I think, follow the Singapore model, phased sequential entry, but first try to overcome this fundamental problem. Thank you.
Thank you. Thank you, Mr. Bhasin. I think it is a very good perspective that Indian law firms, Society of Indian Law Firm, supports opening up of the legal market, but in a phased manner, in a joint venture manner, and that will lead to growth. I think clearly, I think we all appreciate that perspective. And again, very important part, because this really comes from Advocate Act, that the people who are going to practice law in India have to be an advocate and it has to be a citizen of India. And that's really what was reiterated by Balaji also. So really, at the end of the day, which you are absolutely right, that anybody who is allowed to practice law in India, if he's an advocate, then he has to be a citizen of India. And this is not really an Indian law firm issue or industry issue. It is largely a legal issue, a legal impediment. And this is what is being challenged at the Delhi High Court. So I think instead of wasting time on that issue, I think this is important is that this issue gets sorted out. Atul, we want to get your perspective because I think you are one of the first few who have built up a very interesting firm over the years, and now you have a JV or a structure with Denton, and we worked with Denton for a long time. So you give your perspective how this is helping, and I would say really, and a lot of audience here would be interested in listening to you.
But Atul has not acted in breach of any law or
No,
regulation.
I'm not disputing that.
I don't need to say anything more.
You have a counsel there. You have a
Mr.
counsel there.
Bhasin's support.
He's done something unique.
No, I think the larger question, what has prompted us to do this? We need to get that perspective right. Well, I am an old time, in fact, I'm a prodigy of Mr. Bhasin. We all know this is a noble profession. But the fact of the matter is that we have been outmaneuvered as a country in the legal services by the West. First, we recognize that fact. We have heard that we need to walk the talk in terms of what the model is going to be, how it is going to be implemented, what is the mode and manner, where it's phased, whether it is full-blown, whether you'll allow ownership. That's one part of the whole problem. The larger problem that we have is today, by not taking a decision and by not ensuring that we do it in the right manner in the interest of the local lawyers in India, we have deprived all our youngsters of the best quality of work. I'm not even talking of practices. Practices also is a component. But we have deprived them of the best quality of work. And I think I'm not wrong. I'm sure Beetika sitting on the panel, you, Mohit, having practiced so much of international work, would support this statement of mine. 80% of the transactional work in relation to Indian businesses, whether inbound and to a large extent outbound, obviously outbound, but to a large extent inbound as well, is being executed by dual qualified lawyers, not in this country, outside of this country. We have no business to deprive our lawyers, young lawyers sitting in this country, to do that work. On the contentious side itself, I believe at least 20 to 25% of the decision-making, the preparatory work, the preparation of the cases, the evidence preparation, all that is happening outside of this country. Again, we are depriving our younger people to have access to that work. We owe it to them as people, and I'm sure Mr. Bhasin would support that. We as people who have a particular generation have set up these practices to ensure that, all the youngsters, the juniors, they do get their dues in terms of exposure, in terms of, because the whole profession has changed. In the last 20 years, 30 years, it has changed in India. We have brought in the law firm culture. You have been a significant part of it. Large number of law firms have been set up. We have professional managements. But then if we don't give them that kind of work and exposure, I think we have failed. So we have to walk the talk, take a decision, move forward. And what we have sought to do is ensure that we don't give any ownership, we don't give any management rights. We get what is best for us, and we continue to have the benefit, the best practices, and all the IT systems. We get the best platforms that are available to an international firm, and we are paying for it. So therefore, if that kind of environment can be the first step, as Mr. Bhasin said, the joint venture, whatever be the form, that is something which will really be the first step, first part of the graded allowance of the foreign firms, and no foreign lawyer is actually interested in coming here. No foreign national. If we can give them an alternative of a domestic capability, I see no reason why they should do it. I think Bitika has probably worked in the sector for a long time, and it'll be happy to hear from her as to what she perceives as the vision of those people who want to have a say. Nobody wants to come in and have ownership and management rights in Indian firms. We should give them an opportunity where they say that we are going to run it. You stay away as foreign nationals, but we will do it in the manner in which we think this country should be run in legal practice.
I think, Atul, thank you very much for sharing the perspective. I think what is important, it is actually in light of what you just said. Right now, our exports are $250 billion, and we want to get to $1 trillion by 2030. And large part, hopefully, large part of it will be supported by professionals and legal field. Because really what is important is what rightly you said, when Indian businesses are doing business outside, should we have an ability to collaborate and partnership and do that? That's one part, and therefore you'll require dual qualified lawyer, which as Mr. Bhasin said, as you said, is not there. And the second thing is that when you are investing, when you are doing India, when your foreign companies and foreign clients and foreign corporations are buying into India, then can we do, in a way, it is like an export substitution. So somebody who would have probably taken a Wall Street firm to come to India, can Indian law firm do that? And I think we like what your model is. I think you get the upside of technology, platform and everything, and there's no downside about Indian citizenship. So that's, I think many congratulations to you.
Mohit, I don't say that a foreign firm has come here. We say we are global.
Yes.
We have today 160 offices across 80 countries. That's a statement, and I can say that with a lot of pride today, because we have not ceded control.
Well,
not allowed a foreign lawyer to come in and
Bitika,
practice.
you want to add the last line?
Yeah, so it's really true. When I speak to international law firms, they are not wanting to come if there are a lot of gray areas and laws are not kind of decided. They're very happy. They said we will not come until everything is sorted out, especially when they have to invest in our company, starting infrastructure of offices, putting in it. But definitely if the network of their businesses, so basically this part of I would call Dentons as in India also part of that huge network where if any matter relating to India is there, it is passed on to one firm. Now, interestingly also, when I met a lot of Indian law firms, even now also, they all have already a best friends relationship. It's just that they are exchanging work and they are giving them the India part of the work by those foreign law firms. And you have kind of taken it to the next level because you have used their name. That's the only...
So we have now Attorney General, and we are just at the final stages of our panel discussion. Thank you, sir, for joining us. And I think with this, we come to an end of our session, and we welcome the respected Attorney General to the conference. And now we start the inaugural session. Thank you very much.
Yes, I would request the eminent speakers to kindly stay back for the group photograph and the felicitation. For felicitation, I would like to call upon stage Mr. Rakesh Sharma, Chairman, Legal Sector, SEPC. Meanwhile, SEPC takes privilege to extend warm welcome to the Honorable Attorney General of India, Dr. R. Venkataramani, who graces our conference as chief guest. We welcome you, sir. A huge round of applause for him, please.
I think our thanks to Mr. Mohit Saraf and all the worthy panelists for a exceedingly meaningful, fruitful, productive discussion on this important issue. So a big hand you see to the eminent people.
Thank you, panelists. You may kindly take your respective seats. Now, to begin with the inaugural session, I would like to call upon stage Mr. Rakesh Sharma, Chairman Legal Sector, SEPC, Mr. Karan Rathod, Chairman, SEPC, Manisha, Manisha.
ये नाम हटाना ये कौन है?
So, as we begin the inaugural session of the day, I would like to call upon stage Mr. Rakesh Sharma, Chairman Legal Sector, SEPC, Mr. Karan Rathod, Chairman, SEPC, Mr. Mohit Saraf, Founder and Managing Partner, Saraf and Partners, Mr. Atul Sharma, Executive Chairman, Dentons Link Legal, Dr. Lalit Bhasin, President, Society of Indian Law Firms, and Founder Chairman, SEPC, and our distinguished chief guest, Honorable Attorney General of India, Dr. R. Venkataraman. I would request DG SEPC, Dr. Abhay Sinha, to kindly escort our distinguished guests to the dais, please. We welcome you, sir, and we highly appreciate that you have taken time from your busy schedule, and despite being engaged in other programs, you have made your time to be present here with us. Let's welcome the dignitaries with a huge round of applause. Now, I would request Chairman SEPC, Mr. Karan Rathod, to kindly welcome esteemed delegates and guests. So please.
Good morning, Mr. R. Venkatramani, Attorney General of India, Chief Guest, sir. Dr. Lalit Bhasin, President, Society of Indian Law Firms, Founder, Chairman, SEPC. Mr. Mohit Saraf, Founding and Managing Partner, Saraf and Partners, and our knowledge partner. Mr. Atul Sharma, Executive Chairman, Denton Legal, Link Legal. Dr. Abhay Sinha, DG and his entire team. Mr. Rakesh Sharma, Chairman, Legal Sectors, and all the CGC members of the SEPC. Eminent speakers, officers from Ministry of Commerce and Industry, Ministry of Law, Justice, SILF, and IACC. Media and press, partners, and delegate participating. Ladies and gentlemen, it is my great pleasure to welcome you all to our initiative of stocking up this theme, the legal dimensions of global trade at the rate 2047, in line with the versions of Indian economy and export goals during the Amrit Kal. Being a catalyst and a platform and a nodal point of facilitating international trades, explore, create business opportunities, SCPC has a very significant role in providing inputs of policy formulation and regulatory framework conducive for enhancing exports from India, lower down the trade barriers across the globe. The conference, which would brainstorm on liberalization of Indian legal sectors, evolving global supply chain for legal services, role of FTAs in promoting bilateral and international trades, dispute resolution, negotiation, mediation, and arbitration. Artificial intelligence in legal practices is being organized at a juncture where India strives to take giant leap towards realization of becoming developed nation by 2047. The legal sector, a cornerstone of both manufacturing and services, holds immense economic importance. With over 1.4 million advocates nationwide, Indian boasts one of the legal professions globally. Recognizing this, SCPC champions the cause of Indian service providers, paving the way for their success on a global stage. With the theme cantered on future of global trade, the conference underscores the transformation potential of legal sectors in shaping Indian trajectory. We believe the conference will provide significant takeaways towards the same. We are having the privilege of having the blessings and presence of Attorney General Mr. R. Venkatrami, our chief guest. We would be enlightened by his vital inputs drawn from experience and his knowledge. The topics have been curated under the guidance of Dr. Lalit Bhashin sir and knowledge partner Saraf Partners. I must acknowledge the immense amount of support, guidance provided by Bhashin sir, our founder chairman. We are privileged to have his continued patronage. The International Legal Conference 2024 is a testament to Indians' commitment to fostering excellence and innovation in the legal domain. By bringing together thought leaders and practitioners, we aim to chart a course towards future where Bharat, India's legal prowess is globally recognized. Extending my warm welcome to every one of you, we look forward to a very engaging discussions throughout the day. Thank you.
Thank you, Chairman. In the sequence, I would like to call upon Mr. Rakesh Kumar Sharma, Chairman, Legal Sector, SCPC, to make the introductory remarks, please. Sir, please.
Very tough to speak when you have so many legal stalwarts sitting before you, whom you chased as your idol. Thank you very much to all the dignitaries on the stage and the friends on the off the stage. Let me say that we are on to the platform to talk about the Global Trade 2047. Global Trade 2047 reflects our aim to have 10% of the entire global trade we want to visualize in the years to come. From somewhere around 2.1%, leveraging to 10% is going to be a big task, especially where I see legal sector as a thread which runs through all the trade practices, all the import and exports happening cross-border. So legal sector plays a very vital role in it. At the same time, we have to see that how legal sector also contributes significantly to this volume of the global trade from our Indian side. And when I talk about Indian legal sector, I can visualize this beyond courts and within courts. I can see the factors which contribute to the entire legal fraternity. Legal sector encompasses not just the attorneys, but also all the trade partners which are directly, indirectly connected with our sector. I further develop a vision to this part that the legal sector is going to contribute a huge amount in this 2047 target. Now, where does that target comes from? Our abilities to sharpen up, to grab the work from the foreign international law firms, At the same time, hold on the work which usually goes out of India from the legal sector. So we have to visualize and see all these spheres. Of course, there are challenges. When I talk about the legal sector, I visualize three categories, three dimensions. These three dimensions shows the person who delivers the justice, the person who assists to get the justice, and the person who is looking for the justice. But at this moment, when we talk about the technology playing a wonderful role, technology and artificial intelligence is getting into our every sphere. Legal is not something untouched. When we talk about artificial intelligence or technology, I remember my first professor, Professor Upendra Bakshi, he was teaching us in Delhi University Campus Law Center, and it was 1986. When I asked that, sir, how do you guide me? What to do? I? He said, foresee the future. So Professor Upendra Bakshi laid down a lot of things for us. So he's still been the one who says whether the technology has to adopt the law or law has to adopt the technology. So we have to see that how these different combinations help our legal fraternity to really achieve a wonderful part, significant portion of the global trade 2047. Thank you very much, and I am really pleased to see that we'll have a lot of insights coming down from this conference, and all of us will be taking home a lot. Thank you.
Next in the sequence, I would like to call upon Mr. Atul Sharma, Executive Chairman, Denton's Link Legal, to kindly address the conference. So please.
Thank you. Thank you so much for having me here. It's a privilege and a pleasure to be a part of this inaugural session chaired by the attorney. When we talk of legal sector, one question, of course, Mr. Bhasin did mention in the earlier session on the liberalization. We must first settle the debate as to whether this is a business or this is a profession or these are services. So I think the compromise could be that we are providing legal services, and in that manner of speaking, we are service providers. So if we are service providers, we need to be organized. And we need to be organized in a manner which helps the cause of the nation. Fortunately for us, we are positioned in the time of history as a nation which is huge potential for the growth of the economy. And I think it's a given. We hear in, day out, that next decade is the decade of India. So far as this position is concerned, we owe a lot to the reforms that we introduced way back in 1990. In certain manners, those reforms were lopsided. We missed a significant piece of manufacturing expertise, which we have overcome with our excellence in the services sector. And that is substantially premised on the growth of IT, ITES, and BPO sector. So far as the legal profession is concerned, unfortunately, we have not had that level of reforms at different levels of the sector. We have barely had any amendments in the Advocates Act. We have barely had any regulatory changes which have necessitated the growth in other sectors. Now we have a living illustration of the telecom sector, the electricity sector, virtually every sector, every walk of life, we have had large number of reforms. But we have not created those reforms within the legal services sector. And for reasons I don't want to go into, because they could not necessarily be germane to the issue of why we have not had it. When we talk of legal sector, there are three major components. There are three major stakeholders, compartments or departments or whatever you want to call it. One is the justice delivery system. The second is the clients. And the third is we, the service providers, the law firms, lawyers, and paralegals, and the support system. And of course, a very significant part of this element is how the judicial system has kept pace. If we look at the reforms that we have done in the justice delivery system, and when we talk of justice delivery system, we essentially talk of the constitutional courts. Most of the reforms that we have done, and in fact, I'm minded, I wrote an article, I would take the liberty and permission of the chair to read through some passages of that article which I wrote as back as, I think, 2021. And if we notice, there is hardly any change which has happened since then, or maybe in the last 15 to 20 years, so far as the court system is concerned. We have had an excellent computerization regime. We have brought in technology. But there is an element which we have completely missed. And that is the governance system. Because what had happened was, and if I may read the one paragraph from that article, the entire debate centers around personalities and individuals and not the system. Well, quite a few steps have been taken to improve the justice delivery system, but most of these are outward facing, like computerization of records, electronic methods of dissemination of information to litigants. What is needed is a set of internal governance reforms. Governance is akin to management. Thus, any parallel from successfully managed organizations, including business houses, can be a good guide. The new successful businesses, organizations, and we know whom we are talking about, you're talking of the Infosys of the world, have taught us great lessons in management. A number of methods of institutionalization can be learned from these experiences. The justice dispensation system needs to be viewed through the eyes of young India. They desire a modern, efficient, and transparent justice system as consumers of justice delivery service. Each citizen of India as a stakeholder of this system is looking at the management of the Supreme Court and the High Courts, like any other shareholder of a company is looking at its management. If this fact is recognized and the Supreme Court lays down the ground rules for its own governance and of its subordinate courts, a large part of the perception issue can be addressed. Does this curtail the freedom of judges? On the contrary, if a transparent governance system is adopted, such freedom will be seen in the light of its true intent. Every bench of the Supreme Court is Supreme Court for every citizen of India. It makes no difference to him if it is passed by a bench of 2, 5, 7, or 9 judges. These are nuances of law. Lack of consistency between two different benches and the Supreme Court while answering the same question has been one of the factors that affect its credibility. One can cite numerous examples. I think things have, with respect to the Supreme Court, things have not gone for better, but I think in the light of what we have seen recently, sir, they reaffirm what my humble opinion here has been. A key part of the institutionalized governance system is unification of decision-making processes at different levels. Today's Supreme Court and High Courts are a conglomeration of learned judges. They need to be unified and under a common management system. Devolution of powers on judges who are younger or have longer tenures and a multi-layered decision-making process is the need of the day. Nothing prevents the Supreme Court from taking the advice of the best in the management business. This is my 2 pennies worth so far as the justice delivery system is concerned. The second aspect is clients. If you look at the ratio of or the weightage of the cases which are decided by the courts or in arbitration tribunals and as well as quasi-judicial tribunals, 60 to 70% of them are involving the government or public sector or a state agency or a regulator. One of the basic problems that we have had in really having the best support to the court system is the fee structure that has been adopted by public sector and the government. I can cite an example. I am an Indian lawyer, as good as any foreign lawyer. And because the matter I am handling is for a public sector corporation, there is no base for determining the fees that I am to be paid. And sir, you'll be surprised to know that for something which I have to bid through an L1 process, $100 per hour, the same client pays to a foreign lawyer $650 an hour. So that's the level of discrimination. And therefore, this needs to be addressed and made sure that the service providers get what they deserve in respect of those matters, and therefore, there has to be a need for ensuring that there is a base for all public sector and government engagements, and we need to have the best in the country to be representing public sector and the government. The last part which I would like to touch upon is the legal education. We believe that we have, by introducing the 5-year law course, done what we were expected to do. There's absolutely no iota of a continuous legal education process for lawyers. Once you have got through your exams, you've enrolled with the Bar Council, you've written that Bar Council open book exam, that's the end all and be all so far as your education is concerned. There is no change in the curriculum. We still teach law. We don't teach ethics. We don't teach bias. If we go to the National Judicial Academy, sir, you have been there, I have been there. And in fact, we were lucky to be on the same panel once. We don't need to teach law to judges. They know law, they're trained to interpret law. What we need to teach them is how to write a judgment, the structure of a judgment. We need to teach them bias. We need to teach them ethics. We need to teach them the inherent bias. And if you look at the curriculum that we have for all international law schools, that's a very significant part of the curriculum which we have missed out completely. So these were the 3 components which I want to talk about. There's a lot we can talk about, but because there's a huge amount of pendency in terms of the reforms that we need to bring into the system. But we have paucity of time, and I think I would have exceeded my 7 minutes, which I calculated as per the division between all the speakers. Thank you.
Next, I would request our knowledge partner, Mr. Mohit Saraf, founder and managing partner, Saraf and Partners, to kindly address the conference. Given the paucity of time, request you to kindly keep the time into consideration, please. Thank you.
Mr. R. Venkatramani, Mr. Lalit Bhasin, Rakesh Sharma, and Atul Sharma, and other members on the dais and off dais. I think the important part about this conference is that the topic of the conference, the legal dimension of global trade in 2047. And I think what is important is that Prime Minister has been talking about 2047 as a landmark year where we will move from a third world country or a developing country to a developed world. Today, if you look at our world trade, we only contribute 2% of the world trade and very small portion of the services. And therefore, I think this is going to be a big situation and big opportunity for all of us. I want to cover a few aspects which are important, and particularly because Mr. Venkatramani is here, and I don't want to miss, and I might exceed my time, but don't, because I think the government is looking at the agenda for next 100 days, and therefore I want to use this opportunity and talk a little bit. I would say if you look at legal profession, we are really being a very conservative profession which have not changed at all. I would say if you look at the changes, there have been hardly any change in last few years. I think what is dramatic, and I think I keep talking to my partners and a lot of my partners keep dismissing, is that the dramatic AI is very different. I think we are one of the first law firm in India to have a closed AI system. And virtually, this is going to be a game changer. And this is an important part which I think just Mr. Venkatramani, you should think about is the entire judicial system, which Atul talked about. I think there's a lot of opportunity there. And because a lot of law firms and a lot of lawyers, we are not really flying rockets. A lot of our work is usual. And I think if the systems are good, then it can make a world of a difference. What if you look at the technology, if you look at global, if in the earlier version, if you are a part of a large law firm which have invested a lot of money, then you were equal on technology. Now, this generative AI, what has changed is it has brought everybody to the same platform. Everybody has equal access. Maybe somebody can have access a few months earlier than that. That's it. And that's the greatest opportunity for a country like India, where we have a huge connectivity advantage and where generative AI can be a big game changer. The second important thing which I want to talk about is the globalization which we are facing today. In last 77 years of our independence, we have moved from almost a very, very small economy to a $3.65 trillion. And if you look at today, I think 2047, the Prime Minister talks about being a Viksit Bharat. But I would say I was looking at a report of Jeffries. They said by 2027, we should be a third largest economy. And by 2030-31, we should be at $10 trillion. So really, what we are talking about is a $3.65 trillion to moving to $10 trillion in a matter of 7-8 years. And I want to give you some numbers so that we understand the opportunities and what we can do together. So really what we're going to add is $6 trillion, $7 trillion actually, $6.5 trillion in next 10 years to our GDP. Now there are proven factor that today to add $1 of GDP in this country, sir, you need investment of 55 cents. So to add $7 trillion, we would require $3.5 trillion of investment in next 10 years. If we don't get that investment, we are not going to $10 trillion. And that's an important opportunity. And therefore, this is a game changer in my view. So each one of us in the room can have so much of matter. I don't think the dearth of matter will not be there in next 10 years. The dearth will be our capability to handle it. And that's the greatest opportunity. And therefore, we have to understand and embrace AI. And on the last bit, sir, I think I want to talk about is the judicial reform bit, which Atul also mentioned, and which is again a very core to my heart. So when the government came into power in 2014, we were bottom on ease of doing business and on enforcement of contract. On ease of doing business, we significantly improved. Now we are 63 out of 190 nations. But on enforcement of contract, we are in last 25. We are 163 out of 190 nation. So if you are that bad, so therefore this is something which clearly we should think about what the government needs to do, because the government is trying to draw an agenda. And I heard Prime Minister telling his bureaucrats that once I get elected, there is going to be a huge amount of work which will be done. And this is an area which we need to fix. And I think, in my view, there are few suggestions which I want to make, sir. Today, I think we all criticize court system in India because there is a lot of pendency. I think, in my view, the pendency is not because of a court system. The pendency is because of outdated laws. And I think I want to draw your attention, particularly to Section 73 of an outdated Indian Contract Act of 1863, which actually makes sure that if you are in breach of contract, you keep litigating and you do not perform, because it gives an advantage, because the damages which is paid is so poor in this modern era that you actually make more money. And I was at National Judicial Academy and I told judges that, you know, lawyers and clients make more money in this India by breaching contract than by following contract. And they said, no, I don't agree with you. And I gave them maths, and I'll give you a maths here also. And this is important for you too, sir, because I know that the government is going to be talking about next 100 days agenda. So if you have to pay somebody 100 crore rupees, you litigate frivolously. The World Bank says it takes 4.25 years to litigate the matter at the first level. So basically, if you are a corporate in India, you have a cost of borrowing is 12-13%. So if you pay, you get 4 years of lease. So you basically save 60 crore of interest. And the World Bank again says that litigation cost in India is 31 cents to a dollar. 31 cents. So basically, there are 60.5 cents. So basically, you've not paid 100 crores, you've saved interest for 60 crores, you have paid legal fee of 16 crore because that it will get divided into two. So really, you make a lot of money by litigating frivolously. And therefore, what is important, sir, is to make sure that you don't get so many cases to the court. And therefore, what you require is amendment to the damages, Section 73. Then you require something so that interest cost, if people delay in payment, they pay their interest cost. If they are borrowing from the bank, if the borrowing cost is 12%, they should pay 12% plus prime interest rate. If their borrowing cost is 18%, they should pay 18%. And the third is cost, that the court should award cost, because that will take frivolous case away. When we work for corporates in India, they don't want to do a frivolous litigation in the US, but in India, they will encourage us to do it. So that's one part of it, sir. The second important thing is to make sure India become an arbitration hub. And for that, you need to make sure that the institutions are strong. Institutions are strong on lawyers, institutions are strong on arbitrators, and institutions are strong on the litigants. So that 18 months means 18 months, 12 months means 12 months. And the third system, sir, I would request is, the court system Atulya mentioned, is if you look at Malaysia, Malaysia used to be as bad court system like India. But what they changed is, they got a chief operating officer for courts. And the chief operating officer sits under the chief justice, because he's a technology man. And I think something like that can change the whole pendency, can bring a lot of transparency, and bring a lot of accountability. So this is, sir, my bit for you for 100 days for Indian government. Thank you, sir.
Thank you, sir, for elaborating on what initiatives should government be taking in the next 100 days. Now, I would like to call Dr. Lalit Bhasin, President, Society of Indian Law Firms, and Founder Chairman, SEPC, to deliver the keynote address. Sir, please.
Mr. Venkat Ramani, the Attorney General of India, Mr. Karan Rathore, Chairman, Services Export Promotion Council, Mr. Rakesh Sharma, Member, represents the legal sector in the Services Export Promotion Council. Dr. Abhay Sinha and his entire team and worthy colleagues on the dais and friends. What ails, you see, the Indian system of administration of justice? Three factors, some of them have been referred to. First and foremost, it is the notorious laws delays. Laws delays, admitted position is 5 crore cases pending all over the country. Cases are mounting this for the reason that, as Honorable Chief Justice of India said very recently, I was sharing the dais with him in Pune in the Symbiosis Law School, that we have facilitated now filing of cases by use of technology, affidavits, evidence, and all those things can be done. It has reduced the cost also. So I was to speak after him and I asked him, Your Lordship is correct that you have facilitated filing, but what about facilitating disposal of the matters? The more you create the ease of filing, there should be a simultaneous process of disposal of the matters also, but the disposal is not taking place. Now, why this is not taking place? It is essentially, as Mohit also rightly pointed out, the obsolete laws that we have. But it doesn't mean that, okay, you are removing laws, therefore you must create new laws. For these days, what I have seen that at the drop of the hat, we bring in new regulations, new laws, with the result that more regulators, more disputes, good for lawyers, but bad for the country, bad for the economy. Therefore, there has to be rationalization of laws, and that rationalization process should involve removal of all, you see, deleting from the statute books all the laws which are obsolete and all that, whether it is 1800 something law of Evidence Act, Contract Act, CPC, CRPC, IPC, and so many other laws are there which need to have a, but it doesn't mean that you should just substitute by bringing certain new codes which will be like old wine in some new bottle, as has been done also in the case of the labor codes. What has been done is that laws have been codified, existing laws, but what is the benefit out of that? Hardly anything. Therefore, there has to be what I describe as a rationalization of approach so far as the law is concerned, and that is where the legislative department of the Ministry of Law and Justice has to play a very important and significant role. The second element which ails the Indian judiciary is the change of the government's mindset. It is admitted position again that government is the largest litigant, this side or that side, and whether as an appellant you see or as a respondent, because every case the government loses, it becomes a question of ego, that yes, why we have lost, we will go in appeal and all that. I have been lawyer, you see, Atul knows about it, to various public sector undertakings. So when some cases used to come to me that this is a dispute, I said, why don't you try to settle it? So they told me, sir, if we settle it, tomorrow there will be a CBI inquiry. Why have you settled the matter? Well, that sort of an approach, you see, has to be given a go-by. That will, if the government takes a positive stand, I can tell you these notorious laws delays, this will come drastically down. Drastically it will come down. If the government, you see, takes this, that, okay, there was a move. A committee of secretaries was set up, you see, way back, I think, about 25, 30 years ago, to look into the disputes of inter-say public sector or public sector and private sector, but that also has been given. Yeah, also, yes. So that was also given a go-by. So this is what ails the system, that how do we bring justice to citizens of this country. Justice is mentioned, you see, in our preamble, that economic, social, and political justice we have to secure for our citizens. That is in the very first preamble. After that, justice does not find any mention in the Constitution, except, you see, when a few stray places. But law is there. Therefore, emphasis has to shift from law to justice. And that is what is being ignored, you see, by our respective governments, by our respective courts also. And Mohit again mentioned about enforcement of contracts, because we are talking of global trade. We are talking of globalization of services, of trade, of everything. But what is that taking place? Can it take place, you see, in the absence of there being a proper mechanism for enforcement of contracts? It takes years and years. I know that in a Bombay High Court, if you file a case for execution, I think it will be taken up after 7-8 years. Your turn will come. That is the situation. We talk of arbitration. Has it taken off in India? Despite repeated attempts, you see, from the by various amendments of law. And I am saying with some daring certainty, and also as the chairman of the Chartered Institute of Arbitrators, that arbitration has failed to take off in India, and the only way out is, and that requires very serious consideration, is the mediation, settlement of disputes, samjhauta. I know I attended one of Mohit's functions in his office and all that, where I did mention, he said Mr. Bhasin will definitely talk about settlement of disputes and all that. And that is what I did. And I keep on saying from public platform that mediation is the only answer. But that has also to come from the law schools. You have to teach the students, you see, that they should have a mindset to settle disputes, not to just go for litigation or create disputes. Therefore, negotiating skills have to be developed, you see, among our students in the law schools. And that would result in creating an atmosphere for settlement, samjhauta, which has been our culture, which has been our tradition, our panchayat system, way back, our Zilla Parishad. During Mughal times, the Adle Jahangir, that is justice of Jahangir. There was no mention of law. It was only justice, and that used to come because there was no adversarial system. Well, we have inherited it. It is a part of our constitutional framework, so we have to live with it. But while living with it, we have to promote, you see, settlements and create that sort of a mediation expertise in this country, that people should have faith very well. We will go not for arbitration also, because that is, arbitration is just now monopolized only, with due respect to Justice Amanullah here, Justice Khan here, that has been monopolized by our retired judges and all that. It has become very expensive, very prolonged. Therefore, only answer is to deal with this problem, to bring justice by reducing the notorious law delays, is mediation and settlement. And I give this message to all of you to consider it very seriously. Thank you.
Dear sir, thank you for shedding light on the roadmap of the legal system for the entire decade. Now would request our chief guest, Honorable Attorney General for India, Dr. R. Venkataramani, to please address the August gathering. Sir, please. Let's welcome him with a huge round of applause. Thank you.
Good morning, my dear sisters and brothers. A lot of questions have been thrown at my doorsteps, and very interesting questions. All of us breathe, talk, debate every day with all these questions. Before I go further, my learned friend Lalit Bhasin talked about the volume of laws we are enacting over a period of time. And at some point of time when India enacted the constitution, we were told, look here, you are having the longest constitution. But if I look at what United States is doing, you count that there are 30,000 statutes on the statute book of United States of America. Compared to that, we are a minuscule nation with far, far few legislations. And if you look at studies on the impact of laws which United States have made, virtually touching upon every aspect of their life transaction, the studies look at how they're taking over of human transactions which are essentially based on ethics, morality, and fairness, which we suppose are innate in the human brain, is replaced by a mechanical system called law. Because the law will have to be essentially, in one fundamental sense, mechanical, because you have to have a framework. You build in some rules and principles into that framework, and then we ask somebody else who's not enacted this law to read into it something or read out of it something. The law by itself is inert. In the whole endeavor of interpretation of laws by courts, wherever they are, look at any part of the world. So the endeavor of making sense of a law comes by what one may call a possible or an inconvenient marriage between those who made the laws and the intent and those who want to read the law, because there are multiple parties before the justice system who want the court to read the laws in more than one way. Therefore, somewhere in the process of our trying to capture every aspect of our life or bring within the scope of law, there is a problem. There will always be a problem. But that question does not end there. For when I was asked to come and speak, these very highly intelligent people gathered here who have a lot of experiences in law, business, and civil services. I asked Mr. Jain as to what do you think the attorney would be able to throw light, because I want to gather from your understanding and experiences as to what we can draw a roadmap. If the government is talking about a roadmap, I think all of us can also draw some roadmaps in different branches of our provision of services. I suppose life is all about providing services. I also suppose that the Indian way of life told us that our life is all about being in service, not only to oneself, but also to the community. We are not talking about Adam Smith's invisible hand, the candle maker, the butcher, and the baker, who don't do business because they do it for the community, but that's the invisible hand that Adam Smith talked about. So the invisible hand is a different way, a different perspective on what connectivities can happen between individual, society, and the community. But then today we are not living in an isolated pocket. The way the world has connected itself, unimagine it. 10 years ago, we wouldn't have imagined that we'll be able to connect ourselves in less than a drop of a second to the rest of the world, virtually in more than one sense and one way. So today, if we are at the crossroads of every part of the world poised for changes in several aspects, can we merely talk about trade, commerce, etc. in isolation? I suppose not. At the same time, as legal fraternity and those who are intimately connected with enhancing the quality of provision of services of law through a wide range of systems of administration of justice. I'll come in a short while about the relevance of looking at what one may call the deficit performance of courts, from the lawyer to the Supreme Court, tribunals, and so on and so forth. I'll currently try to look at that. So we can't talk about trade and commerce in isolation. We have the intersection of technology altering our lives so fundamentally that probably our very thought process, our perspectives on life, and our understanding of how do we interact with each other in every aspect of our life now is poised for changes. Certainly, like lawmaking in contemporary times, a little while ago, where technology did not make that huge impact, it is like an automobile plant. You can imagine an automobile plant where several parts of it are made and then they are assembled. The assemblage is a very important part of the automobile plant, like many manufacturing activities today, even a pharmaceutical industry. Look at the nice way everything gets packed. The medicines get packed in a beautiful way. So what somebody calls the gizmo, automobile gizmo metaphor, policy making used to be like that. So it was, as long as we did not get connected to GATT and WTO, our domestic policy making was on so-called the great strong industrial basis. We all recollect the Industries Development and Regulation Act of 1956 and the Essential Commodities Act of those days. So when we are talking about scarcity to be made and to be regulated by claims for equality and justice, etc., we were looking at world, law, trade, commerce differently. We're looking at human productivity differently. But we have changed so radically now, even the policy making. When you say policy making today, it's no longer the domain of the executive. The executive do not make policy making in what called the unconnected ways. Every thought, every motion, every understanding of the policymakers are definitely impacted by what flows from the community and what flows from them into the community. Therefore, the beautiful, like a ways, the spider, web system, thread, the beautiful connectivity now happen. Technology, policy, global impact, equality, then fundamentally, most fundamentally, I think all of us want to be part of, in our own individual life and a part of the community, in a way we could create something. We could innovate something. So creativity, innovation, and doing something emerging, something new and better, I think is the engine of life. If each one of us are told not to think creatively, innovatively, and to make something new, lovely, affectionate, so on and so forth, life will be just as bad as, right, inert as a piece of stone. So therefore, innovation, creativity, etc., are so important for our lives. And so it's important for the community and for growth. Since we have moved, maybe for good, from the clash of ideologies and a more and more open society demands and focus in almost all parts of the world, we are now beginning to look at all these connectivities in more than one radical way. In that context, I suppose, the slow-moving machineries of lawmaking, some of the very outmoded understanding and principles in various legislations, and the slow-moving machinery of administration of justice will have to be taken stock of. And we don't take stock of, I think, in isolation. Yesterday, I was in Calcutta High Court arguing a matter, an arbitration appeal before the judges. In the past couple of months, many arbitration cases have come up on my table, either for engagement or for offering opinions, or for some very critical look at what is happening in arbitration issues in India. So as I was arguing this matter, what came to my mind was, well, of course, presenting a point of view. Why is that we need to spend enormous amount of time in terms of intellectual and other resources in ensuring that parties who are locked in a battle need to see the end of the day? Could be two important things. As we always talk about inauguration, the inauguration of our engagement in a particular trade transaction, the nuptial ceremony in marriage. So the inauguration and the culmination. So all of us look at, when you draw a contract, we want to know when we will be able to conclude the contract, and if so, with the least amount of human, intellectual, and economic investments. Many of you who are students of economics will know that how, in the context of exploitation, the surplus theory of value has ruled human mind for a long time, and the whole labor code went on that basis. So how economic productivity and the value generation, element in economic transactions, so also, I suppose, in the domain of administration of justice. If one can evolve a formula where one says least investment plus quality adjustment would equal to the most optimal results. If only we can have a formula applied to our lawmaking and our court system, well, we would have said, yes, beautiful. But the question is how easy it is to translate it into practice. I don't think we should be talking about, oh, there are so many problems, how do we handle them? If one wants to make a change, all that one needs to do is think about changes. If one wants to think about changes, all that probably want to think about, forget about the past. Only pick up those elements which will have those perennial values for all times to come, and drop the rest as dead wood. So in the lawmaking process, we have still not Parliament all over the world. I was absorbed in reading a book during about 25, 30 years of English government, Thatcher, Labour Party, Conservative Party. The title of the book was very interesting, Blunders of a Government. It talks about how governments can make blunders and for what reasons. Very short-sighted political, ends and things like that. If you go to other parts of the world, like the newly liberated East European countries, who are moving from a very, very nascent democratic stage to a more mature democratic process, you find how they are struggling to find sense in the best way of making legislations and the best use of systems of administration of justice. And if you look at some more examples from South America or some of the Asian countries, so we have those best a wide range of examples and illustrations we can gather to find out how the world, in a very fundamental sense, is moving away from old habits of thinking. But at the same time, we are not one human civilization. We are still countries. We are still countries with our own political, economic obligation. We are still countries with our own isolated pursuit of hegemony. I'll say China for that matter. Look at what it has done on the Belt and Road initiatives. A huge, exercise undertaken in this, virtually trying to capture good part of Africa and some of the Asian nations, setting up an international university, setting up an international commercial court, and so on and so forth. So we also know that many other countries in the world would probably like to do many things so covertly, not certainly openly, to bring down emerging economic giants like India. So at one level, all of us are wanting to do something huge. At the same level, several countries are ensuring that India does not really grow. These are the global, political dimensions. It's in that context. All these issues come very, very, very importantly. Briefly, before I also try to bring my thoughts on what probably can be done. We talked about lawyers' role in the service sector. There's a very interesting study, and which is now in the form of a published book by Cambridge. It's called A History of Law and Lawyers in the GATT and WTO. It looks at the changing scenario of laws, services, and services by lawyers over a period of time, and under the catchword of rule of law. But suppose sometimes rule of law can become a flag which hides many other invisible aspects of what one may like to do. Therefore, these studies like this tell us that while we can at one level talk about convergence or a confluence of legal services from across the world, opening up India's frontiers and Indian legal service to the rest of the world, or vice versa. I don't know whether the world is still ready. The Europe and the rest of the world is ready to have an equal regard marriage of provision of services from other parts of the world. We have a very huge challenge there. Let us not forget that. But while we are talking about how India should grow, probably we can have a look at them, keep them in our mind, but endeavor in a very, very different, radical way to probably challenge those encounters and to probably dilute the efficacy or the impact of those encounters. And what can India do? So if you can probably list out in the list of what we can do, what lawyers can do, what governments can do, and what courts can do. As I saw in the past 1.5 years of my position as Attorney General, I find the list is burgeoning. It's quite heavy. And the more you look at it, it looks, oh, can you do anything? But I suppose we are in a position. Our intelligence quotient is not less than any other quotient in the rest of the world. All that probably require a more and more combination and congregation and the what called meeting of minds as often as possible. Because many of our conferences end with, I wouldn't like to be part of a mere inaugural ceremony. When we are here in the inaugural ceremony, I think more like eating into your time on discussion. My apologies for that. But I think more and more of continuing engagements on a frequent basis. Well, let's say I take stock of my monthly experience, like stock taking. And I take a monthly stock of my experience, and then we meet again together. Now we can meet together virtually, morning, evening, at any time of the day. So we take stock of our experience monthly and find out, like what happens on the Dalal Street. So I look at it and say, okay, well, this stock is like this. What do I do with that? I think we should evolve a system of getting together as frequently as possible. That's a process I'm thinking about. But if you take stock of something very basic, fundamental, which can be done without any difficulty, since section 73 was talked about, well, the whole of the contract law, which has stood the test of times, not only in India and England, and the basic principles of contract law, which say is based on good faith. The good faith element is the essential element of contract law. We enter into a contract while not committing a breach of a contract, while adhering to our obligations under the contract. Put all of them together, it means a good faith element. You will find it in almost all principles of contract law in any part of the world. But then that's not the question. Despite a good faith element, why are we still not able to have the contract law perform well? So therefore, these aspects of the Indian contracting, namely 73 or few other aspects, I think there is a possibility that we can amend it, and also bring in some fresh elements. All that I see coming from the need to invoke a more vibrant, multi-dimensional, I wouldn't call it an arbitration versus mediation or arbitration mediation versus conciliation, probably would be able to think about a confluence of these systems where, as I said, the least amount of investment plus the efficacious, performance, which equals to the best outcome. So if you talk about a confluence of all these systems together and then relook at a contract law, then we try to connect the justice administration systems. Probably that's how it has to happen. But our focus on debates on law and changes in law seem to be happening in compartmentalized ways or sectoral ways. We have a large amount of debate in arbitration law, the reforms in Arbitration Act, etc. I'm sure, just to give you some information, we've been talking about institutionalization of arbitration procedure in our country. So under the IAC regime, and talking with just Hemant Gupta, who is the chairman of this, in the past couple of months, a few ideas have been discussed and debated. Two announcements I want to make: that probably by middle of May, we will have an inauguration of the Arbitration Bar of India. And by that time, the Permanent Court of Arbitration seat in India would also have been run through. So I want to make these two announcements. And the reason is that if India can take pride in saying, look here, we are taking major steps in the institutionalization of the arbitration process in India, then we would have scored a century in the literal sense. But there are many more things to happen. I was reminded about racialization of laws, then the huge pendency of litigations in our courts. In one of those occasions when I was in the Law Commission, we were asked to look at the optimal number of judges we need to have in every courts in order to meet the burgeoning litigation. We looked at experiences all over the world. The people percentage population versus judge number is always talked about in many situations. People are trying to give solutions on that basis. But in the Law Commission, we thought that perhaps that's only one way of looking at it. But there's a cultural factor. Every country has a cultural factor to its litigation approach. Then there are certain basic legislations and legal instruments which contribute one way or the other to burgeoning litigation. So we thought we should look at all those factors. Keeping that experience in mind, I've been able to push the government into thinking on a litigation management policy, and after about 7 to 8 months of internal discussions between different ministries and departments, so we have reached a stage of having a skeletal central government litigation management policy, and which probably in a few months' time can see the light of the day. And I'm sure with that experimentation, Many policies require a lot of experimentation. We talk hugely about their wisdom, but when they actually get onto the field, right, we encounter many issues. So I suppose with this skeletal litigation management policy, we'd be able to open up new chapters on handling the stagnations in litigation and avoiding wasteful litigation, and also, if possible, enhancing the quality of litigation themselves. I suppose, as a lawyer, when I want to go to a court or represent a client, I'm talking about the comfort which I want to give to my client, the comfort in the court system. So look at the way our criminal courts are the most discomforting situation or places to go. So the comfort element, the ease element, talking about ease of business, I suppose ease of being in law. I think that's going to be the mantra for us. Ease of being in law and ease of being a legal professional. If you look at that, I think ethics will be taken care of. And they're reinforcing elements. So I find there are very interesting, challenging aspects. Many of us would definitely have a good deal of insights and suggestions and propositions which can be collected. And as there are quite a lot of thoughts which have been thrown, as I said, at my place. But as I said, if you have moved away from a closed system, like I said, the 1956 Act was a closed system. The heavy industry impact, Jawaharlal Nehru talked about the huge dams, etc. So we moved away from it where the policy making itself is now people-centric, people involved, and so on and so forth. So why should services provision should hang out in isolation? Today, I think it's still hanging out somewhere without getting really connected to the rest of the policy making. If all of us can think together and think that our lawmaking process should also undergo radical changes institutionally, we borrowed a British system. For a long time went on talking about Westminster versus USA, and I think it's all dead wood. We need to move towards a more fundamental, effective, radical, institutional elements in the parliamentary system. Namely, how do really people not only elect their representatives, but representatives become really representatives in the real sense. So the connection between people, representatives, policy making, inputs, insights, all that, it's like a loop which must happen. How do we really make it happen? And that's a big challenge, I think, an invitation for each and every one of us. If you can only spend more and more time on this, I'm sure every one of you would be able to give wonderful insights and suggestions. I believe that's the genius of us in the legal profession, and I'm sure that while we will continue to talk about the ills of the past, we will only talk about it only for the purpose of stock taking, not because we need to be dragged by the past. I want you to think about the future. Everything, I think, unfolds like a good, blossoming flower in the morning. Why can't we do that? We should do that. So congregations like this, meetings like this, conferences like this, I think will serve that kind of a purpose. And I would certainly like to share with you the kind of agendas and the kind of items which I have drawn up for my own personal, further navigation in the rest of my another year and a half, perhaps, of my position as Attorney General, and I hope that all of us, whether somebody is in position or not, it hardly matters. What matters is what we need to think together. So I thank Basin and Dr. Vaisina to call me today. And if I have taken more of your time, my apologies. But I thought we must share as much of sharing and more, I suppose, with passion, commitment, and future-looking, visions. I just want to conclude on another note. In the 1940s, to 1960s, 70s. All of us would have read about, H.G. Wells. H.G. Wells' Time Machine. So you do a time travel. So during that period, a lot of people writing on called the utopian visions. The utopian visions was a genre of literature. I think India can produce a new genre of utopian visions. And Services Promotion Council is doing well to make us do that. Thank you so much.
Possibly, I think most of you know that the Attorney General is the constitutional legal head of the legal profession of the country. The only position which is recognized in our constitution for a lawyer is that of the Attorney General. But the present Attorney General is not just a lawyer, he is not just an Attorney General, he is a great scholar, he is a great author, he is a great educationist, and above all, he is a great jurist. I think his address was very exhilarating. I think it was not his sharing his views with us, it was a learning experience for all of us. So I think a big hand you see to them.
Now, I would request our chairman to kindly felicitate our honorable chief guest. Thank you, sir. Thank you for coming here and gracing the occasion. Now, I would request Mr. Rakesh Kumar to kindly felicitate. Acha. To kindly extend the vote of thanks and concluding remarks, please. Thank you.
Thank you very much, sir. Lots been said, but what I could perceive and gather out of all this is that there are challenges, there are concerns. Let's have a look at them, but visualize the solutions. Go to every lawyer, ask for solutions, let everyone come with new thoughts. So whatever I could gather from this talk is that probably we have come a long way to go. But that's not something we'll keep on struggling with the challenges we have. That's what I said, we have to adopt the technology. Today we lead world in technology. So today we have to forge ahead with these solutions. So my take out of this talk is that all the three parts, be it the laws, be it the judges and the lawyers, and be it the litigants or the clients, we have to move ahead finding better solutions, keeping sight of the challenges or the problems we have. I'll conclude it here because I can understand we have the next sessions also being waited. Thank you very much, and all our regards and thanks to the Attorney General for finding some time and gracing the occasions and initiating the first candle, whereby we'll continue to lighten it up ahead. Thank you very much to all the dignitaries we have here. Thanks a lot. Thank you.
Thank you, sir. Now I would request all the dignitaries on the stage to kindly stay back for the group photograph, please. Given the paucity of time, we are quickly starting the next session in a while, please. To begin with session 2, I would like to call upon stage Ms. Ramya Suresh, partners Saraf and Partners, Ms. Raka Roy, partners Galadari, advocates and legal consultants, Dubai, Mr. Sachin Mishra, head legal and company secretary, Tata Consulting Engineers Limited, Mr. Dinesh Pardasani, partner, DSK Legal India, Mr. Deepti Lavya Swain, founder and managing partner, DLS Law, Mr. Satvik Shekhar, legal consultant, Center for Trade and Investment Law. I would request all the eminent speakers to please come on the dais, please. And request the paucity of time, would request the moderator to kindly summarize the session in half an hour time. So sorry for the rush at the last moment.
I request everyone to take a cup of coffee or tea and please come back inside so that we don't lose time. Yeah, no, they will continue. We're just asking the people to come. We are continuing with the session. Anyone, please come inside, those who have gone out for tea and coffee. Yeah.
I hand over the dais to Ms. Ramya Suresh, partner Saraf and Partners, to begin with the session. She can introduce the speakers on the panel and we can begin the session. Thank you.
Thank you. Thanks, Soumya. Good afternoon, everyone, to the session 2. Please welcome you all. I hope we can have more people joining as we go along. It's truly an honor to be among such distinguished legal minds, each of whom bring a wealth of experience and expertise to our discussion today. We have with us here Ms. Raka Roy. She's a partner with Galadari Advocates and Legal Consultants in Dubai. With her extensive background in international law and cross-border transactions and intellectual property rights, Ms. Roy brings valuable insights into the global legal landscape, particularly from the perspective of the Middle East. We have with us also Mr. Dinesh Pardasani, partner at DSK Legal. As a seasoned practitioner in the Indian legal arena, Mr. Pardasani brings deep insights into the regulatory framework and business environment, offering perspectives on the challenges and opportunities of integrating Indian legal services into the global supply chain. We have with us Mr. Deepti Lavya Swain, founder and managing partner at DLS Law. With a focus on technology-driven legal solutions and innovation, Mr. Swain brings a forward-thinking approach to our discussion, shedding light on the transformative potential of technology in reshaping the global supply chain. We then have with us Mr. Satvik Shekhar, legal consultant at the Center for Trade and Investment Law. Mr. Shekhar's expertise in international trade law and policy provides a critical perspective on the regulatory frameworks governing cross-border transactions, offering insights into the legal dimension of global trade and investment. And last but certainly not the least, we have with us Mr. Sachin Mishra, Head Legal and Company Secretary at Tata Consulting Engineers Limited. As a seasoned in-house lawyer with deep insights on the corporate structure, hierarchy, functioning, and expectations, he'll help throw light on the transformation in the legal supply chain from a different non-law firm perspective, if I may say so. So coming to the topic that we have for our session, corporate legal services are undergoing a noticeable transformation. Over the past decade, there's been a notable shift towards digitization, automation, streamlining processes, compliances with regulatory requirements, risk management, and cost optimization through outsourcing certain legal functions. Besides the usual law firm service offerings, now there are ancillary services that complement traditional legal representation. These include services like legal research and analysis, outsourcing and legal research and analysis teams help with the firms in providing them corporates with in-depth insights and guidance on complex matters. There is also compliance management systems, which include compliance management consulting, training, and audits, which help corporates with softwares that can help manage their compliances on a periodic basis. There are also e-discovery tools for identifying, collecting, and processing electronic data. There are case management softwares. There are entities that provide litigation support services, which includes document review service, trial representation service, expert witness services, and so on. There are also IP management service providers, which include patent and trademark services, IP portfolio management services, and so on. Now, these services are versatile enough to be availed by or offered by traditional law firms. However, as for the service providers, their market is both inward-facing in terms of providing services to Indian law firms, as well as outward-facing in providing services to foreign law firms and corporates within India and abroad. Now, in that backdrop, I'd like to start the discussion for this session with a question to Dinesh as to what he thinks are the reasons that are propelling the growth of the legal services supply chain, cost efficiency, technical advancements, modernization, any other reasons that you see are propelling the growth.
Thank you, Ramya. Good afternoon, everyone. Good afternoon, sir. I think it is India's time, and for even LPOs, it's no different. The work started some 10 years back, but now we see more opportunities. There are 6 or 7 points which I feel are helpful for India to get that business. We are talking about today $7 billion, which is getting into 30 billion in next 3 to 4 years. So we can see the potential that we have. And I think the way things are working and considering the infrastructure that India has, I'm sure we are able to cross even 30 billion in next 5 years. I think skilled workforce is something that can never be competed with India. Like all other industries, even LPOs will grow. English is, of course, an advantage that India has, and that is the reason all those BPOs worked, and now even LPOs. And considering that more and more students are opting for law, there'll be enough strength of lawyers to handle this business. Another advantage that I see is time zone advantage, where we can deliver when the West is sleeping, which is very advantageous for them. In terms of IT, I think we have the best infrastructure, as even our Honorable Prime Minister has proved, digital payments, which no other country has adopted. So we have the IT infrastructure, which will help this in delivering that 30 billion business that we are talking about. Another advantage, I think, which Britishers have given us is the common law, which because of sitting in India, we understand how English law works, how Australian law works, Canada law works. So that gives us an edge over others. With IT behind us, English behind us, we are able to deliver even on the law knowledge. Data security measures, I think we are at best, which is what the prime requirement of all the law firms overseas and even India now. Confidentiality is important, and we with our robust measures can deliver that also. I think these are the main points which we think can, or are the reason because of which we are talking about 5 times growth in next 3 to 4 years. Thank you.
Thank you. Thanks, Dinesh. That was very helpful. Moving to Raqqa, just to get a sense of how things are in the Middle Eastern turf, what sort of transformation are you witnessing there, Raqqa, if you can help us with that?
Thank you. Thank you so much. First and foremost, it's a pleasure. Definitely, every time I come back and I address a room full of extremely intellectual and knowledgeable lawyers. For me, it's always the best takeaways. So having practiced in UAE, in the Middle East for the last 18 years, Ramya, I would actually take a little back step and say that, in terms of transformative, before even I speak anything about that, I would want to say that Middle East has a very different way in which it has been founded. And because of that, and because of the background that Middle Eastern or the Gulf countries have, the legal structure is quite different from how it is in the rest of the world. Obviously, the countries that were formed more recently, much more recently, as compared to any other Commonwealth countries that we are talking about. The laws as a part of that are obviously quite simpler, and of course the practicing regulations also. Now, having said that, when we talk about the kind of blend of legal supply chain that is there, it is more of a blend of lawyers from different background and jurisdiction which gathered up together. It was a melting pot, which always was the idea of UAE, because it was formed almost in the similar structure of Singapore. So having seen that, my experience always have been that a legal supply chain always is extremely varied, with a blend of UK qualified lawyers, UK nationals, Australians, Indian lawyers, and so on and so forth. So that way, that is basically how the background was set up. Now, when we talk about transformation, one of the very interesting things I really would want to share is the localization which is happening in these countries. Now they are at a stage where, a few decades have passed, and the country is looking at having their own nationals to be also in the forefront. So there is a huge level of Emiratization, Saudiization, which is happening, not just in the legal, but every sector, as per the policy of the government. So as a part of that, there's a huge level of local lawyers who are encouraged to be a part of the legal supply chain now. It's mandatory, in fact, that way. So that's one thing that we have seen as a transformation that has happened. The other, obviously, two things which I think, I know there are other sessions where legal tech and AI will be discussed, but honestly, I cannot but not touch upon this, because we are seeing so much of this in the UAE. Like 29 legal tech companies are already independently existingly running in the UAE, starting from way back 2015. There is a legal tech council, which the stats say that apparently 90% of the law firms have adopted legal tech as one of their, strongest way of taking over most of their mandates. So yes, in terms of this, definitely, at least from the Middle East perspective, I would have to say that these are things which have gone into the transformational stage. And in terms of, let's say, and if you would say that if there is an import or an export of, of supply chain, I would say that it's still more of an import zone where obviously this is not a jurisdiction of choice. Middle East is still a jurisdiction only when it is compulsorily commercial necessities which calls for it. So yes, it is definitely not a place where, if it is given a choice, an arbitration would be either be in London or maybe in Singapore. So that way, of course, it is more of import. A lot of, like I said, because of the background, a lot of lawyers who are imported to this jurisdiction are cohesively working. But yes, as a matter of transformation, these are the things like, yes,
Thank you, Raka. That was very insightful. In fact, that brings me to the question I had for Satvik with his regulatory and policy background. How have you seen the regulatory landscape evolve in India when it comes to legal services? And just to top up what Raka said, as far as the Indian market goes, do you see India as a net exporter of legal services or a net importer of legal services?
Thank you, Ramya. And I'll actually answer the second question as a nice transition from what Raga mentioned. I think it's a little difficult to talk about whether India at this point of time is a net exporter or importer of legal services per se, because right now here we are talking about the global supply chain in the legal services sector. But we have seen non-legal practitioners being part of the legal supply chain. Like we've seen the tax law firms hiring GST experts and the cost accountants, GST experts for that matter, IPR law firms hiring, say, trademark investigators who are not lawyers, or say, for example, certain outsourced activities of tabulation of all the patents which might be applied for and granted. Another example is in the trade remedies law firms. They have cost accountants to look at the costings of the client companies and all. So these are actually non-lawyers. Now, when we're looking at the export of legal services, to what extent have we regulation-wise, as well as from a business standpoint, been able to see whether the services by non-lawyers within the legal supply chain has been accounted for? And I mention this because in my as part of my work, I work with the government on daily basis, and one of these policies which the government had introduced was the SEIS scheme, which was the Services Export Incentive Scheme, where the services exporters from India could get some duty rebates and all. So interestingly, the services which are being exported from India to other countries, which I've seen personally, are actually not really tallying with what's there in the law. Like, so just like in goods, we have the harmonized system of classification whenever goods are traded. Here we are looking at global supply chain, so we cannot ignore the fact that we are talking about legal services being traded across the borders. So there's something called the United Nations Central Product Classification, the CPC codes. Now, right now, the CPC codes have evolved over the period of time, and right now they're following 2.1, the version 2.1, where the legal services are classified under Division 82 as legal advisory and representation services in criminal law, legal advisory and representation services in other fields of law, legal documentation and certification services, and other legal services under which arbitration and conciliation services are part of it. Now, this CPC 2.1 version came in 2015. But this is the international standard of classifying legal services. However, in India, unfortunately, we still follow the CPC provisional. Now, the fact that it's called provisional, it says enough that it was still in the early stages. And how early was it? It was actually adopted by the UN in New York in 1991. So while the world has already moved to CPC 2.1, which is the latest version in 2015, the Indian regulatory regime still relies on classification of services under CPC provisional. So a lot of services exporters, when they are actually filing for benefits under the SEI scheme, as I mentioned, when their invoices and their clients' representations mention certain services which they're providing, they might not be found in the CPC provisional. And then the service providers might not be able to avail the benefits of SEIs. So that's the regulatory, that's where we are regulatory regime-wise, and where we, I think, should be and want to be, because that's when we can actually have the right numbers on whether we are net importers or exporters of legal services, and keeping in mind that we're also talking about services provided by the non-lawyers within the legal supply chain. So that's my answer to you.
Thank you, Satvik. That really helps actually. I mean, it's easy to discuss things like net importer and exporter, but having those practical insights on how the law is functioning and whether those numbers are actually able to be calculated is something that will really, help the audience understand that it's not as easy as just calling India net exporter of service. There's a lot that needs to be done regulatorily speaking for accurately calculating the services that are being imported and exported from and to India. From there, coming to Deepti, given that we at this panel are majority law firms, I'll take the liberty of posing you a question to just understand what the dynamics are between law firms and LPOs or other entities that are providing legal services. Any thoughts on that?
Right. Thank you, Ramya. Good afternoon, everybody. Good afternoon, sir. I think a very, very interesting question. And, we all are perhaps mostly lawyers here in this hall. And I can tell you that I don't think lawyers in law firms or, in-house counsels versus LPOs, they are competitors. No, I don't think. I think, both beautifully aid each other. We will all be very surprised to also note that the numbers talk differently. We've all perhaps always seen lawyers play roles in courts, in advising, everywhere else. And LPO is, rather recent phenomenon. It perhaps has started in the last 10, 15, or maybe maximum 20 years. It all, maybe started in US, picked up by China, also rampant in Canada. But now we see that in India as well. And strangely, the Indian legal market is perhaps about a 1.2, 1.3, 1.35 billion dollar market. Whereas, and you'll be very surprised to know, the LPO market is perhaps about $7 to $8 billion. Now, quite a huge amount of contrast, which is why we will see that these days we see a lot of legal and legal tech startups coming up. This is perhaps the reason why people are now shifting to try and use AI and technology to do a lot of mundane jobs. We lawyers do a lot of work, and we spend a lot of work which perhaps can be done by technology, can be done by AI, can be done by LPOs. And there is many times a lot of reading. Let's say we're doing a large transaction. We just recently closed a very large transaction in the firm, and we had a lot of people working and on the due diligence, reading multiple documents and perhaps eyeing for the same clause, putting them into the same table in the due diligence report. A lot of these functionalities can actually perhaps be picked up by LPOs, by AI, etc. And perhaps a lawyer can actually come in at the next level, and be efficient, come and do all of that work. Legal tech startups have started to do all of that, Well, I think there is slowly a little bit of intermingling in these terms, LPOs and legal tech startups. The numbers I think are about, hazy. It perhaps is at about 600 to 650 or 700 legal tech startups, including LPOs. But I think, a lot of them are either defunct or are not in the foray. So, the number realistically is perhaps half of it, maybe around 300 to 350, but it is growing. I am an investor in a lot of companies, startups, etc. And I can tell you, I see a lot of pitch decks coming to me from new age LPOs, legal tech startups driven by AIs, etc. And the number is pretty increasing. And I can also tell you that it is not just that these companies are at their initial stages of life. They are not at seed or angel funding levels. They are, perhaps at pre-series or post-seed, or in fact, some are almost about to touch Series A funding stages. These are brilliant news. That is because of the fact that, we can all do different type of, complex legal work and use our minds in important work. And I can tell you that, whenever we do large transactions, I'm a corporate lawyer, and when we do large private equity M&A transactions, even a small issue like, a diligence finding, for example, like, title to equity shares of the company, if there is an issue there, even the founder or the managing partner gets worried. Now to do that due diligence and come up to that stage, I think we eat up a lot of time. All of this perhaps can be done by AI, by LPOs, so that we can do, more efficient work, perhaps be creative in our advice. I do that a lot of times. I don't try and give, regular legal advice to clients. I try to give, business advice to clients, because that is very important. Today's client is perhaps, a lot of well aware, thanks to Google or thanks to internet service providers. Most of us, perhaps are good lawyers, but even the client has done their basic amount of research and come up. In fact, I get, pleasantly surprised at a lot of intelligent legal points being raised by clients. Now, so if that is the position, I think we should definitely try and encompass, this new incoming of LPOs. We can all lawyers take, a different stand. LPOs can take different stands. Legal startups can take different stands. I don't think they are competitors. They aid each other. And as I said, the numbers are quite different, right? $1.35 billion versus, $7 or $7.5 billion. That's the market that is to be capped. And this is perhaps one of the reasons why, tech giants like Infosys or IBM, TCS also have, started providing LPO services. And this is not a recent phenomenon, by the way. This has been happening for a long period of time, and which is why we should actually embrace this change. We should all try to use, AI. I have been speaking at a lot of AI conferences, and people, keep asking me the question that will AI actually replace the lawyer? A lawyer? I think, the answer obviously is no. And as I, generally say, AI or technology can be a very good intern to a lawyer, but, cannot replace a lawyer. Thank you.
Thanks, Dipti. I think for all his wisdom, it was right when Mr. Bhasin said that they're all a co-opetition. It's never either a collaboration or a competition. So I think that was very aptly put, and that applies to what we just discussed as well. Coming to Dinesh, do you see that the supply chain transformation Has it impacted talent acquisition and retention at law firms? Is that really a concern you think we face?
Yeah, maybe if LPOs are willing to offer the same salary without the targets, I might consider. But I doubt. I think law firm is a different field, and in-house is also there. Now, if LPOs also come, there'll be more options for the students when they come out. So I won't see it as a competition. Maybe at the zero level, as the business grows and it goes to 30 billion, might be at A0 level, there would be more options, and therefore they will consider LPOs if the LPOs has gone to 30 billion. But I doubt that will disrupt law firm retention in any manner. So I think I agree with Deepti. I think it's more a healthy place for more options for students rather than like a competition to the law firm.
Well put, Dinesh. Thank you so much. Now, moving away from the law firm paradigm that we've been discussing, coming to Sachin with us at the panel, do you perceive any cultural or language barriers to providing effective legal service to corporates from diverse backgrounds?
Yeah. Thanks, Ramya and SEPC for this. I think I'm listening to Satvik, Raka, Dipti, and a lot of things has been spoken about supply chain, the numbers, and investors, LPO, technologies, AI, and etc. etc. Let me tell you, the culture plays one of the basic role in doing all those things. And when you transact in a multiple geography, like we have got offices in US, UK, and then going back to the Indonesia and Australia, when I interact with my colleagues from that part of the country, and the exchange of ideas or the exchange of deliberation happens on various legal matter, many things comes up. So in a corporate, we actually make a pool of HR. HR means I'm not talking about the HR department, I'm talking about the human resource in a legal fraternity when I say. And the way of working of Indian legal students, or I'm also a legal student, and the way of working of a legal student when I see in US and UK, there is a difference in the approach altogether. Similarly, language is one thing which is a very common denominator for both of us when we speak in English. But in the morning when I was listening to Mr. Sharaf and the other panelists on the side, I observed that yes, it's true. I found a Uzbekistan lawyer as a managing partner in a KSA. I find an Indian lawyer as a managing partner in Singapore. I find an Indian lawyer as a managing partner in US, but I don't find those countries' lawyers as a managing partner in India. So even if we share a common language amongst all of us, but that difference I can very well see amongst the way of working. Now, when I interact with my team across the geography, language is something which is not a barrier, because we all know India is proudly say that it's one of the best English speaking country in the globe, even better than nowadays in UK. But the cultural aspect, some of the softer aspects, I mean, whether it is a timing of the office, whether it is the holidays, whether it is rule of the land, how it is being interacted, all this small matter, I can see the difference of working between our companies or my legal team and legal team which is sitting in that particular part of the country. I can very well see that. The commitment is there in both the sides. I can see here in India, the young students are so committed, we see them sitting late night and doing their best in everything. But when I tell them, just go little outside the legal boundary, what you have just learned in the law school, that's where I see that the synergy is not coming out. That's where I see in the Indian staff, I can see the synergy is not coming out. Why it is not coming out? I think Dipti and all my panelists have spoken about the supply chain. And still, if I see the supply chain, we only talk about the GST lawyer, the IPR lawyer. We are still talking about lawyer. We don't talk about the investigator, who is a police officer who can be on the role of a law firm. We do not talk about an engineer who could be on a role of a law firm, who could just add to the many various other things. In the team comprising of, the lawyers in that side of the country, if I see, if I'm discussing them on some matter of the contractual dispute, and if it is a dispute on a road related project or the tunnel related project, by default, I see that the other side of the team has come up with a non-lawyer fraternity. It would be engineer, it could be doctor, it could be nuclear scientist also. Whereas in India, it is the practice expert will come, that particular domain practice expert, but not that person will come. So if you really see the culture has to also evolve in terms of not just lawyer from the India side, but other people who are actually the supply chain of the legal fraternity, whether it is the investigator, whether it is the engineer, whether it is the even a doctor from a pharma sector, if I say, they should be part of this thing. It is just a matter of billing. People say $7 billion, $8 billion. If the billing really happens from Indian law firm, considering these people also on the table, the number could easily go to 70 or 80 billion dollar. And corporate way of working, I can see, engineering consulting company, one of my client asked me that, look, I want one liaisoning support from one of the lawyer, they denied, would you help? And I was surprised to know that in our contract, yes, that was part of my scope. I said, but I'm an engineering company, how would I do this? He said, no, but it is sold. But that I don't see the lawyer denied and the engineering company is doing. So somewhere those things has to be taken with a pinch of salt. Yeah, that's it from my side.
Thank you, Sachin. While we're on the multi-jurisdictional topic, Raka, can you throw some light on any challenges that are surrounding transfer of sensitive client data across jurisdiction, especially with the evolving data protection laws?
Okay, yeah, thanks, Ramya. I mean, before I address that, I'm really itching to just add on a little bit on the cultural part. So well, highlighted by Sachin, because for me, to be very honest, it was something which I actually went through because, I qualified from India and then I have always worked out of it, and I had to unlearn a few things which it was, honed into my system culturally, and I had to learn it differently. And as Sachin pointed out, that this is definitely something which needs to be seen from a much more macro perspective. And if not, then somewhere something is missing out. So definitely that is something, because it is more of a mental aptitude which one has to develop rather than saying what is missing in the system. That's one. Now coming to the issue of data protection and if you may.
Basically transfer of client data where it's moving from one jurisdiction to the other in the process of
doing the
providing services.
Yes. Right. So in terms of this, Ramya, I would focus again on UAE because that's basically where I work. So there we are in a critical situation where the law is there. We have the personal data protection law in UAE now. We are still waiting for the implementing regulations. So we are at that stage where we are aware, and then there are some free zones. For example, the Dubai International Financial Center, DIFC, or the ADGM, which is the Abu Dhabi Financial Center, they already have an up and running data protection law implemented and there, but then only applicable to the free zones. Now, when we are to address this, we are now at a situation where we know that maybe in future there will be the regulations and we have to do it, but we are not under any burden given that the regulations are still not there. On a very practical side, I'll tell you what the industry is doing. When we get the client insights, the multinationals, or I would say the largest sized clients, the larger enterprises are definitely preparing for this. They are coming back to us, taking advices, doing their bit of compliances to make sure that they are just ready to take on the regulations. And likewise, when it comes to the transfer of client data, that is where each of these organizations, including ourselves, we are well equipped. Because if I kind of bring it down to exactly what you asked, that to the micro level of our firm, we have a data protection policy in place. Our letter of engagements already has a data protection clause included. There is a letter of consent which goes with every letter of engagement that we are sending. While we are still not absolutely under an obligation, we are already doing it. We do it mainly because we want to make sure that we are compliant, whether now or later, and we work on a very large level with European clients. We have our colleagues who are Europeans. So there is a GDPR aspect which has an extraterritorial implication. So we are trying to cover on that already. And yes, just to make sure that in future we are not stuck with any such issues.
Understood. I think from a regulatory perspective, situation is largely the same here as well, and I think all of us here in the industry are working at complying with it, at least learning how to in time for it to actually be implemented. Coming to, I'd address it to the whole panel. This is the last question to just keep the session brief. What do you expect the future holds for the industry? Satvik, perhaps from a regulatory perspective, Dinesh, Dipti and Sachin, anything else to add on how do you see this going?
Right. So I think, like I did touch about the future, I think the future lies with technology. Today we have generative AI. Tomorrow we may actually have something else. We will also have robotics. We may have a lot of different types of things. But I think it is very important for all of us, especially lawyers, to adopt technology. I think, if Supreme Court has adopted technology and we've actually moved to, virtual hearing, perhaps, every other lawyer must do that. Clients definitely have adopted technology. The future is about technology. I think efficiency will really increase with technology. We must not say no to technology. And I think it is the bottom line is that without technology, we cannot survive. It is actually about existential aspect right now more than developing or better equipping. So I think the future is about technology.
I'll just very briefly touch on the regulatory side of things, where things need to kind of evolve. And I think the first session of this event actually must have covered a little bit of it, but I really believe that the representation of law firms and LPOs separately, and that kind of goes well with what our co-panelists said, that there is a happy marriage between, and there could be a happy marriage between LPOs and law firms. So maybe a proper regulatory representation and more of a regulation from data protection standpoint, as we talked about, the legal tech consultation, which is something Raka mentioned that might be happening already in UAE. So that's something where we can learn from. So and arbitration, obviously. India is still not picked up on the arbitration side of things, as Mr. Bhasin has mentioned during the inauguration, that we've actually really failed to make India, as we've mentioned, hub for arbitration what comes to mind is the institutional arbitration. We have MCIA in Bombay, we've got ICADR in Hyderabad, and we've got a few other institutional arbitrations. I think that's where the regulatory regime needs to kind of up the ante. And lastly, I think I can move a little bit towards what the law firms and the legal education can come into the picture. We need a very strong clinical legal education in the law schools. Students who are graduating from law schools, they don't have real life experiences. They have not worked for real clients except the internships, and even in the internships, more often than not, they don't really get the exposure which they deserve. So I think the clinical legal education is a really important aspect, because it also helps in skill development and soft skilling on this. That's where we can probably think about creating global lawyers from who might be ready for law firms or LPOs, and with an interdisciplinary approach, because we talked about non-lawyers also being part of the legal supply chain. So that's where probably we can have one last push to achieve a long-term target of having a more robust legal services. My last point is that once we are able to have a regulatory convergence for law firms, LPOs, and practitioner lawyers in a more streamlined manner, the regulations and laws should allow the law firms and the LPOs to operate in a more of a hub and spoke model, where probably the law firms can be in a position to be the hub, and each of the spokes can extend to different verticals of the supply chain. If our regulators are happy to think on that lines, possibly we can actually meet the target of being probably reaching the $5 trillion economy, because legal services has huge potentials. We are already much better when it comes to what our LPOs are offering, and India, obviously, whether it's about common law experience, whether it's about English proficiency, whether it's about cost efficient services which we provide. I think the next step could be to actually have more of a conducive environment to create a business model in a hub and spoke model for law firms and for other legal practitioners. And once that happens, I think the entire sector could be more productive, so to say. It's not that it's not productive right now, but there's always room for improvement. So I think that's what I can say on the regulatory side of things.
Thanks, Atul.
Very briefly. So I think we need to pick up high-end work rather than low-end work. They should not be dumping low-end work, and for which technology is important. And Satvik rightly pointed out, I think the educational institution has to bring technology in it. We never were taught technology when we were doing law, but right now also, I believe even now, technology is not playing that active role for students who are doing law, which is very imperative. E-discovery market is becoming very big in the US, and someone is required to analyze, collect that data which is stored in electronically stored information, ESI, to analyze and place it before the jury or judiciary, where they're looking for someone to analyze and produce the output accurately. So I think that sort of results are only possible if technology is also taught in the schools. I think that's what my suggestion is. Thank you.
Thanks, Dinesh. Thank you to all the panelists.
Ramya, just 1 second.
Sure.
I would like that this discussion will continue, because in US I see that the bigger ALSP which came up, Elevate, that Elevate was a support to a couple of law firms in US. It had its offices across the globe. Now Elevate is becoming a law firm. It's been given a permission in one state to practice. So this question will remain open, that ALSPs are maybe over a time going to be something parallel to the law firms as we foresee in US. So I having started an LPO in 2008. So I have traveled this journey along, and I see that ALSP is no doubt always a support to the law firms for the reasons LPO can hire the medical professionals for the health laws, for the patent, for engineering, everything. Law firms are little step back in hiring those non-professionals, simply because they may not have that abundance of work in those areas. So I leave this question to all of you to let's see that how things will roll out in time to come, that our Indian ALSPs will also be there somewhere competing with the Arab firms. Thank you.
Sure, I'll take that, and I'd like for all of you all to pitch in wherever you can. I think the likelihood of that happening can certainly not be challenged or denied. There are a couple of things to perhaps think of. A, how long it'll take for it to happen. B, besides the entities that are actually running such organizations, it's also a function of the people who are at the back end of those entities, and whether it is growing at a pace fast enough which is encouraging and inviting for graduates to actually look at this as a career opportunity to, move away from the typical career aspirations of being a lawyer, working in a law firm or so on. That sort of a growth, that sort of a movement of talent, I think that is what is needed. So I think it's a function of time, but certainly not unimaginable. It could perhaps also happen in India.
I think for LPOs, what I know, like I would say 6-7 years back, it all started in a big, there was a lot of buzz on the LPO thing. And I think I met a lot of these small people who were doing from their houses, they wanted to start or run an LPO. And some large ones like Bodhi Global and all, they just kind of wrapped up. I think there was a huge issue on their technology side because they could not convince the foreign side that their data and their confidentiality will be taken care of. So technology was the big issue. In fact, countries like Malaysia and all picked it up very fast. India, even till today, LPO is now coming up again. But I think we need to invest more on technology, though the buzzword is technology and AI. But I think in India, we really need to work on that to get that kind of business also in India.
I think, Bidika, sorry.
Bolo.
No, I was just saying that the COVID bit has helped us in
Yes.
building up that infrastructure. So hopefully now the business would certainly grow.
Yeah. But I don't know whether the COVID type of structure that was built up for network, for whatever, will that apply to LPOs?
So see, I think
maybe the
it actually
technology
is
companies
happening.
have started maybe,
Things are actually developing. There is a lot of investment, that is coming in. I can tell you that, our typical investors and funds, I'm not naming some of these funds, but, these are investors in, say, deep tech, and they are investors now in, legal tech. So these
so maybe
investments
that's why
are
the buzz
coming
of
up.
LPOs have also like just
Yes,
going
that
up
that is why they are
suddenly,
sprucing up.
Because I remember a couple of
As
years
I
back
said,
it had gone
the legal market is perhaps much smaller than the LPO market.
Yes,
And
technology
I think
market
it's a
is way
different
bigger
type of
than the
business.
legal law firm market, correct?
It will come up eventually.
I think one last
just
point
about
which
a
I wanted
decade.
to mention was, I think when about a decade ago, when I was very new in the legal profession, a lot of young students used to say that the LPO experiences are not accounted for when you're applying in a law firm. Right, they're saying the law firms don't really consider my 1 or 2 years of experience working in an LPO because they don't consider as a practicing lawyers or associates.
in fact,
But I think hopefully the things will change. I've been in policy sphere way away from the law firm world to not be updated about it. So I think that's something if gets more streamlined, I think it will be better even for the younger lawyers to take LPOs as a
anyway, I
good.
think everybody is waiting for lunch.
Yes, we won't keep you from your
Given the
lunches any
paucity
longer.
of time, because this is quite an engaging session and the discussion would go on and on. But given the paucity of time, we would love to close the session. And I would like to thank all our panelists for delivering such a wonderful and engaging session. I would request our CGC chairman, legal sector, to kindly come and felicitate the speakers, please. And other people could please join us for the lunch at the foyer. Yes. So please join us for the group photograph, post which we'll do the felicitation. We'll have the next session at 2:30 sharp, so request everyone to kindly join us post lunch. Do join us post lunch for the remaining sessions, as we are having very interesting sessions to be delivered. Thank you.
good responsibility done.
Thank you so much. Thank you so much.
They all have to do so many things together. I know the results of the they actually had to cut the costs. So that's where we were born. Exactly. Yeah. So I think that helped. Yes. Yes. Of course, we'll definitely have a closer group session. Sure. Thank you. Yeah. And we actually tell them here only, sir. Right now we're booking for lunch. Okay. We resume at 2:30. Okay. Is it put and then we go for lunch? No, no, I'm free. Free? You don't know? I don't know. It is post-lunch session, no? Yes, sir. 3:30. The post-lunch session will start at 2:30. And you're in the FTA? No, you're in the dispute resolution. Nice to meet you. Nice to meet you, sir. Very well. Hi, Saurabh. Hey, hi, Saurabh. Sahil. Nice to meet you.
You had your lunch?
Man, no thanks. Like the worst timing possible.
I know. This is what I was telling him, that you won't find people around, you won't find everyone. It's up to you.
Cut down to half an hour.
बोलोगे क्या?
Everyone is aware of but we were there in a previous session. They virtually spoke about everything on air. Exactly.
Because everyone wants to talk about that.
Yeah.
I think we just have to shift one to that side.
Okay. Yeah, there's only one show. That's okay. Consider it. They can keep, I think, Nipun's paper there. बहुत ज़्यादा पास कर सकते हैं. This is me.
also disputes lawyer side. I'm a fortunately or unfortunately a corporate transaction lawyer. Always complicated. You get all the excitement. White collar, right? You do white collar. I do white collar. But actually, white collar work sounds more exciting than it is. It is all the tedium of in detail of typical criminal law without the ability to go to court and frequent. It is a lot of investigation hand holding, a lot of internal corporate investigations, which is exciting in its own way, but I'm sure maybe with its own stress. I was advising something very similar, very tangential to white collar, gaining stress. Both but I think with time you get used to it. Yeah, yeah. I'm sure for you you become thick-skinned about it, and then you start to distance yourself from the clients. Then you realize that I'm really trying to do something. More billing.
Then we fight for
Bail
bail.
for billing.
Bail for billing.
So you're a disputes partner.
I'm a dispute partner. Disputes and litigation. But in India, it's very difficult. The procedures are so difficult, and what happens is I'm representing a client in Bombay. This person has never traveled to India. Last traveled in 1970s. There's a sexual harassment complaint against him. And there's an FIR as well to top it up.
Fun times.
India can get.
10 minutes.
Okay.
Should we start and she'll join in the meantime?
Yeah, it's to you. Anyhow, we'll have to wait for 5 minutes more.
I think
There's no one here.
maybe a little longer than 5 minutes because no one's here.
Yeah, so we can't.
Lunch break was supposed to be 45 minutes. It started at 2 o'clock. 45 minutes.
Wait करना ही पड़ेगा.
Okay.
Come, we are waiting for you now.
No pressure.
we are filling seats. Yeah. There's no one.
You're calling people. No, that's a sorry state of post-lunch sessions.
What if we just tell them session ho gaya? Very good.
Very good, yeah. Please.
See, you will introduce all the panelists, right?
I'll do that. Yeah, only one lines because you want me to be a Shatabdi Express. You have written, please close. Before we start.
I want to sleep.
Sorry to be late.
Hi.
Hi, Saurabh. Nice to meet you. Hi, nice to meet you.
Two songs.
Nice to meet you.
He's coming. No, he's coming, Mr. Bhawan.
Not on your right. Couldn't be more perfect. I think you can start. He hasn't come in as yet.
I see.
Odd because yesterday in court he said that you.
I don't. Yeah, he was there. It was. तो हटा ही दो ना. I think name plate. If he's not coming.
Because he said, yeah, I'll show you the fund.
But glad it's now.
Yes, and
Then
not in the
15
middle,
minutes
no?
later. Yeah.
And asking about AI. I mean, it's just an example of AI being
Gone wrong.
Yeah, yeah.
I think by the
They
time
know-
will come, this is stand and say over. Thank you for attending the session.
Does someone call my class?
I think
The organizers
the
must have.
organizers are speaking.
Because he's talking about yesterday and said, I'll see you tomorrow. I said, oh, okay, then. And I said, yeah. And I said, no, I'll try and come for lunch. Just continues.
Just a heads up, the previous session was all about AI.
He was the first one to share all the questions with me.
Yeah.
The day I wrote to everyone, he was the first one to.
Thank you so much.
Yeah, but he was the first one to work, on my email.
Ajay.
Yeah,
Oh,
yeah.
right. Yeah. I'm very surprised. I'm actually very surprised.
I'm sure you know.
Yeah.
Evolving supply chain for legal service became all about AI.
No, they were saying AI is one of the burning topics. We should see how supply chain. There should be integration of AI in supply chain.
Integration of AI in digitalization of India's legal sector. In every session they keep up.
Yeah.
अच्छा ये भी मेरा पॉइंट गया ये भी मेरा पॉइंट गया every session में AI tech why you show exactly integrate AI into mediation arbitration negotiation.
As we're waiting for more people to join us for the session, meanwhile we can start, so not to delay it further. Really sorry for the delay and for the inconvenience and for the absence of audience as of now, but definitely we are going to have more audience. Yeah, yes. No, it's not that, but since we have cut down the tea and coffee session, so maybe people are more hungry by the time. So we are starting with session 3, which is very interesting and very relevant, which is on artificial intelligence in legal practice. For this session, we have Mr. Saurabh Bindal, partner, Fox Mandal and Associates, as a moderator. And as a esteemed panelist, we have Dr. Menika Guruswamy. I hope she needs no introduction. And Mr. Saurabh Rath, partner, Trilegal. Mr. Sahil Arora, partner, Saraf and Partners. Mr. Nipun K. Bhatia, CEO, Legal League Consulting. Mr. Saurabh, over to you. You can kindly introduce the panelist and begin the session, please. Thank you.
Thank you, Soumya. Yeah, first of all, I would like to thank SCPC for having us here. On behalf of my panel, I thank the SCPC to host this event here. I would like to first introduce Dr. Menika Guruswamy. She is an advocate with Supreme Court of India, and she is litigating throughout her career, and she has been, arguing good number of matters before the Honorable Supreme Court of India. Next, I introduce my namesake, which is Mr. Saurabh Rath. He is a partner, and he handles dispute resolution and white collar at the firm called Trilegal. Next to me is Sahil Arora. He is a transactional and advisory lawyer with Saraf and Partners. And last but not the least, I have my close friend Nipun K. Bhatia. He's the CEO of Legal League Consulting. So he is the one who manages all the law firms here. We are today speaking on a very interesting topic of intersection of AI with law or the legal practice. Why is it interesting? It is interesting because, today when we talk about AI, it may be seen as both as a boon and a bane. It can be seen as a panacea, it can be seen as a pandemic, but we are still at a stage where we are understanding what is AI and how well it can integrate with the profession. There have been constant debates about, integration of AI with the legal profession, and these debates, talk about maybe intersection of AI with the human rights perspective, intersection of AI with the privacy perspective, intersection of AI with the intellectual property perspective. I won't take much time speaking on this very topic because we have an eminent panel here, and these all learned speakers will be talking about it in detail. But I got a chance to read a very important article, and an article was shared with me by one of the panelists about how copyright integrates, what is the issue with copyright and AI. And the article, it's very, I would like the audience to read that article. It talks about how New York Times have sued Microsoft over an issue of copyright infringement. And this article was written by none other than Dr. Menaka Guruswamy. So I would start with you, ma'am. The first question to you is, when you talk about, these kind of debates where copyright law is challenging AI, what do you see is the limit? Are there some checks, for this rampant ingestion of information by AI?
So thanks for this. And the hardest job ever is to be on the panel that is immediately after lunch or that is during the elongated lunch break.
Certainly.
So really the people in the audience are heroes here because they've chosen us over lunch. So I don't know how many of you know how AI works, but AI works on ingesting or eating up or digesting as much information as is out there. So whether it's from newspapers, whether it's from any form of information that is out there, is crunched up. Think of AI as a machine absorbing that information and processing it. So it is premised on, for instance, eating information from that newspaper's report. Now newspapers, columnists, for instance, I'm a columnist at the Indian Express. The newspaper and me, we have copyright over my column. Supposing you have a bot that eats that information up. The New York Times was faced with this, where I don't know how many of you have used ChatGPT and how many of you have followed the debate on OpenAI. It's a very interesting debate because all of this is premised on all this information being absorbed. So the New York Times sued OpenAI and Microsoft, which has a substantial stake in OpenAI, and said that, look, you're violating our copyright. Our reporters, our columnists are writing, and you are ingesting this information and you will sell at profit. So this is a copyright infringement and we have to think about damages, even though the Times had not quantified damages. And so this is a first case of its kind. But there are authors and musicians, novelists and poets who are suing AI as we speak, saying that you're violating my copyright. So the question really becomes that if intellectual property, like normal, regular property rights, is premised on ownership. So I not only own my house, but I also own my book, I also own my column. If it is premised on individual ownership and artificial insemination is premised on a ingestion of publicly available information, whether it's owned publicly, owned individually, owned privately, then at some point you have a clash between these two values. One value of individual ownership of property and the other value, which is premised on ingesting individually owned property. So that's the first issue. Now, how have other AI companies sorted through this? They've entered into arrangements, right? So for instance, other European AI companies have entered into arrangements with the Associated Press, etc., to pay them some amount of money, some amount of royalty. So this is kind of a field that is now opening up. What is interesting about the field is not the monetary aspect, right? Because what is wealth is changing today. So the highest market valuation companies today in the world are tech companies. Only Saudi Aramco, which is an oil company, is the only exception to this norm. Of the top 10 companies are all related to tech or the provision of semiconductors for tech, right? So there's nothing else. So what is wealth has changed. But importantly, what is property is going to change. So what is fascinating about this time is what it means intellectually for us in terms of how we understand ownership, how we understand knowledge, and how we understand intelligence. Because if a bot can be intelligent, then can the bot also own what it's created?
Certainly, it is very, very nice to hear your views on this, Dr. Guruswamy. There has been, I understand there has been a debate in India as well, that whether an AI can have a copyright, because can an AI claim that it has that intelligence to make something? When you talk about intellectual property, you have always been, hearing about Lockean theory that labor is something which derives it. So it is the reward for the labor. But when it comes to AI, are we going to reward it or not is something which we have to definitely see in future. Thank you for your inputs on this, Dr. Guruswamy. I would next like to move to my namesake, Mr. Saurabh Rath. Saurabh Rath is, he deals with white collar crime. So, my question to him is, when you think about AI, can it bring about meaningful improvements when you look at investigations being conducted? How do you think that AI is going to get involved with these kind of things?
Thank you, Saurabh. That's a pertinent question. But before we get into that, I'd just like to elaborate in what context, what is the nature of the investigation that Saurabh just mentioned. As a part of the work that we do in white collar crime advisory, a big part of that is conducting internal investigation, which is really different from the way a law enforcement investigation happens. Right? In an internal investigation, a company would come to us saying, we are suspecting of a certain wrongdoing in the company, please investigate it, please tell us what are the facts that you find and tell us how to address it. So really, this is a practice which was popularized back in the US and through corporate governance norms has also become a standard play used by Indian companies to ensure that they're in compliance with all applicable laws. And we see technology being used in this process through and through, from collecting data from individuals, from their phones, from their laptops, to processing it, to presenting it to lawyers in a digestible form so that we can intelligently review the data, assess it, identify what are the red flags, what are the gaps, and think about ways to address it in order to ensure that the company is made compliant if it is not compliant, right? So the way now AI can be used to bring meaningful changes, and by meaningful, I like to think of the term meaningful when it comes to this kind of workflow as being a process which reduces the, if I can use the word, drudgery involved with it. Because honestly, a lot of legal work, it involves some junior, some associate sitting in some corner, and all of us have gone through that in our younger days, sitting somewhere in a corner, pouring through pages over pages, documents over documents, while having to maintain full concentration, full diligence. But of course, as a human being, you are prone to making errors despite your best efforts, right? So really, when I think about meaningful changes, I believe AI can be used in a way so that it can reduce the tedium involved in the process. It can help mainly in streamlining the process and better planning out the process. And as I was mentioning, technology has been used for this in the course of conducting internal investigations for a long time now. AI is but the next natural step, back when the computers sort of began to revolutionize every sector. The biggest tool that we had was the database, the collection of data that was sorted in an intelligent form that allowed anyone to go through it. Databases eventually became known through fancier and fancier terms. It became big data. From big data, it moved on to machine learning, which is where you were using these computerized tools to quickly investigate the data and draw out meaningful patterns from it. Now, machine learning has transformed into AI, and the way we all understand it is using some sort of generative technology to create something that we as human beings can easily understand. Now, has AI reached that point to help us with internal investigations? I don't think so, not today. Can it reach that point in the future? That is a debatable point, and maybe we'll come to discuss that in the course of the talk today. But definitely, in terms of planning a large investigation, for doing resource allocation, ensuring that appropriate number of people are allocated to each task, everything's happening on track, everything's happening smoothly, all of it can be automated to a large extent through AI, which will free up people involved in the process from doing the administrative tasks associated with it, so that they can focus their attention on doing what is actually needed, getting into the details, and making the entire process more efficient from both a time and cost perspective. So really, that's where AI can play a significant role.
Thank you, Saurabh, for your inputs. I understand definitely, as per your words, AI is going to be a boon in future, because it will make sure that, the task which used to take around 1 week can be completed in, maybe 5 minutes. So that is definitely going to be there. Moving ahead with this question, I would like to, ask this question to Sahil, who is a corporate partner. That Sahil, when you do corporate M&A deals, there's a question of doing it at a particular point of time. Do you think that AI is going to balance that for you? Do you think that AI is going to be the means to, make sure that speed and legal analysis or risk mitigation is taken care of?
Sure. So thanks, Saurabh, for that, and I'll take off from what Saurabh had mentioned. AI is going to be an absolute boon for all of us sitting here. We just need to identify it, use it appropriately, and continuously supervise. That's going to be absolutely key. How I see AI impacting me as an M&A and corporate lawyer is that it will bring about a lot of focus in what we as lawyers need to actually spend our time and energy. Gone are the days when we are going to be spending days on end doing diligences, document review, figuring out change in control clauses, can the contracts be assigned or not. Those are not things that clients give us a medal for. Oh, so great, you figured there's a change of control in a particular clause. What clients actually give us credit for is complex structuring, bringing our best in a negotiation, making relations not just with the client but also with the counterparty in a manner that we are able to deliver the M&A transaction in a time-bound and efficient manner. Those are things that now with AI we'll actually be able to focus on. And I can't stop to think about the time when, as a junior counsel, at the end of the week on a Friday or Saturday, everyone in the batch would get together and discuss, oh God, who's on the least due diligences, who's able to devolve their time in actually doing transaction documents, actually doing legal research, and spending less time doing diligences. Diligences are important, make no mistake. It sort of gives you the fillip, makes you understand what the context is, helps you realize, small things that are found in a diligence process actually has an impact on the transaction. But you don't need to do more than a point. So that will really help take the junior associates also to the next level. It will help retention of talent as well, because ultimately you are actually giving them good quality work. You're giving them tools at their disposal. They're able to use it, spend less time. Work-life balance, which is, much wanted in today's time, will also come in. So all of these things brought together will certainly impact the M&A and corporate landscape. With all these positives, I do want to mention that, look, we would need to supervise the applicability of AI. I'll give you one example. Over a very rushed weekend, the landmark judgment of Cox and Kings came out a few months back. It had an applicability to a corporate transaction that had gone into dispute, and I wanted to figure, is my client going to be liable under the new guidelines that have been laid down by the Supreme Court? And I asked the team that was working on it, listen, can you brief this up and can you tell me, are we impacted? Because we didn't have that much time. While I was waiting for the analysis to come through, I said, the firms adopted this co-pilot, heard so much about it, let me just look through it and figure a brief. The brief was magnificent. When I had the discussion, there was one point in the brief by co-pilot that nobody had sort of told me about. And I said that, listen, this forms the absolute fulcrum. This certainly helps us. Why has the team not highlighted this aspect? And as it turned out, the software that we were using hallucinated and created a particular legal analysis or a rationale to the end judgment when none of that existed, and that was confirmed when I actually read the 100-page order. So what we need to do is, we need to use AI. All other points, 99%, perfect, really helped. But for that 1%, we need to continue to supervise. We need to be on it. Like, Spider-Man's Uncle Ben said, with great power comes great responsibility. AI is that power which we need to use responsibly. It's new to law, right? So much like an associate who's just joined the field, you are supervising important tasks, we'll need to do the same thing.
Well, Sahil, thank you for, letting me know that I'm not going to lose my job.
No, absolutely.
Because I have to still supervise.
Not yet.
Nipun, coming to you on that very particular point because you manage everything. Can you share with us some where AI meets law firm management?
Oh yes, plenty. But considering the paucity of time, I'll limit to a few examples. And let's also get one thing clear. Let's differentiate between tech and AI. In simple words, Gmail is tech. But when I start writing my email and it gives me some predictive texts based on my past behavior is where AI comes in. It studies patterns, it studies behaviors. So if you really ask me, in artificial intelligence, where law firm management comes in, like Menika said, it ingests a lot of information. So now imagine if I need to create a wow experience for my clients, what am I going to do? With an AI tool, it studies the patterns of my client requirements. At what stages do I need to give a red flag to the client? At what stages do I need to send an update? At what stage do I need to analyze the past behavior, the requirement? If I need, and we are in a behavior-driven industry, the client experience is what matters. Whether I'm going to be retained further, ultimately, the law remains the same. It's the interpretation and it's the servicing that you give to the client is when client's going to come back to you. So if I utilize technology to create that wow experience for a client is when the client is going to come back to me. That is where AI steps in, Saurabh. When a prospective client goes to your website and an AI bot immediately responds saying, welcome to so-and-so law firm. Here, what can we do for you? It's all something that's been fed into the system. But imagine now the client's not struggling. The client's not saying, oh, am I going to get a call back? No, there is inbuilt system in the tool itself where you can leave a WhatsApp message. It's going to connect you to the concerned person. So now the reachability has improved manyfold. So I think two areas that come to my mind immediately, of course, there's a whole lot of things that AI can do with operations. But if you ask me two examples, I think one would be creating that wow experience with a client, and B will be its immense power to do business development or to study trends. Now, there are two aspects to it. Let's say if we have a lot of past data, which kind of leads got converted, which are the hot practice areas, which are the practice areas where I get maximum leads from. And if the AI tool is studying all of that internal updates, and now I also plug in the economic updates, which sectors are showing a lot of movement, which are the lacunas of law which we can tap into, which sectors are going to be more litigious in nature. When my internal reservoir of information gets clubbed with the immense data that AI holds, analyzes, and in real time generates trends, imagine the kind of power I would have to tap into new clients, to tap into new sectors, and it can perhaps create a whole full-fledged BD plan for me. So if you really ask me, the two areas is enhancement of client services. That's going to be really, a lot of firms are already using this. Earlier this year, Nishad Desai and Associates launched NIDA. They said they launched an AI tool called NIDA. And I'm going to take you guys back to 2016 where firms like Baker and Hostetler were already using ROS. In fact, Denton's used Next Law Labs, which is an innovation hub they use for conducting due diligences. The ROS part, which I'm talking about, is the first artificial intelligent research lawyer that saved tons and tons of times for lawyers to conduct basic researches. So if you really ask me where AI can step into managing law firms, in a nutshell, the outreach for the clients, the BD part, and saving the lawyers time to concentrate on the pure strategy work, which is going to actually be cost saving for the law firm, reduced rates for clients, and better profitability, and obviously competitive outreach. So yeah.
Well, definitely I understand, there's a difference between technology and AI, which you have very well pointed out, in making your discourse, in giving your discourse, that there's a difference between what technology is and what AI is. And we understand that when it comes to AI, it is about the data which is fed into that AI. Now that data can bring a lot of complexity. I understand from, again, I've read one of a very beautiful article which actually talks about how Europe has brought a law on AI, and that is written by Dr. Menaka Guruswamy again. So I want to ask her a question that what do you see is the future regulatory framework for AI in India? Is there some framework? Are we moving ahead towards a framework? Like we have seen recently a case, Anil Kapoor case, if you see, they talk about that this is all technology and this is how they are using it. In fact, because we are into elections, my father is here, he was coming with me, and he told me that, what is happening is that there is a deepfake video of Amir Khan, and that is running the show. He's supporting one of the parties, and Amir Khan has come in open, and he has said that I'm not supporting that party.
Yeah.
So is there a regulatory framework we are moving towards?
So firstly, I wanted to say hello to Saurabh's father. Hello, uncle. Nice to have you here. I also saw the Amir Khan fake video, and Amir Khan promptly, clarifies, no, I'm not supporting any party. You could just kind of feel the fear, No, look, I think there's a lot of demand within India from industry to at least consult with industry to come up with a draft legislation or a draft regulatory framework. Now, Europe's framework is the first of its kind. And it's the first of its kind because it's fairly comprehensive. America's moving towards an artificial intelligence sort of act, if you will. So they're broadly, again, different conceptions, right, sort of. So there's the Chinese way, which is the government controls all of it, and the person who programs the AI is responsible for the output. So assume the output is fake news. Then the programmer, along with the company, is responsible for that by a penal regime. So there are penal sanctions. This could result in a fine or imprisonment, right? So that's one regime. America's sort of broad approach is, it's entrepreneurial. There's an enormous amount of freedom. There will be some regulation, but that regulation will focus on things like fake news and hate speech and, but it's broadly intended to encourage and stimulate AI entrepreneurship. And so that's the second model. Now, Europe is interesting because Europe is actually thinking very deeply about how do you combat fake news and how do you combat a fake bot? How do you combat a fake Amir Khan, right? Or worse, right? Because call to hate, so on and so forth, has tangible consequences. So there is a conception of what is it that this AI is doing to alter consciousness. Now, I've actually never seen a regulation or a statutory provision or a penal provision that seeks to penalize the alteration of consciousness. So if Saurabh and I, absorb something from AI, and that alters Saurabh's consciousness and my consciousness, then the programmer and the company is responsible for this. Now, this is fascinating, right? Because this kind of takes you into almost mythological understandings of what is a crime, right? So a crime is not just what you physically do or a conspiracy that you enter into with others, but it also includes the alteration of our consciousness. And this is something that AI can do because we are governed by algorithms. So how I absorb information that is created by AI is also on the basis of how AI profiles my ideology, my views. So if my consciousness is altered by this, then this can result in penal consequences, assuming my altered consciousness ends up with me engaging in crime. So it's, it's multifaceted. You kind of feel that the foundations of criminal law will change. So it's not just about tech, about money, about valuation, but it's also about what is crime. Just like what is property, what is ownership, what is crime. Right? So, frankly, I've been a lawyer for about 27 years. Now, as a senior advocate today, we are invested in, an overburdened Supreme Court, in terms of the number of cases that come to it, the pendency, and how technology, not AI, technology, right, is enhancing the functioning of the court. You can get orders online. When I first started practicing law, you could not get orders online. Today, I can get orders online, not just of cases I argued yesterday, but cases I argued 10 years ago. So it is an extraordinary innovation. Today we're talking about transcription of arguments, big constitution bench arguments. AI is helping transcript those arguments. You can see it being typed up immediately in real time. But it's a real asset because the potential of AI in adjudicating simple issues, routine issues, procedural issues, parole, many European countries make parole decisions using AI. The Supreme Court of America uses Compass, right? And what Compass does is it helps profile the accused in front of you. So this is the way in which AI is assisting adjudication because, the facet of the law I'm most invested in is the institution of the court system, right? The judiciary, the bar, which is us, and that adjudicatory function. So how is it that you ease that burden? And I think that is where AI can really assist us in helping ease that burden by actually bringing in more efficiency to the system, by taking away a lot of routine tasks, administrative tasks that judges spend their time on, and most importantly, by bringing cohesion to a system which is actually defined by volumes. So it's a system that is defined by volume. The American Supreme Court hears 60 to 80 cases a year. The Indian Supreme Court will hear 60,000 to 80,000 cases a year. Right? So how do you assist that adjudicatory function?
Well, thank you, Dr. Goswami. As you may correct, me if I'm wrong, but I understand there was a case on Compass as well in US.
Yes.
And it was dismissed on the ground that you have to balance it. You have to
Yes.
see how AI can function for the betterment of humans.
Yeah.
So, we are working towards a phase where definitely there's going to be a regulation in future. But what concerns me is that whether, and Sahil has told me that I will not lose my job, but what concerns me is this, that if suppose I have to do an investigation for a white collar crime, what my friend Saurabh does, and if I as a lawyer do that, and if there's an AI which can also do the same exercise, would Saurabh choose an AI over me? Is the question to Saurabh.
Well, the short answer to that question is not today. The slightly longer answer to that question.
I still have 30 more years.
The slightly longer answer to that question is maybe not even in the next 5 to 6 years, at least until we can come up with what's known as a perfect AI system, which means no hallucinations, which means the ability to ask questions about areas that it has currently no knowledge about, so it can gain knowledge on those issues, which currently AI struggles with a lot, right? Because as Dr. Guruswamy correctly pointed out, the way AI works today is that it digests past information to give you an output to whatever it is that you require in terms of giving you a ready-made answer, right? Now, what is the work that we do generally as all lawyers looking into, say, researching a topic, moving a little broader beyond investigations, is we ask questions of ourselves, right, to ourselves, saying that this is the issue, right? I don't have this information with me. What do I need to do to get that information? And that's really where the research happens. It's a process of asking detailed, thoughtful, insightful questions to yourself and trying to find the answers. That is at the heart of everything that we do as lawyers, everything that we do as human beings, any endeavor, professional, personal, that we have, right? Let's apply it to the way an internal investigation workflow happens. There is a lot of sensitive information that's usually with the client, their company's sensitive documents, privileged information that comes to you, extremely confidential information, technical information, information which if leaked out can really make or break the company. And you as a lawyer are in a position of trust to review that information, applying your strictest professional judgment to the issue, right? Assess it for its merit, and also identify other areas where you need to look into further. A big part of this workflow is, of course, sitting with the executives and officers of a company and asking them questions about the wrongdoing that has happened, about their role in it, right? The skill set that you need goes beyond identifying the questions to ask them. The skill set that you need to develop
akin to, say, doing a cross-examination thoroughly, is the ability to read the person sitting across you during the interview and to ask them questions in the way that will make them comfortable and allow them to feel free enough to share the information that you need, right? So it's beyond simply processing information. So which is why I feel that not today, not in the next 5, 6, maybe even 10 years, is an AI going to be replacing what lawyers do in the course of an internal investigation? Can it happen one day? I mean, the answer to that is potentially a yes. But I believe that by that point of time, we would have come up with regulations recognizing that this is a risk, right? And maybe our AI tools will be used in the correct direction. And what I feel is the correct direction is, again, reducing tedium in our lives so that we are free to do the more deep thinking related tasks, the critical thinking tasks, the creative tasks, whereas AI takes care of the day-to-day administrative aspects of tasks like Dr. Guruswamy mentioned earlier as well. So to, echo Sahil, your job is definitely safe.
Yeah, thank you.
So is mine for a while. But yeah.
No, but when computers came in 1990s, and I was young, I'm still very young, just to tell you. So what happened was there was a debate that, computers are going to take away jobs. I think this is the same story with AI as well. As humans, we'll be above AI and we'll make sure that our jobs are there. But still, there's one question I would want to put to Nipun because he manages law firms. Nipun, he has talked about lawyers. What do you see, the role of AI when it comes to, intersecting with the roles of law firm business support and management consultants? Would there be, would AI be used, with legal consultants or management consultants, or would there be, there be a challenge to their jobs as well?
No, I think my job is also not being taken away, for sure, because I think I'd agree with Saurabh that when we have programmed the AI to take certain decisions and there's a lot of data that's been fed in, what it still lacks is the decisions or the advisory that we do based on our gut, our emotion, our instinct. A lot of it which is still very human, and that still a machine cannot combat because it is studying the past data or it's being programmed to do something. What if the situation is so unique that it has not happened in the past? What if it is something totally new? What if the machine cannot go back and learn from the data that it already holds? Whenever there is going to be something that's unique, that's new, we will need to fall back on the human instinct. We will need to, so similar is the role for people who are managing practices or managing law firms or any leader in a law firm. I think a lot of decisions are taken on the basis of the risk-taking ability. What appetite do we have for growth, expansion? I think yes, what I still feel is the powerful AI and HI combo. I say artificial intelligence and human intelligence combo. That is definitely a deadly combination because here we are combining all that data that resides, the reservoir of data that AI holds for us. It can do proofing for us. It can give us very precise, accurate results in very short span of time. So speed, accuracy, let that all be the USP of AI which we are leveraging. But to take that data and transform it into something that's meaningful, that's the suggestion, that's so many years of our experience. Let's say if I am using AI, if I'm using so many data, MIS reports, or dashboards, but what I make out of it to suggest to a client, to suggest to a law firm that this basis on what I study and basis on what my experience and gut says for you, basis on what my instinct says for you, and let's brainstorm, let's do information exchange to find what's the best way forward. That sort of powerful combo of AI and HI is what will work.
Well, thank you, Nipun. Definitely that powerful combo has to work, and it has to be data-driven for sure. But one more question which comes to my mind, and this is to Sahil, that you do a lot of M&A transactions. Now, we are all talking about, data being fed into a machine and its intelligence being used. how do you see, the client's concern regarding confidentiality when the data is being, fed to the machine?
Sure. So that's a key point, right? Because at the moment, the clients, I guess, haven't really understood, or it's not really dawned on them that now legal advice could potentially have an AI role in it. We make full disclosure at our end that, we've adopted this, and so do some of the other law firms, but I haven't in my discussions at least seen an acceptance or an understanding by the clients that this is real, but it's going to happen. So in that backdrop, there are a lot of ethical considerations that all of us as lawyers who are leveraging AI need to bear in mind. Simple things like making full disclosure to the client that their advice, to some extent, not the ultimate end analysis or way forward or potential structures, but some of the aspects that require a lot of time and number crunching could be done by AI. That's full disclosure. It's also important that law firms pick and choose which software they use, and generic stuff you can use in OpenAI, sure. That's acceptable. But other than that, for client work, whether confidential information, whether not, it has to be a closed AI system which only leverages the web, your own documents, and does not give your information away to third parties. But that's easier said than done, right? Because ultimately, as a lot of the law firms in the US realized, that when they were using OpenAI or some of the other AI softwares, their user engagement terms or their data engagement terms with the relevant software allowed the software, like a Microsoft Azure, to use the keywords that one was punching in for their further data analysis. So that's where, as law firms, as lawyers, we need to be very clear what amount of data is being fed into the system and what is ultimately being stored and further utilized by the software, because that could be problematic. In that backdrop, one thing that we are doing is ensuring that to the maximum extent possible, we are anonymizing data, anonymizing drafts, and only then uploading even on our closed AI software, because we're just getting there, right? It's not fully real. So we are just getting there, and we need to be very, very cautious going forward. I do want to take a minute to talk about regulation. And as Dr. Guruswamy mentioned, look, we as lawyers thrive on vacuum. For years on end, practitioners like us thrived on there not being a data protection law. There still isn't, but thrived on it. Hoped it never came. And even in the fintech space, everyone was happy that the RBI is taking its time, coming up with regulation, etc., etc. Because what they feared and what's going to happen with data protection becoming a reality is massive disruption, which people are not realizing. But the time for regulation, even though I may not want it as a lawyer, vacuum helps. But as an individual and as a consumer of data, as a consumer of information, the time for regulation is now, because it will be least disruptive if it comes now. If it comes anytime later, we'll be so far down the adoption scale that all of our processes are ultimately going to be impacted. There are benefits. When I look back, and I was reminded during lunch of Imran Khan giving this speech after the elections, and he was sitting in jail, and the AI allowed an almost real speech being delivered to the audience, and obviously condemning the election, so on and so forth. And I was thinking how much I would give for me to just feed in what I wanted to say and take a quick nap during the session. But then also, similar AI, you see deepfake as well. So there are good, there is bad. In a lot of the clerical and administrative work will be done in a beautiful manner with the use of AI, but even there, you do notice a lot of banks processing loans, credit card applications using AI having a gender bias, or globally having a racial bias. So there's good and bad. Before we go too far down the road, the regulation needs to come in and needs to accept realities.
Thank you, Sahil. I understand that, confidentiality is definitely going to be one of the issues when it comes to use of AI, but we can work around it, and we can make sure that, with closed loops and, maybe closed AI, we can, take care of confidentiality of the data. Now, I come to Dr. Guruswamy again, and because she's practicing in Supreme Court, what I would like to understand is that what is the Supreme Court's view when it comes to AI? How is it integrating AI with it?
Well, as you know, the Chief Justice is very tech-friendly, and he has adopted an enormous amount of, I should say, technological interventions, to help the court function more efficiently. As you know, the Supreme Court was one of the first courts in the country to adopt virtual courts during the pandemic. So we saw the utility and the value of technological interventions into the law. Right? I think when we're now arguing constitution bench cases, you can see an almost simultaneous transcription being done by AI, not by a human being. So there isn't a transcriber who's sort of inputting, it's AI that's picking up the speech and translating into text. The element of error, of course, is there, but it's still a huge step forward. So at this point, I think we're at a stage where we're using technology to absorb and organize information. And by that, I mean also adjudicatory consequences, orders, judgments, and that's a huge step up. So Delhi as a jurisdiction, if you go to a trial court, you will find trial court orders uploaded, which is actually not the norm across the country. So I started out practicing in the criminal courts of Delhi, in the CBI courts, white collar, like Saurabh here. And 20 years ago, you couldn't get orders. So the human mind, old practitioners were a reservoir of information. Yeah. Today, it's taken for granted that our colleagues will dig up relevant orders. So the legal system is foraying into justice delivery using tech and increasingly thinking about AI as a utility. So I think that's the first thing. But the second thing is, there are certain functions in the legal system which will not be outsourced to AI for a long time, like my job, right? So I argue cases. As a senior advocate, we argue cases. As long as the adjudicator is human, you will have a human counsel. When the adjudicator becomes AI, then it will be a different mode of dispute resolution, and it will be brief-centric, and it will be AI making decisions on the basis of the brief. So the nature of the system will change. We are largely, even culturally, we are an oral tradition. In history also, we are an oral tradition, unlike Western society, which is a documentary tradition. So advocacy also is an oral tradition. If you go to court, you'll see that most things are argued out. It's not a brief-centric dispute resolution system. So as long as you remain an oral system, at least in the process that is the courtroom, AI will play a minimal role. But yes, in a past life, and I've said this before, when I was a mergers and acquisitions lawyer in AI in New York City, my job then of due diligence is almost entirely been outsourced, almost a decade ago. So almost a decade ago, this function of due diligence has been outsourced to AI because it helps with costs. A first year, a second year, a third year associate at a white collar, a blue chip firm in America is still very expensive. Even 20 years ago, I would be billed out at hundreds of dollars an hour. Now the machine that comes in is a much cheaper acquisition for the firm, and on simple due diligence tasks is less liable to make a mistake. So these are two facets. We're still at a point in India where relatively, labor is cheaper. And I mean that across the board, right? In Germany, the big investment into AI is because of a lack of population and an unwillingness to tolerate mistakes. So cars will eventually all be automated in Western Europe because they don't want the accident cost and they don't have enough people to drive. We are not that society. So in this society, where you still want to guarantee jobs, because we care about livelihoods, The question is, how do you think about AI that will supplement human occupation and not substitute it? Because that is a very core commitment, an ethical commitment that we have to have.
Well, thank you, Dr. Guruswamy. I think it's a good point to close this session. I've been told by the organizers here that we have reached our station. We will, sir. It's just
Even I have a question.
I just want to close the session with what she has said, that we have to look at how we supplement the use of AI. And now I open the floor for questions.
Do any of you see a DNO insurance backing an AI director? And do you see a professional indemnity cover for an opinion given by an AI-based information?
I think it is going to be the future, sir. Because, you have insurance cover for everything these days. So there will definitely be a time where there will definitely be a cover for, AI-backed information which is given.
Will you have AI directors?
I don't think...
Two instances have failed in Hong Kong.
Yes, and I think the issue with that is the accuracy of AI as we know it today.
Yeah.
If ChatGPT is going to be the basis of a legal opinion, you are guaranteed mistakes.
Yeah.
Now, once you get to GPT 14, there probably won't be mistakes. So that's the first, I think that's the first aspect to it. The second aspect is, so I'm a director, I'm an independent director on companies. I am not just expected to make knowledge-based decisions. I am also expected to make strategic decisions and ethical decisions. The question is, at what point will AI be able to make ethical choices? So as directors, we play multifaceted roles. So that is part to it. And I think the real issue is how sophisticated will AI become?
I
think you can speak.
Yeah, I think just to supplement, right? The idea is that we are not there in terms of, as even law firms, we're just trying to figure the first step in terms of doing our legal basic research, document review. The ultimate analysis is just so far away that right now the only thought that comes to one's mind is a professional liability insurance would cover us. In future, once adoption increases, the insurance company will perhaps catch up, premiums increase,
That means for the next few years, it's only an aid.
Yeah. Absolutely, absolutely.
It's not a substitute.
And I think I couldn't, I'll also take up Dr. Guruswamy's point, and I couldn't agree more. As a society, we are just so driven to protect jobs. You see this brilliant thing of DigiYatra, right? There's a line, you can speed through. There are still two people manning the DigiYatra line to ensure that if someone has any difficulty, they can let them through. So AI directors, I don't see this happening at least for the next decade and a half, because
fundamental thing in human beings. They're born like that.
Totally
They
agree.
will never allow. Once upon a time, computers, everybody's going to lose that. In fact, their jobs have increased. It's a basic, inherent,
yes.
As a human being, it's in you. That's your nature.
Yeah.
You will always kind of make sure you are not this thing, but they're still ruling the planet.
No, absolutely. But just in terms of being leveled, right? I never say never. Didn't envisage AI being this powerful, right? But I couldn't agree more. Perhaps instead of an AI director, what could happen is mandatory compliance check by a technical tool in a company, which sort of immediately flags non-compliances. Yeah. Perhaps that could be one thing that we see in a couple of decades. But I totally agree. Given the society, AI directors ain't happening anytime in the near future.
And I have another question.
So if you agree that AI could be human, because right now we're even fighting for, getting that it could be an author, or it could be it could create something. We are still struggling with that. So
I think all this also human minds, thinking. They think beyond. When you think beyond, so you say, oh, maybe human beings will be replaced. This is all your human being doing it, right, to you. So I think you can also know when to stop human beings, I'm sure. I have a quick question.
Please.
Now, is there anything in the litigation, because when I attended a conference many years back in, I think Singapore or someplace, 7, 8 years back, they thought that they are coming up with some permutation combination methodology, so they could determine what will be the outcome of the litigation case. So do you think it is happening in India through AI, or is we are far off from there? Or we are just imagining all
Manika,
this?
I think we
excuse
have
me.
something else to determine
Can I
outcomes,
interrupt?
good senior counsel. So we don't need AI.
Can I interrupt before you
That would
answer
be
this?
me.
Yeah. Can I interrupt before you answer this? In fact, I am a litigation lawyer, senior partner with Saraf and Partners. In fact, 4 days back, in fact, I had a discussion with Sahil also. 4 days back, I was finalizing a response to a jurisdictional issue. And the issue was about the seat and the venue and which court would have the jurisdiction. Once the draft was finalized, I thought of using that co-pilot which we have. So I just basically asked the co-pilot whether actually we can improve on some legal issues this particular draft. And a very funny response came that I can't help you on legal issues. You better consult a legal professional in this regard. So I think just to answer your question, I think it would be very difficult because the law is evolving each day. There are different judgments which are coming, which is setting different law from the previous judgments, and it would be very difficult for AI to match that kind of a pace and the brainwave which with the judiciary right now is using. So I think this is something I think would be very difficult in near future. It may take a decade or more.
Capture as fast as you kind of change that.
Yeah, absolutely. Yeah, but once you have a brain or analytical ability, which is very typical of a lawyer or a judicial mind which you require, I think that is something which may take few more years to develop.
I think all the law firms should calculate the revenues they earn from due diligence and the mundane kind of work. They should know that and then see how they're going to replace the revenues with something else if they let go of all that.
Given the paucity of time, I think we should come to the conclusion of this very engaging and captivating session. And so sorry to disrupt in between and not allowing to speak in such an engaging session. I would really be grateful for the panelists for covering such a captivating and delivering such an interactive session on how to regulate AI. I would request everyone to kindly stand for the group photograph, please. And I would like to call upon stage our legal chairman, Mr. Rakesh Kumar Sharma, for the felicitation of the speakers. Please join. We can pull all the chairs back.
The topic seems so interesting. I held myself back to ask it.
Thank you so much. Thank you so much for coming and sparing time with us over the weekend. Thank you. Please wait, I'll get a photo clip with you. So very quickly, we'll begin session 4, that is role of FTAs in promoting bilateral and international trade. To begin with session 4, I would like to call upon stage Mr. Shravan Yamanur, partner Denton's Link Legal as a moderator of the session. And as an esteemed panelist for the session, we have Dr. James J. Nidumpara, Head and Professor, Center for International Trade and Investment Law, Mr. Pranav Kumar, Vice President, International Trade Policy and Compliance, Reliance Industries Limited, Dr. Ram Singh, Professor, Head, IIFT, and Mr. Ankush Sharma, Partner, Lakshmi Kumaran and Sridharan. We welcome you all on the dais, please. Shravan, over to you for the session. Shravan, over to you, please.
Yeah, thank you. Welcome everybody. It's an interesting session that we'll have, and we thank everyone who's sitting here after lunch. So session 4 is on the role of FTAs in promoting bilateral and international trade. I've of course shared a few questions already with my panelists. Free trade agreements are very important and growingly important, especially given the impasse that we have in the WTO. Multilateral organizations are unable to regulate trade any longer, at least in the foreseeable past, given the politics that we see in the United States and in some of the emerging economies. So there is an increasing focus on bilateral agreements and regional agreements regulating trade issues. And given that FTAs no longer only cover what we earlier knew as trade in goods and trade in services, they're going into issues of domestic regulations. They're also involving issues of investment. So ever increasingly, FTAs are impacting our lives in many ways. So this is an important session, and we have a wonderful panel with us. So I'll open the floor, and I'll start with Dr. Nidumpara. Dr. Nidumpara, what are your views on India's position on these issues regarding, especially given the topic of our conference, that is legal dimensions of global trade? India took a decision not to sign the RCEP, but if we see in the recent past, we have both an agreement with Australia, we have one with Mauritius. So there are these new agreements that are coming. And I'm sure, given that you were involved in these negotiations, where do you see India heading now, especially in the multilateral and regional space?
So thank you, Shravan. I think that is a very good question. So you correctly pointed out to what happened during the RCP trade negotiations. So that actually came in 2019. So we have traveled almost 5 years since then. The field of international, you can say the geometry of international trade has basically changed. The WTO system has not been able to deliver major changes in the last 25 years. So we have got a Doha round trade negotiation which started in November 2001. And under the Doha round, only 2 agreements were partially concluded. One is actually the trade facilitation agreement that was completed in 2014. And then we have got a recent agreement that was signed in 2022 on certain elements of the fisheries subsidies negotiations. But again, another important pillar of the fish negotiation is still not completed. So in that context, I think, and I should also mention that a lot changed since 2019. Until 2019, India has been fairly apprehensive. If you really look at the history of India's trade agreements, we signed a number of agreements as part of the Act East policy from 2005 until 2011. So we signed agreements with Singapore, with South Korea, with Japan, with Malaysia, and we also entered into the ASEAN agreement. But after that, the RCP negotiations consumed a lot of our time, and we also had a major problem in terms of dealing with the ASEAN countries. And it is absolutely not a question that the ASEAN countries are extremely competitive. And when the ASEAN actually includes China and 5 other countries, definitely there are some sensitive considerations for India as well. And then I think as a pragmatic step, India turned towards the West. And I would say that that is one area where we have got significant amount of complementarities. We have got traditional trade surplus with the Western countries, with the European Union, with the United States, with Canada, and many other countries. So our approach changed a little bit. And I should also say that now we are coming with a newer set of challenges. The new set of challenges is that when you negotiate an agreement with Western countries, the focus is not purely on market access. The focus is actually on a regional on harmonization of standards and practices, and also we had to deal with the sustainability development related issues. So if you look at any major agreement that the European Union has signed, there are a number of provisions on environment, labor, gender, anti-corruption, sustainable food system, and a number of areas. And traditionally these areas are quite difficult for India. So that is why I said, when we deal with the East Asian countries, the market access is actually the main fulcrum of what we get. But when we negotiate with the Western countries, of course market access will be a part of the negotiation, but the real challenge will be in terms of having regulatory harmonization. And in addition to that, I should also touch upon one area where you were involved while during your time at the DE, the investment treaties. We have the model 2015 model BITs. So India's traditional practice was to have a model bilateral investment treaty, but that actually changed to after the implementation of the model BIT. Now many countries are saying that the investment treaty should also be part of the trade agreement. Because I would also like to mention that now, if you really look at India's approach, the trade agreements are actually part of a bigger picture. And in the bigger picture, WTO has a role, the trade agreements have got a role, the G20 have, and many other multilateral engagements have a role. And one of the questions which you shared during in your mail, what can we actually do with the MSME? How to make sure that the MSME can really access the market in other countries? The challenge is that we can't do specifically in the context of an FTA, these kind of challenges. So what we need to do is to have a much more broad-based approach. And that is why, if you look at the G20 statement, New Delhi Declaration, we developed a regulatory toolkit for financial inclusion of MSMEs. So on the, I should actually say that the trade agreements, having said all, have a very limited impact. If you really want to have significant amount of economic development in the country, we have to actually build our infrastructure, physical and social, and we have to also make sure that our industries are actually competing with the best industries in the world. So unless we improve the competitiveness of our industry, unless we are able to do that, these free trade agreements may not be able to deliver. So there is a huge challenge in terms of enhancing their capacity to play a much more effective role in doing business. Thank you.
Yeah, thank you, Dr. Nirampara. You're absolutely right that along with the free trade agreements, we need to increase the competitiveness of our domestic industry, look at our domestic regulations, and I think, of course, ease of doing business is also part of that. You did mention that multilateral institutions continue to be important. We have an example that you gave, the G20. Now, when we have negotiations like the G20, you have bodies also like B20, which allows the businesses to also provide some input into the discussions that are happening in the G20. Mr. Kumar, you're part of the industry. When it comes to these free trade agreements, the transparency or the lack of it, in fact, in these negotiations, how do you perceive it and how far do you see industry being involved in these discussions? Are inputs sought, and what kind of inputs do you think should be fed into from the industry, especially when India negotiates with countries which are far likely to cause more imports than exports from our country?
Thank you, Shravan, and thank you, SEPC, for inviting me and for giving this opportunity to express my view, and more particularly from the Indian industry perspective. As far as FTAs are concerned, and you raised a very pertinent question in terms of the consultation mechanism between industry and the government, I would say that's still evolving towards a better kind of structured consultation which is happening now. So if you ask me, it's 20 years since we have witnessed the negotiation and the operationalization of free trade agreements. So For instance, if you keep aside the Sri Lanka agreement that was signed in 1999 and operationalized in 2000. So in 2003, we launched the negotiation with ASEAN, and after that, the Singapore happened in 2005. ASEAN concluded in 2009, followed by Japan, Korea, Malaysia, and all. So that was the first phase of FTA, what we call it FTA 1.0. That was India's experience with free trade agreement. Of course, during that phase, the consultation process was evolving. Industry also did not have much capacity. And India moved towards the east because there were a lot of political and strategic consideration also. At that time, of course, traditionally we have been exporting to West, that is USA and Europe, and using the GSP benefit. Still, USA happens to have topmost export destination. Europe is also important export destination. But for long, we have been trying to diversify our export basket, that is product diversification and market diversification. So in both that strategy, the look east policy and look east policy for FTA, that was fitting very well. And that is how the government moved towards. But the problem is that if you look at the eastward, the country like China, Japan, Korea, and for that matter, ASEAN also, they are much ahead in terms of their manufacturing capability and manufacturing prowess. And when we, at that time in 2003, we were also simultaneously negotiating in World Trade Organizations. One of the major offensive interest for us was the services. And services, you know, that is, because at that time, what we recently realized our strength that we are going to be a big player in services trade. So that was notion and created because of IT-enabled services and all. But we forgot that IT-enabled services is related to the movement of professional, movement of people, which is always very sensitive. It's not so easy. Movement of capital is easy, but movement of people is not very easy. And the countries like Japan, Korea, I'm not talking about China, but ASEAN and also, except Singapore and all, where we are more familiar in terms of our professionals. But by and large, our professionals are more culturally in sync with the West. Still, if you're given a choice to move to Tokyo or London, just now we were discussing during lunch, you will go to London than to Tokyo for a job. So that was a kind of strategic, I won't say mistake, but of course that sort of misleading that while going with the East, we will be able to get access in services. Because of course we did not have much manufacturing strength to capture that market. Second important thing, you have to understand that ASEAN, for instance, the three countries, Japan, Korea, and China, they negotiated their agreement around 2006-07 with ASEAN. And by the time we entered that market was already captured. So even though we got some preferential access in that market, but of course we were hardly any, we were not very competitive in that market to penetrate. So after that, what happened that we were not able to demonstrate that benefit to Indian industry. Because government was telling that we have negotiated, now you have preference, you go and export. But of course, our industry and the companies were facing problem in penetrating that market because of not so strong manufacturing competitiveness. Of course, there were so many domestic regions also, cost of capital, infrastructure, so forth and so on and so forth. So there was a kind of, even within the government and within the industry, of course, there was a muted acceptance that these FTAs haven't able to deliver good for us in terms of enhancing export. And what has happened that between 2012 and 2019 or 20 till the COVID, our export performance was really pathetic in terms of, it was a flat growth almost. If you look at the compound annual growth rate, it was 1 to 1.5%. The export picked up after COVID, I would say. And so that also given a strength to the industry and government, both in the thing that, of course, these FTAs haven't worked. When the new Prime Minister Modi government came in 2014, they announced that we will go for review of all that agreement. So, but that's why if between 2012 and 2019, the entire FTA was dominated by RCEP. And RCEP, I would say that was more a strategic initiative for India because initial architecture of RCEP was ASEAN +3. So Japan took the initiative, got India on board, and invited Australia and New Zealand also make it ASEAN +6. So when that kind of architecture was presented to the government, of course, and that too came, coming from a very friendly country from Japan, so India was not in a position to say no, knowing very well that China is present in that. So I still remember when the negotiation started and the consultation started with the government industry. At that time I was in Confederation of Indian Industry. On the very first day, the question was posed to government, look, RCEP is a 10+6 countries. We already have FTA with ASEAN. We have FTA with Japan. We have FTA with Korea. We are negotiating with Australia and New Zealand. So that leaves only China. So with China, neither government nor industry ever wanted FTA. So why we are going for RCEP? So there was a strong strategic component to that. That's why India was on board for RCEP. But what has happened in RCEP that during the entire period of negotiation, our negotiating stance was more China-centric. So, but RCEP was revealing in one sense that it has really helped in building the capacity of industry in terms of consultation process between industry and the government. So I'll just take one more minute. So of course, that's a long story. We worked out of RCEP in 2019. After that, we changed our strategy, and that is what we call FTA 2.0. So FTA 2.0, in many ways, it is more kind of a strategic shift and very kind of bold strategic shift. Because first thing that we thought that let's look westward now, no eastward. Second, government decided that the Ministry of Commerce that there is no point in just prolonging the negotiation for 10, 15 years because scenario completely changes. So for instance, with European Union, you started in 2007 and now 2024. So 2007 scenario, 2024 scenario, just now we were discussing the AI and all. So it's a completely changing scenario. So let's have a time-bound agreement, and that we delivered also in case of UAE. Less than 3 months, 88 days precise, we have concluded. Second was selection of country, that we're looking west. So that of course was a kind of, that thinking was in sync with the industry, because industry always said that looks, go for the buyer country. Who are our buyers? It's USA and Europe, not the ASEAN, not the China, not Japan and Korea. Second was government really helped industry to articulate this offensive stance. That's why we've seen that nowadays industry is very much engaged with the consultation process of the government. And fourth was government was open to new issues. That was again the demand, which James also mentioned, like a whole lot of issues, environment, social standard like labor, gender, human rights and all. So that is FTA 2.0, but the challenge for industry is still more confined to the goods negotiation, tariff. Other issues like government procurement, environment, social standards, investment, industry still doesn't have that kind of capacity, and industry is not paying much attention to that. So that's the situation. Thank you.
Yeah, thank you. You're right that some of the long negotiations do not take into account the change scenarios, but these are important negotiations. We all of us appreciate, of course, that it does take time, especially with important partners, and India does consider a lot of aspects. You pointed out trade and services especially. That is something that I feel I would like to ask Dr. Singh relating to trade and services, that there is this sense that it's really difficult to capture the data. We do have a recent report, of course, of the Global Trade Outlook and Statistics report, which says that India's export has increased from, say, it was 4.4% in 2019, it has become 6% now in terms of delivery of exporting digital services. But how do you see, Professor, how are we able to capture this data? Because it's very difficult, unlike trade in goods, where it's very clear we can capture what goods are being exported, how much goods are coming in. But when it comes to services, and a very pertinent point was raised, that when it comes to mode 4, where there's movement of natural persons, how does the government capture this data, and how do statisticians deal with this?
Yes, thank you very much. And first of all, I extend my warm appreciation to Services Export Promotion Council for inviting me. Your question is relevant in the context that services are not classified at a decentralized level as the merchandise trade is. So we can fetch a data at a digital level per se. Our merchandise trade engagements with the different partners are concerned. Services are more into, you said 12 groups defined by WTO, 3J appendix, which is usually issued by DGFT. And in terms of trade, what we call a general agreement of for trade in services, there are 4 modes. So per se, how data is fetched? In fact, India has a robust system of data collection, but there are issues how a particular data is collected. So usually services data is not collected by customs. It is based on the document which is filed by the exporter to RBI. This document is known as soft tax. So any firm which is exporting out of India, usually at the maybe on a quarterly basis or on a monthly basis, depending on their milestone of billing. Big firm usually have a billing of maybe a fortnight or a monthly time. They will file a document duly authenticated by chartered accountant. Per se, their exports and imports are concerned with the RBI. So RBI collect the data, that's the nodal agency, and that is usually for mode 1, that is being exported out of India. But question is beyond, and for other cases, for example, when we talk about mode 2, when there is a people who will be working on a project, for example, project is in the United States of America, usually we rely on a data which is not directly collected. Maybe we can go for immigration data, sometimes we go for data which is not by us but by the other agencies. For example, number of visas being issued in the United States of America. Based on that data, we correlate that how many Indians are working in the United States of America, something like that. Now the major challenge comes for mode 3 and mode 4, because that is where the issues which are related to movement of people, investment, and there are other issues which comes in interplay. As on today, we cannot say any data is reliable. So the most reliable data is the data which is on the goods which are being exported out of India. But even within that, I may be doubtful. For example, if I'm offering tuition services online, which classification I'm referring to, being an ignorant person, even I'm not aware. So that data may be, for example, if I say it is a business related services, I find it, I contact my chartered accountant, and it is usually collected on that basis, and there are 12 broad sectors on the basis of which the data is collected. So there is a challenge per se, our data in terms of services export is concerned. I would also like to a little bit add with regard to trade in goods. I mean, when Professor Nedumpara was talking about that, our engagement remains suboptimal. Indeed, in fact, they remain suboptimal in terms of our engagement, which is well reflected in terms of exports, that we are in a bracket of 300 billion, 400 billion for almost 1.5 decade. From 2011-12, we are in 2024, we are still in 300, sometime 200 billion, 300 billion. Last 2 years, we have been able to graduate it. So it remains a mixed bag. Regions are there are many. For example, let me take 2 case studies because people will be able to correlate better with the case studies. Now, when we talk about certain trades, certain success stories that I would like to share with you, majority of the success that we have achieved is not because of FTA, it is beyond the FTA. Let me take 2 specific cases. India emerged as a global player per se, our motorcycle export is concerned. India manufactured its capacity is almost 2.5 crore motorcycle it can manufacture. It has emerged one of the largest exporter, almost, I mean, at par with China. We are, in terms of export, we are touching almost the same number. China manufactured a motorcycle as on today at a price of maybe $500 US, $450 US. We are manufacturing at a price of $900 US. Still, we remain a reliable exporter. So reasons are many, because in many cases, our success, and when we say success has come because of 3 things. Number 1, manufacturing capability. Number 2, manufacturing capacity. And third is a manufacturing competence. Unfortunately, we lack in all 3. China manufacture 1,000 million ton of steel. 1,000 million ton, mind my figure. Second largest producers in the world is India, that manufacture only 200 million, 180 million, 170 million ton of steel. So the price, usually we are in India, the Chinese steel is being dumped. What are the regions? We are putting anti-dumping, we are putting minimum import price, DGFT has come with what we call a steel import monitoring system. Am I right? Several measures we have come up, but still we are not able to compete per se. Chinese production of steel is concerned. If even today I have to order manufacturing of a container, I will not go to Indian manufacturer. I will go to a Chinese manufacturer. They produce at a fraction of cost. One thing. Second success story, which usually people discuss as a pharmacy of word, it has not come because of any of the FTA. So when you have a manufacturing, number one, capacities, number two, capabilities. Now let me define capabilities. In India, still majority of the steel plants are running on furnace. Travel to China, they are running, maybe 50% of the plants are furnace, but they have modernized themselves. Majority of them are running now on electricity. They are moving even a step ahead. They are coming with an induction. They brought a pipeline from Tapi, but what usually discussed in India, Tapi, they have brought gas from Turkmenistan, induction-based steel plant systems. They've dedicated gas, which is, providing them. And you can imagine, as a common individual, when you are running a coal-based facility, input costs become much higher. Scaling a business, keeping it down, keeping it up, it becomes a huge cost. But at the same time, I see a great change in terms of our engagement, and that is something which I would like to highlight. Maybe I will take additional 2 minutes. If you see, our initial engagements were with the countries which are production-rich economies. We signed FTA with Japan, production-rich economies. We signed FTA with Korea, production-rich. In terms of technology, production-rich economies. We signed FTA with ASEAN countries. They are production-rich, much better than India. Chinese, how they are playing with rules of origin to dump their products in India. How cycle, which used to be manufactured in Ludhiana at one point of time, is being replaced by China by setting up a SEZ in Dhaka. So these are that how they're able to leverage, their assets, their investment to dump their product in India by manufacturing in the country where we have signed our FTA. So the point I would like to highlight, the new FTA that we are signing, I see a ray of hope, and that is especially two FTA I would like to highlight too. India-UAE FTA. One beautiful thing that has come up to reduce just 1% duty on gold, just 1%. But see the whole business model. 1% reduction in custom duty will translate into, thousands of additional job, incremental export, not this year because market is down, buyers do not have a capacity to buy too, world economy is in lull, everybody knows it. But you see the whole business model, and that's something very historic, and I've written a case on that also. When gold is coming, the cost of financing gold is a very high value item. So gold, it is financed by banks from UAE at a lower cost. The cost of financing reach 2.5%, 3%. In our country, minimum cost will comes out 8.5% minimum. If you see even RBI rate today, there will be a minimum spread of at least 1%, even by RBI circular. So if you see that gold is brought by, manufacturer from UAE, and it is kept at gift city. So you are warehousing at a place where there is no custom duty. You are bringing it with somebody else's money. Now, people like you will come, will take a gold on a loan of 90 days. So you end up paying only for 90 days, manufacture it. And when you create a jewelry, now your people hypothetically do not have any working capital. You come to me, approach me. I release the gold from my FTWZ. Just on a loan basis or on a bond basis, you don't end up paying custom duty, number one. You are working, you're doing your business with other people money. Then the jewelry that will be manufactured again will be shifted to Dubai. 2 crore customer, 2 crore tourists every year visit. So the people all over the world, they come and buy their jewelry when they visit Dubai. That's the beauty. That's a role model the government can think of. Leveraging whether it is a services, whether it is a goods, and it will create good number of jobs which are at the top level and also at the bottom level. Usually goldsmith who will be working for these plants. A lot of automation has come up, but still I see the new FTA that we have signed, be it EFTA, be it with UAE, be it with Australia. We have seen our engineering export rising. So I see that there is a good job being done our negotiator, and I must congratulate them both largely in case of goods. Services, our engagements are limited as of now, except wherever we have got a success, it is only because of our capability. I will say we have been able to export to US without any FTA. We have been able to export to UK without any FTA. It is only because of capability. So mind my words, a nation need to create capability, capacity, and competence. And with that will come competitiveness. You will scale, you will create system, you will create synergy, you will bring sophistication, and that is how your success will come. Thank you very much.
Yeah, thank you, Dr. Singh. So there are some positives that we can see are coming out of the new FTAs. But at the same time, one wonders, invariably, the parties do envisage that there will be disputes. And that's the reason there is a dispute settlement mechanism provided in the free trade agreements as well. And increasingly, if there is this increase in exports, and Dr. Nedumpara also mentioned one of the questions that I had shared with all the panelists was about MSMEs. So, Mr. Sharma, I wanted to ask you, as a lawyer, where do you see these dispute settlement mechanisms being used by MSMEs? How effectively are MSMEs being able to use these free trade agreements, and what role do you think lawyers can play in that?
Thank you very much for the question, and it's a pleasure to be here. Excellent job by SCPC to collect all the speakers here on some very interesting sessions. So I'll give my perspective, and I've had the benefit of listening to my speakers before me. So before I address about how MSMEs can leverage FTAs, I think what we need to understand is the FTA 1.0, then FTA 2.0 I'll call the RCEP phase, which we left out, and FTA 3.0, which is now going on, or move towards the West. So traditionally 1.0, when the phase was going on, two topics or two subjects were most relevant for the stakeholders, the biggest stakeholders being the governments involved, because at our side, the industry was hardly involved in the negotiations. The subject of discussion was on goods and services. 2.0 in RCEP, there were some other subjects negotiated. The texts are also visible online, one can see there are some other topics. Now the 3.0 wave, which is huge, where we are tilting towards the West. Now, how the West negotiates is, already the customs duties in those countries are at zero, okay? By signing the FTAs with them, is India really gaining anything additional on the goods? You can already export several commodities over there in the 98 customs tariff chapters at zero duties. US duty framework at the WTO level ranges between 5 to 10%. Mostly the duties are below 5. Since President Trump came to power, 2 or 3 sensitive sectors they have identified. One is steel, another is aluminium. So steel is at 35%, aluminium is at 10%. There are special package duties only on China. That regime is separately going on by the US. As a result of US retaliation against, unilateral retaliation against China, I would call, EU did something fascinating. They said, okay, they did something haywire, we'll do it systematically. There will be madness, but systematic madness. So what they did, they launched a global safeguard investigation on steel. That duty has been in force since the last 5-6 years. The safeguards agreement will say, which we are party to WTO, that any safeguard duty must lapse at the end of 10 years. So let's see what the EU does, whether they are willing to let the safeguard duties lapse or not. 3-4 years we are waiting, and we have European Commission election also now in June. And that's also an interesting aspect for our discussion now. Now, when India is now moving towards the West, the reason is we have had problems with our tilt towards the East earlier. Perpetually, if you see the trade data, we are running in trade deficits with the ASEAN countries, even with Japan, even with Korea. So then with the West, we are already a surplus without FTAs. We want deeper integration with them. In COVID, when the supply chains were disrupted, everyone saw how the scenario has panned out. China, being reliable for 20 years, immediately become non-reliable. They are not in the good books of EU, Canada, and the US, but they are still the manufacturing hub for the world. So the West is looking for another place to shift the manufacturing. Much of the manufacturing has moved to ASEAN, but ASEAN has its limitation, the human capital, right? There is, beyond a point, you can't really invest and expect higher manufacturing scale capabilities. It can only happen through automation. Then India is the next possibility. We have English speaking population. The government is also now investing in skill development. So let's see how this pans out. The government is also very keen on inviting high-end manufacturing in India, which is hardware that, is there in every phone that we use. The very, very fundamental hardware that is powering the devices that we use. The chip manufacturing, which is a very sophisticated technology. So this is India's way of warming up to the West to encourage them to come to India. And one way to encourage them is by becoming an FTA partner with them. That shows a level of reliability that they can show to us, because we have signed on the dotted line that we are going to be a reliable partner. Our economy is open. Why don't you export to us? We will export to you. There are complementarities. We are not competing on goods. You manufacture some things which we don't manufacture. We welcome those imports. We manufacture something which you desire, so you welcome those imports. But there are conditionalities over there now, which is very interesting. So West says, look at our FTA model text. It's not only goods and services. We are going to deluge you with a few more commitments, and those commitments are arising from a chapter on gender. Imagine, what will a chapter on gender do in an FTA? But it is there, and you should read the text. There's a chapter on environment. There's a chapter on labor. There's a chapter on human rights. There's a chapter on anti-corruption. And these are all forming part of India's commitment to the West. Why? I'll give you some more context. So there's text and there's context. Now I'll give you some context why these commitments are there. With the China joining WTO, and they laid out the red carpet for the manufacturing from the West to move to them. They have become the manufacturing base of the world. There has been a ruthless level of efficiency achievement in China. So they have achieved ruthless efficiency and cost cutting in China. So they have become, giving us quality products at a much lower cost. That has led to shifting of manufacturing from the West to China. It has eventually led to job losses. Okay. Capital is moving to China in a big way. There is rampant dissatisfaction in the West. And this issue has become more political, as we now see in the various elections that are happening in the world. Everywhere you will see this, there is general dissatisfaction, and you want to bring manufacturing back to the West. While India gives the assurance that we are not going to steal your jobs, we are only going to complement your economy in a certain way. So now, to answer your question, how the MSME is going to leverage the FTAs, I think it's going to be tough, because now the commitments are that if you want to access the US market, you cannot do based on slave labor. Your factory should not have any slave labor. You should pay proper minimum wages. Show us that there is gender equity, there is no inequality. Show us what are the working hours in your factory. So these are the commitments that are coming up from the newer FTAs, which were not there earlier. Show us as the government of India that you will protect our intellectual property rights. When we transfer the technology to India to manufacture chips, what can India tell us or show us from the laws or regulatory regime that our technology will not be leaked to sensitive countries like China or Russia? Can we really manufacture chips here? It's a very sensitive product today. Can a capital good, the lithographic machines which are manufactured in Europe, can they be shipped to India? Can you manufacture chips here? Because there are rampant sanctions also. So sanctions is outside the FTA regime, but they are also, as I would say, a co-pilot along with the FTA. So.
All right, thank you. There are many more questions that come to mind, but unfortunately there is a lack of time here, given that some of the earlier sessions went overboard and we ended up where we are right now. So I will open the floor for maybe one or two questions, that's it. We don't have, well, Dr. Basin is saying we can't have any questions, so thank you so much. We'll end the session at that. Thank you.
Thank you.
I didn't want to be part of this picture.
Please, speakers, please wait for the group photograph, please. Dr. James, I would request you to kindly come. Please rest of the speakers for the session. Please come for the photograph and the felicitation, please. Please, Shravan, please do come. Shravan, Dr. Ram, Pranav sir. Again, Ankush Sharma. Please join us for the photograph and for the felicitation. Really sorry for.
You should apply, you should stand your foot down when others speak, beyond the time.
Where is Shravan?
You see, time management and time discipline is very integral to the legal profession. And brevity is an art, I think, which we all should follow. Therefore, we must maintain time discipline and confine our presentations to that only. Yeah.
See, we are not coming here. See, actually, but there was a mistake. The program was, the last session was supposed to end at 2:45, right? It ended at 3:40. 1 hour late, why? Then somebody should have. I agree with the brevity principle.
See, these are given proper time.
Thank you. No, she had to see my problem. Then I think we are supposed to have 4 hours.
To begin quickly with the session 5 on dispute resolution, negotiation, mediation and arbitration, I would like to call upon stage Ms. Abhisar Bairagi, partner Khetan and Company, as moderator. As an esteemed panelist, we have with us Mr. Sanjeev Sharma, senior partner, Saraf and Partners, Mr. Arush Khanna, partner, Newman Law Offices, Ms. Purnima Kamble, senior partner, Fox Mandal and Associates, who is joining virtually with us, Dr. Rama Joga Rao Kasibatla, additional legal advisor, Department of Legal Affairs, Ministry of Law and Justice, Dr. S.B. Saraswat, Managing Director, Global E-Auction and E-Procurement Company, Mr. Osaro, partner, Purstone and Grace from Nigeria, who would be joining us virtually. All the dignitaries are welcome on the stage, please.
We already have the presence of Dr. Manoj Kumar, the Additional Secretary, Ministry of Law and Justice, Legislative. Therefore, my request, you see, to the panelists is to please keep your presentation brief, because our Honorable Chief Guest for the valedictory session is already here. Thank you.
मेरे को इतना
I think I answered. Good evening, everyone. It's on. I think I'm audible, sir. Yeah? Good evening, everyone. Thank you for joining this session, and thanking the people who are outside in advance for joining this session. I hope they come back soon. I'm still not audible, sir.
Switch on your mic.
There's no switch to it. I'll do that. I'll just shift here. Now you could just move my name here. Might be here, yeah? Am I audible now? Yeah. Good evening, everyone. Thank you for joining our session. I think I just begin without much ado. As a country, we continue to be a very attractive destination for foreign investments, and that's what global trade and everything is all about. But let me tell you how we connect our the legal side of things to it. May I continue? Is there anything? Yeah. So let's just say that the appeal of global investments in this country is dependent on how do we deal with our conflicts, how do we avoid them, how do we manage them, how do we resolve them. And with the kind of backlog that we have in this country, in terms of judicial cases, I don't think that we inspire much confidence. But having said that, if you look at our alternate dispute resolution mechanisms, then there's been a lot of activity. We are buzzing with things happening in this country. We have new amendments, we have new amendments, we have new statutes. So we've been busy on the legal side of things. So having said that, let's just say that I saw this internet meme which said, India is not for beginners, India is for the experts. So we have some experts here with us today, and best suited to tell you what's happening here. So let me start with the government representatives first, because I think Dr. Kasi Vatla would have the best insights into things. What is as a government representative, sir, as a legal advisor in the ministry, you'd be looking at things from every point of view. You've been a client, you've been somebody who's drafting statutes, who's looking into policies. So, sir, you tell us that in the Indian scenario at this point of time, what is the significance of alternate dispute resolution?
Thank you very much for affording me this opportunity. I'm thankful to the SEPC. And you rightly put the question about the scope and the development in the scenario of the dispute resolution in India. I must say, and I must confess, I should say that, rather than saying I should confess that, yes, definitely there is a drastic change, there's a metamorphosis in the field of ADR. You might have witnessed that several initiatives have been taken in this regard to expedite, or I can say that even to stimulate the process of ADR. For example, the amendments in the Arbitration and Conciliation Act and the enactment of the Mediation Act 2023, enactment of India International Arbitration Center, and also amendments to the Commercial Courts Act, amendments to the Specific Relief Act. All these glaringly signify and emphasize the sternest efforts made by the government to expedite the process of ADR and to resolve the disputes amicably, effectively, and efficiently. But at the same time, handling the disputes, especially the cross-border disputes. You rightly started with the investment into India, because when we are expecting a 5 trillion economy, we definitely look at the investments from abroad, the foreign direct investment. So when there are investments, certainly the investors will look at an amicable resolution of their disputes. They invariably demand for a time-bound process for settlement of these disputes. But in this regard, still we are facing some challenges, because we are having several ongoing arbitration cases. I myself involved in more than 2 dozen of cases, starting from Enron to the present disputes. You might have seen about the Vodafone saga and the Cain saga, and of course the Anthrics, there was still ongoing disputes. Right. But still, there are several efforts made to resolve these issues, and we have drastically changed our model draft of investment treaty from 1994 to 2015. We come up with a new draft wherein we made an inbuilt provision for exhaustion of local remedies for raising of a dispute under the investment treaty. That is a dispute. And some new areas in this regard are in some of the agreements. For example, in Brazil, we don't have a dispute resolution clause in that. There is no ISDS mechanism where there is a facilitation joint consultative mechanism process is incorporated. And across the globe, there is a serious concern about this investor-state dispute settlement mechanism. And some countries and some agreements, this is totally weeded out. For example, in the North American Free Trade Agreement, which has been concluded very recently, there is no ISDS between America and Canada. But there is an ISDS mechanism between America and Mexico. And even in the recent, because the pre-session, there was some discussion about the RCEP. I was part of the RCEP negotiating team. There is no, as on date, there is no ISDS mechanism under the RCEP, and it is going to be resolved. Even in our model text, there is a provision that we may come up with some statutory mechanism or some appellate mechanism to resolve the investor-state disputes, and that's a process, but we have not yet established or commenced any institution except the institution of India International Arbitration Center. So hopefully, this India International Arbitration Center may establish itself as the biggest attraction for resolution of commercial as well as investment treaty disputes. Though India signed the UNESA Convention, the popularly known as the Singapore Convention on Mediation, India is yet to ratify the convention. Though we evolved an enactment in this regard, but fortunately or unfortunately, there is no much inference or whisper about international mediation in the Mediation Act 2023, because the very wording, the preceding provisions of this enactment indicates that it applies to a mediation that is convened or conducted in India. So with that assumption and presumption, we can say that it is not properly addressing the International Mediation Convention, but because it is a new beginning, and law being an evolving organ, it cannot remain static. It has to grow with the change in the situation, change in the circumstances. So since we are in a changing scenario, we are in a developing mood, we are in an evolving mood, certainly there may be new provisions may come up, new amendments may come up to address these concerns. This is my preliminary reaction to the concern about dispute resolution. But whenever we draft an agreement or a treaty, whether it is a cross-border commercial dispute or it is an investment treaty dispute, as a lawman, we invariably presume and assume that there may be a dispute. That is why we incorporate dispute resolution clauses. In case if there is any dispute in interpreting or understanding the provisions of this act, this can be resolved through blah, 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 blah. So this dispute is inbuilt in any agreement. But what is required is a commitment to resolve it. And my experience in handling various disputes in my official capacity as a one of the legal advisors to the government of India is, in all the cases, invariably the mediation failed. It may be the investors may have an assumption and presumption that the government may not resolve it in the proper manner, but that attitude has to be changed. Because unless you bring both hands together, then only you can clap. So to resolve an issue amicably through mediation, you have to have a joint effort both by the state or the government and by the party on the other side. Then definitely mediation will be a successful attempt to resolve the disputes. And one more, I'll take 1 more minute, sorry, with due apologies. In this scenario, there is one more development on the front of the European Union. European Union proposes a separate court, establishment of a separate court, investment appellate mechanism or a separate court for resolution of the investment disputes, but that is in a in a very nascent stage because there is no data to suggest or there is no inference to suggest how this permanent court mechanism will work. And except in EU, Canada free trade agreement, there is a clear agreement between the two countries that this kind of appellate mechanism can be resolved. UNCITRAL is also coming up with the modernization or reforms of ISDS through Working Group 3. Recently, they concluded about establishment of an advisory council in resolution of these disputes. But we have to see how all these processes or mechanisms will address the concerns. India is actively participating in all these, actively observing the pros and cons of these systems, and may come out with an appropriate system or appropriate method at the appropriate level. Thank you very much.
Thank you, sir. You summed it up really well. Taking a cue from there, where sir said that, most people think that the mediation is going to fail when, we're talking about bilateral investment treaties. Let's bring it closer home. And Sanjeev, you might be able to tell me this, that now with the new law in place, do you think that we are still construing mediation as something which is, a first step to an arbitration? Or are we still looking at it as something which is a pre-arbitration formality, or are we looking at, does it have its standalone value finally?
Thank you, Abhisar, and thank you, SCPC, for having me here. And I know that this is a topic which is very close to Mr. Bhasin's heart also, because in the morning also he spoke about mediation and the necessity of mediation to avoid unnecessary and unproductive expenditure on litigation.
Right.
But obviously, firms thrive on this, so I would not touch too much of necessity of mediation. But yes, I think over past 15-20 years, we have seen that mediation has grown substantially. As a lawyer, I remember 15-20 years back when we used to go to the courts and managing and attending the matters which are going on for 5-10 years. The court used to suggest, there is so much of litigation fatigue, why don't you go and mediate and try to settle it? But as a voluntary mechanism, and purely because of the litigation fatigue between the parties. From there, traveling to 2015 Commercial Courts Act, where Section 12A bring in the mandatory mediation as a pre-step. I absolutely agree with Dr. Rao also when he says that mediation most of the time fails. But the fact is that there is a positive development towards the mediation. And that has been accepted by the Government of India also when they bring in Mediation Act 2023. Most of the provisions are yet to be notified. But what is substantial about Mediation Act 2023 is that it recognizes a principle that if there is a settlement, then that settlement agreement would be treated as an agreement which is an enforceable agreement, just like a decree in Section 27, which is a very substantial development, because normally what happens that if there is an agreement and there is no arbitration going on, then that agreement would in itself become an agreement, and for which you have to litigate to get it enforced. But I would also like to add along with that, that there is a substantial development internationally also with regard to the mediation part of it. There is Dr. Rao touched upon the Singapore Mediation Convention, which is of 2019, but in 2014, Singapore International Court and Singapore International Arbitration Center and Singapore International Mediation Center actually entered into a convention which is called a Protocol of 2015, which basically talks of arbitration, mediation and arbitration, which is a very wonderful concept, because then this is a mediation arbitration protocol. If a party basically approaches SIAC, then mandatorily, obviously, they will have to issue an arbitration notice. Correct. Once the notice is issued, SIAC would, what SIAC would do? It will constitute a tribunal and then immediately send the parties to the mediation to the Singapore International Mediation Center. And if there is a settlement, that settlement agreement comes back to the arbitration so that it can be passed as an award and enforced. So it becomes enforcement becomes a very important issue. And I think the mediation, if the way we are trying to recognize, would definitely help us in settling and reducing the number of the disputes also on this front. I think it's a very important step which the government is taking, and everyone is acknowledging the importance of mediation nowadays.
Thank you, and thank you for sharing with us that what happens on ground. You have a hands-on experience. And another person that has a hands-on experience on this panel is Purnima, who's joined us. Can we have a mic test for you?
Yeah, hi, Abhisar. I hope I'm audible.
Yeah, you're audible. So I'd like to ask this question to you, Purnima, that, our ADR, all our ADR practices, they've all been based around minimal judicial intervention. Do you think that at this point of time, we've been able to achieve minimal judicial interference?
So first of all, SEPC, thank you so much for having me over virtually, which is a very kind gesture on your part. Abhisar, thank you. That's a very, very important question. I think I would agree with what has been said by the earlier speakers. We are just getting there. The intention of ADR is to have minimal, intervention by the courts. But I still believe that it is a journey which has to be traveled. In fact, there are cases I am seeing where judges, honorable judges, are having understood the importance of mediation, are themselves trying to settle matters during, proceedings that are going on in court, which is a wonderful step, but it has to be understood that ADR has to be done by people who are certified, who are trained in managing ADR. For example, I'll just give you an example. Mediation. We have to understand, while there is court-directed mediation, while there is a Mediation Act, mediation is a voluntary process. And both parties have to voluntarily want to settle, only then mediation succeeds. And therefore, there is a need for the mediator to have some personal skill sets which will help that mediator win the trust of both parties. Being a litigator and a mediator, I understand that difference very well. And the moment, the roles are reversed and the mediator is coming across as a judge, then the parties tend to get a little wary. And therefore, it becomes difficult to sort of breach that gap. Now, coming directly to your question, yes, I think judicial intervention has reduced quite a bit. The judgments are all very clear that arbitration should not be meddled with. Arbitration, the need for arbitration to be on its own and the award being binding with minimal interference, interference only when deemed necessary, maybe for the protection of interest of a party, which cannot be done by the arbitrator or because of public policy. Only in such instances there is, I won't say interference, but support in that whole ADR mechanism. So that thought is ingrained now in the judicial system, and that is evolving very well. Having said that, I do believe that there are times when there is an overkill, where that distinction of a mediator and a judge tends to get a little blurred, and that has to be safeguarded against. That if safeguarded against, because what happens, you see, there are practical difficulties in the way the court functions. I'll give you very, very practical instances. Law, we all understand, we all know, but practical instances, for example, the courts are busy. Their matters get listed, and once they go off the list, it takes a long time for a matter to come back on the list. Now, in certain matters, what happens when the parties have gone to court for adjudication, if at that point there is mediation sought, in the sense there is settlement being done by the judiciary, sometimes the matters go off the list because the parties have gone back to get permission from their clients. And when they come back, by the time they want to come back with the instructions, matters gone off the list and again gone into the pipeline of when it is going to get listed. So, the matters can get complicated like this. So it is very important, because we are at that nascent stage, the boundaries should not get blurred. Mediation is by mediators who should be trained for that. Arbitrators, on the other hand, have to be carefully trained for arbitration, and they must recognize that there is a baggage which needs to be left at the door. So when I'm talking about, have we achieved minimal interference, there is a subtle and there is a legal point. So legally, yes, we are moving towards it because of the judicial precedents, etc., which are setting the boundary is very clear. Arbitration should not be, disturbed. But the subtle part also needs to be dealt with. Arbitrators also need to recognize that, the Evidence Act or the proceedings or the procedures they're going to follow need not be so intense like the CPC, because, you have that flexibility in arbitration. The intention is that the ADR mechanism not only be an alternate to the judicial the sort of strength, or rather the stress on the judicial system. It's not just an alternate. It should be able to give you expedient result. It should be able to be efficient. And therefore, that training for arbitrators is very important. And of course, once a litigant has gone to court, then unless the need is found to be referred to a mediator, it's best to leave that to adjudication. So I think to answer your question directly, Abhisar, from a legal perspective, from the way jurisprudence is evolving, I think ADR is now growing on a standalone with minimal interference from court, and that is the best way to grow. But I think the subtle differences and the boundaries now need to be understood and drawn. I hope that answers your question.
It does. Very well said. Thank you so much. Dr. Saraswat, now that we have the benefit of your company and to the uninitiated, Dr. Saraswat has penned down this very comprehensive book on construction disputes. He has it here. Thank you, sir. So I just wanted to ask you, sir, that construction disputes are complicated, they're huge, they're voluminous. Do you think that, and arbitration is obviously always the preferred route when it comes to them, but do you think that mediation, negotiation, conciliation, all these other alternate dispute resolution things could actually work for construction disputes?
Okay, thank you very much. I'm greatly thankful to SEPC that it has given an opportunity to speak and be here to express on a very important area of service sector, that is construction. And I would like to share with you, which all of you know very well, that construction is an extremely important, vital sector for India, particularly in view of the development which is taking place today. If you look, huge number of infrastructure and construction projects are coming up. Our life is influenced to the extent that it is contributing 9% of the GDP only through this sector. You also will be happy to know that 2.7% employment is generated by investment of 1 lakh rupees, which is a very, very high figure. And it is also a notable point that around 70 million people are being employed by this sector. Keeping this importance in view, it is very pertinent that our construction and infrastructure projects must be completed in time. What is the situation? Please have a look. Exceptionally, some project may be completed in time, maybe, but 99% projects are delayed. And there is no relief because it's a multi-party execution. There are at least 20,000 activities in a project. There are vendors, suppliers. There are various disciplines like civil, electrical, mechanical, instrumentation, IT, construction, purchase, all functions which anybody knows are subject to a lot of disputes. But why disputes do take place? That is the question. Question is that it is a commercial activity. Everybody is looking for an opportunity. Client is looking to optimize the prices, and contractors are looking for making money out of it. And at one or other point, due to one or other reason, there is always some delay. And this delay is cascaded by another n number of delays. And finally, the delay is such that project is not delivered. And then what happens? Contractor looks for extension of the time with exemption of the LD, and also making huge unrealistic claim. Contrary to this, client is also telling that my project is delayed, my revenue is stopped, and you have made a damage. Therefore, I am supposed not to pay you, rather recover the money. So here starts the story. And this story goes on. They start negotiating at all the levels. They try to have the mediation, but I can share with you confidently based on my long experience that mediation is an excellent process. And I hope this works very well in particular sector, particular industries, but in particular sector, it is 100% failure. I have got a huge experience having worked maybe decades in Europe, Middle East, and in India, and particularly in steel sector. And I've handled the large project, therefore I am talking from the ground reality that people, particularly in the PSU sector, they will agree everything in mediation. They will discuss for 2 weeks to come out with a draft. And finally, when the sign is to be done, they will come out with changes of the sentences, words, and the mediation agreement, settlement will not be signed at all. So this is the something which is the outcome in particular sector. Of course, some of the sectors are very sensitive to this kind of requirements when they understand that this is going to affect the contractor and vendors, subcontractors, and also the client, that is the company. Then they try to take some actions and reach some kind of agreement, at least to continue the job. But in PSUs and some particular sectors, I can boldly say that mediation is not going to make any dent unless and until some drastic measures are taken from the production of these vigilance, CBI, and auditing authorities. Because that is the fear which these fellows are having. They will die, but they will not sign the document. And therefore, I am giving a very clear message with a humble submission to all the stalwarts. And I understand that the authorities who can have some say, they can take my input, because I was part of the government, so I was not supposed to talk frankly. But today I am no more part of the clutches, so therefore I can talk in so frank words that please take a call, give a safeguard to these executives, maybe 10 in committee, so that they become effective, efficient, and agree, because 75,000 crores is tied up as an investment in the disputes in particular sector. So you can very well imagine this is just an iceberg. The true figures do not come. That's why conclusively, to respond to your query, mediation is an excellent methodology, and I think what Mr. Sanjeev Sharma has told, that has added better tools and teeth to take care of the settlements, that it will be enforceable. But what I have suggested also should be noted, so that it becomes truly applicable in all the sectors, and that if start working, then I think what we are talking of 5 crores, that will come down slowly.
Thank you, sir. Thank you so much for that. Arush, I'll quickly come to you. And let me ask this. You've been on so many panels where we all discuss arbitrations, what's happening, what has been happening. Arbitrations are here to stay, and let's not get into what all have been the historical problems. But on a positive outlook, what do you think? Because there has been a committee, there have been so many recommendations which have come in. What do you think that at this point of time, as we in today's date,
are the progressive steps that you think are going to really work out? Or you think that they've been actually based after assessing all the issues that were practically being faced? And so what are those few developments that you would want to point out? Or if you could point out some of them for us.
Well, thank you, Abhisar. I trust I'm audible. Thank you very much, SCPC, for having me over. It's an absolute honor to be here, and it's also endearing to see a very good gathering on a Saturday afternoon. In terms of arbitration, I think one of my colleagues just spoke about judicial intervention. I think that has plagued the process of arbitration immensely over the last 20-25 years, from the day we started with our current regime. Judicial intervention has seen a slew of legislative as well as judicial changes in that sense. Today, we have the scope of 8 and 11 of the Arbitration Act has been streamlined to an extent that the power of a court to examine the existence of the agreement is only prima facie, using the doctrine that my examination will be confined to only whether the agreement is prima facie in existence or not. Then, in terms of certain landmark rulings, we had the ruling of PASL in 2020, where both parties, 2 Indian parties, were entitled to choose a foreign seat of arbitration, and that was upheld. We had in 2017 the famous case of Centro Trade, where a 2-tier arbitration clause was upheld. We've had cases like Amit Lalchand, where a party, even if they have not signed the document, are bound by the arbitration. Very recently, most recently, we've had the case of NN Global 3, where the issue of stamping has been held to be one of admissibility within the remit of an arbitral tribunal. So that is on judicial intervention. You spoke about an expert committee report. Recently, there was one in February 7th, 2024, it was released. And there are some very noteworthy reforms. I would highly encourage all arbitration practitioners, aspiring students to look at that report. They've encouraged institutional arbitration. Of course, we still haven't notified 11(3) capital A of the Arbitration and Conciliation Act that designates an institution to appoint an arbitrator. But I do see that happening very, very soon, given that the committee has now drafted their report and made recommendations. Most noteworthy, to introduce the concept of an emergency arbitration in our arbitration landscape. I think today we cannot talk about court interference without not talking about the fact that I think it is time that India incorporates the provision of an emergency arbitration, and the expert committee does. They propose introducing 12 capital B, wherein an emergency arbitrator will be directed to pass an award within 30 days from his or her appointment. Thereafter, another significant amendment is to introduce the concept of third-party funding in India. Now, as you are aware, TPF as a concept was prohibited in most common law countries under the doctrines of maintenance and champati. But those doctrines have diluted because they have to embrace modern day economic realities, and therefore they cannot stand now. Having said that, I completely agree. They have proposed to expand the meaning of the term affiliate to include a party who funds a party to an arbitration. And under 18A, they have also made it clear that if a party to an arbitration is being funded by a third party, then they need to give that intimation to the tribunal. Whilst it is a laudable recommendation, but TPF as a concept, I am of the view, will have to be regulated in India as a concept. Otherwise, we will have issues like confidentiality, conflict of interest, influence over arbitration by funders, and in cases of cross-border investment, there could be hiccups with FDI policies as well. So that is also there. I think one noteworthy amendment that I want to conclude with is the power of the court to modify an award. Now we've all spoken, Abhisar, you've spoken as well about modification. Today we have a very scattered line of cases when it comes to modification. You have the case law flowing in from NHI versus Hakim, which says that the court cannot modify an award, and there are several rulings following it. Then there is another parallel set of rulings in Vedanta versus Shandong, which says that the courts can modify an award, and there are rulings that are following that as well. So there's no clarity. So the committee has said, give it clarity, and if an award can be compartmentalized into fragments which are each independent of the other, then an award can be jointly or severally set aside, or a part thereof can be set aside, because otherwise you're relegated back to from where you started. Your award is challenged, the award is quashed by a court, you're back to zero. In this case, the courts can also look at it because you don't have an appellate recourse in arbitration. So 34 becomes very important. So even the courts, just like they do in under Order 41 in a first appeal, they can look at it in a more nuanced and calibrated way and see if two claims have not been adjudicated in accordance with the Arbitration Act or in accordance with the contract, and they are falling foul of 34. Those two claims, the awards under those two claims can be set aside, whereas the other claims can stand. I think that would give it more overall efficiency. But yes, the recommendations are on paper, and in arbitration, in my limited experience, I see that it's not important that we do the right thing, it is important that we do it the right way. So I'll conclude it on that.
That's a good
Sir,
teaching to take home.
If you just give me permit, I'll just want to add 2-3 things to what you just said. One, the power of the tribunal to modify has been referred to the larger bench by the Supreme Court very recently in Gayatri Balasani's case. Yeah, this is one. With regard to the reduction in the judicial interference, there are few more things which after the 2015 amendment have been brought in. One is bringing in section 9 subclause 2 and section 9 subclause 3, where it says that you have to initiate arbitration within 90 days so that the powers of the court can be curtailed, and parties can at the first initial instance within 90 days can be referred to the tribunal. And third is about the power of the court to interfere by way of section 9 unless it is efficacious. And then obviously reducing the scope of raising objections under section 34 after 2015 amendment, and also making amendment in section 36 that there will not be an automatic stay on the operation of the award. I think there are, and government is making very positive and taking positive steps. Obviously, there can't be an explosion of amendments which will actually derail the whole process. It has to be gradual, we understand it, and so that everyone can adjust to this process, because there are a lot of things which have already been ingrained in the judicial system. So you cannot just have everything at one go. It has to be gradual.
One more in addition, there is an amendment in 2019 to 36 where the allegation is that prima facie the court feels that the award is on the basis of the fraud or corruption, then it will get stayed, and that is a recent change in 2019.
Right. I think
Have I your permission? Just
of course you do, sir.
thank you. About judicial interference, you see, when we talk of foreign investment being made, they want some certainty in the law.
That's true.
As that also as pronounced by the Supreme Court, because people presume that that would be final. Now in the latest judgment curative petition, 2 stages have been added, you see, to the arbitral process challenge in the courts.
Right, sir.
First section 34, 37 and all that, it goes on, then it is decided by way of an SLP by one bench, then you take it to the review, then you go take it to the curative. So what sort of finality we are looking at? If the highest court of the land, curative is one of the most rarest, you see, of the cases. And this is, you have added, you see, to more judicial intervention, and that also in arbitration matters. So nothing was final. That is one point, you see, I want to make, that let our judiciary also be conscious that there needs to be a clear-cut pronouncement of law. Yes, after several years you want to review something, you do it, you have a re-hearing, refer it to, but at least for some time that law should prevail. So people should know what the law is. Then second point is Mediation Act. What is the need for a Mediation Act? Because mediation is a voluntary act.
Correct.
Unless there is a meeting of minds that there will be mediation, we agree to a mediation. You see, only then, just having section 27, that okay, once a settlement is arrived at, it can, you see, form the basis of like a court order. But before you come to that stage, you must agree to mediation.
Yes.
Therefore, that requires a change in the mindset of people.
That is true.
It is something very fundamental. And right at the stage of schooling or when they are students in law, that has to be inculcated, you see, the spirit of settlement and mediation and all that. The learned speaker also spoke about the India International Arbitration Center. I think we had about 20 years ago, ICADR. It was set up by the then law minister.
Yeah.
And excellent building, beautiful building, but nothing inside the building. No activity. Nothing, you see, no intellectual activity was carried on. So I hope that this India International Center, which is proposed, will be really a good institution which will inspire confidence and not meet the same fate as ICADR did. Thank you.
Well said, sir. Well said.
Happy sir, I would like to add to that with your permission.
Please do, Poonam.
So I'll just make an observation here with reference to what the respected speaker just said. A case in point is Section 12A of the Commercial Courts Act, where mediation is mandatory. And you will find that option of mediation as being exercised purely as a tick box mechanism. Very, very few people are actually utilizing that facility of mediation. The intention behind that statutory insertion of 12A is very noble. It is to give both parties an opportunity to settle before actually going forward with the commercial dispute. And commercial disputes are ripe for mediation related settlements. But nobody, and I can tell you with that with certainty, is really exercising it the way it has to be exercised. Also, there are certain loopholes which need to be recognized. We have certain acts like your Negotiable Instruments Act, etc., where, say, for example, if it's a case regarding a bill of exchange and you want summary proceedings. Now, when you go for summary proceedings, there is no clarity whether it comes before the commercial court or it comes before the civil court and under CPC. But if it comes before the commercial court, which I have done some matters where this issue came up, then what happens? They tell you to actually do mediation first. And the whole idea of summary proceedings is to be able to get a summary judgment ASAP. Now there is a conflict and the parties don't want to do mediation. They simply go for that purpose of tick box. So what the speaker just said is awareness. That awareness is so important. And today in our schools, when we still talk about law, we talk about litigation and maximum arbitration. We do not talk about dispute. We do not talk about the options available to a person who has a dispute. I am not saying litigant. What are the options that can be explored? So I think larger tools have to be applied from the schooling stage to ensure that that mindset is inculcated, where people understand that if a dispute arises, there are alternate ways to settle it as opposed to just going to court. Thanks.
Thank you. Totally agree. It's actually ironical that we had to bring in a law to regulate a practice which had nothing to do with law, which was based on avoiding law. but it is what it is. And as you rightly pointed out and what Mr. Vaseem said, that yes, it is a mindset which we did not have and we'd have to inculcate it. So we stand at the cusp of great development. So it's not all that bleak, and maybe next time we have a panel like this, we'd have happier news to share. I think with that, we just conclude and save time. Yeah.
Thank you.
Wonderfully done.
Thank you so much, sir. Wonderful.
You spoke to the point.
Thank you, esteemed panelists. We request you to kindly stand for the group photograph, please, for which I would like to join our legal chairman, Mr. Rakesh Sharma, to join and do the felicitation, please.
This book I want to give to you, public. Okay? And this is containing complete details of Sonia, I would like to give this book to.
Thank you so much.
Thank you, sir. Certainly, we look into those aspects which you are
Yeah. There are many
I know
things.
there are certain hurdles as far as the
No,
PSU circles.
I have written many things.
Thank you so much, sir. Thank you.
I wish we had more time.
Yes,
But
sir.
we have kept the session earlier.
No, sir. Catch up with you.
Thank you, Abhisar, and the co-panelists, please. Thank you.
Section to 2017. Justice Sri Krishna has pinpointed categorically is the same in his report. On the basis of which it has been recommended to get it sidelined and then come up with
That's true, actually, sir. कितनी बड़ी थी सर मैं एक मैटर करना चाहती थी आगे से कुछ तो
So, the other suggestion to keep it because I think you are told is expected to be the most interesting, so that we can take part to keep people.
To begin with the valedictory session, I would like to call upon stage Mr. Rakesh Kumar Sharma, Chairman, Legal Sector, SEPC, Mr. Sanjeev Sharma, Senior Partner, Saraf and Partners, our chief guest for the valedictory session, Mr. Manoj Kumar, Additional Secretary, Ministry of Law and Justice. Sir, we welcome you on the stage, please. We also welcome Dr. Lalit Bhasin, President, Society of Indian Law Firms and Founder Chairman, SEPC. Sir, please. We welcome you on the stage, please. People seated at behind, kindly request you to come at the front seats. Kindly come in the front rows. As we are waiting for the additional secretary to join us, for your kind patience, please. Requesting additional secretary Mr. Manoj Kumar to kindly come on the stage, please. Now I would like to call Mr. Rakesh Kumar Sharma, Chairman Legal Secretary ACPC, to give the address at the valedictory ceremony.
Journey of the day coming to an end with wonderful learning and lot of good notes. I think morning I started as a layman, traveled a bit to become a lawman, lawyer and a learner. Very well packed, 35 speakers with us and all abreast of lot of knowledge. So my all thanks to all the speakers for making this journey so tremendously powerful, full of learning. Thank you very much. And I think because of the time constraints, we'll have the next person, please. Thank you.
Thank you, sir, for your precise address, but yet meaningful. Next, I would like to call upon Mr. Sanjeev Sharma, Senior Partner, Saraf and Partners, to give the key takeaways of the day, please.
Thank you so much. In fact, I've been given responsibility to basically some of the key takeaways of the conference. And taking a cue from Mr. Sharma, in fact, I need to be very brief. I think what we have realized in today's session is that change is something which everyone is expecting, and change is something which is now the constant. And I think we have touched on, the distinguished panelists have touched on very important issues. To start with, Mr. Bhasin talked about the opening of the legal sectors, and he has basically highlighted a very important point that unless we have a mechanism where we can overcome the judgment of the Supreme Court, we cannot have a meaningful opening of the legal sector, though it is a necessity, and it is a necessity because this is the requirement of the time, and this is also something which is necessary for the young generation so that they have a better exposure to the legal system and the latest development in the legal system. And this is a very important takeaway from this. And the second is about the important discussion about the AI. And AI is something which is here to stay. How much we get impacted is something which is still in the realm of discussion. And no doubt it has started to impact at the initial and the levels, which is actually the initial level of the judicial system and the processes, but definitely is going to impact us. But I still believe, it's my personal view, I think AI may not be in a position to change the analytical skills which the judicial system requires. But we need to see how much we can adopt this kind of a technology, which is the necessity of the hour. And third, and the important point which we have just discussed and concluded about the mediation. Mediation is something obviously may not require the judicial interference, but yes, because of the reluctance, because we have discussed that it is being treated as something which is taken as a tick the box. It has to come in, we have to teach the young generation, and we have to inculcate that kind of an habit, that mediation should be treated as something which is a very important component of the alternate dispute resolution, so that disputes can be resolved at minimum of the cost and the speed, and so that it also reduces burden on the judiciary. And I think one thing which is very important that our Attorney General, which he has touched on, is about ease of being in law and ease of being in legal profession, so that it can handle the issues of ethics in the profession. And he has also talked about two important issues, which he said that he will definitely be coming out in open in next few months, about the arbitration bar and about the government litigation management policy to avoid stagnation in litigation and bring more efficiency. And this is also very important insight which we have got during the today's session. And last but not the least, the changes required in the legislation, especially Mohit talked about, my managing partner talked about making changes in section 73 of the Contract Act, so that we can have like a proper damage assessment and recovery proceedings, and the importance of bringing down the Indian ranking on the enforcement panel. I think these are the important takeaways from me. Thank you so much. Thank you everyone for being patient with us. And I think I want to thank all the distinguished guests and Mr. Manoj Kumar to take out time and come and address us. Thank you so much.
Thank you, sir. Now, for the valedictory address, I would like to invite Mr. Manoj Kumar, Additional Secretary, Ministry of Law and Justice. Sir, please. We welcome you with a huge round of applause.
Well, good afternoon, friends, and last session, valedictory session, and that too after a little bit of delay in the course of the day. I can understand your patience is running out, so I'll try and keep it short as well. Respected Dr. Bhasin, Mr. Sharma, Mr. Sharma, yeah, and friends. I did get a chance to, in fact, I did deliberately, I spoke to Ashima and I did watch the inaugural session on my phone, so, to hear the views, particularly to get the contours of where we are headed in terms of our discussion on the legal dimensions of global trade and 2047. So you might come across some references from the discussions in the inaugural session, which are deliberate and very well picked up from there. I'll try and keep it short. The journey towards 2047, we have been talking in terms of numbers, 10 trillion, 8 trillion, 7 trillion. So obviously we're talking about wealth creation. The journey that we foresee as a nation is of wealth creation, inclusive growth, and sustainable development. Now, it's important as lawyers, with my humble input, that we always think in a broader canvas when we're talking about where we stand in the journey to 2047, as you'll notice as I talk over the next few minutes. All issues that we discussed are very relevant in terms of how the profession should be liberalized, in terms of what specific changes should be made to certain laws, in terms of how initiatives should be made to simplify or rationalize the laws. But all this has to be looked upon on a larger format of governance. And if we do that, then we'll probably see where we all fit in, and we'll be able to understand the change and be a part of the change more effectively. Wealth creation in this country, as you would have seen over the last decade or so, is not a crime anymore. Wealth creators are seen as employment generators. In fact, wealth creation or empowering a nation with a strong economic base, a strong manufacturing base, is actually results in reducing the vulnerability of that nation in the global stage. A strong business is not a business alone, but it's important for a national security. And when we look at the way India is emerging as a global leader and the way we see India over the next 2.5 decades, moving from the different categorization as a developing country to a developed country to a global leader, issues of national security, issues of national interest become paramount and always get intertwined with the strategies, policies, and lawmakings across sectors at the broad scale and at the micro scale, and the legal sector is very much a part of it. So let's try and understand what is this journey to 2047 in Amrit Kal. The journey to 2047 essentially should envisage that consumers and common persons are in fact partners in the process of development. The governance model during this period is an inclusive model of policy and lawmaking. Citizens are not subjects being governed anymore. They are partners in governance, and that therefore also has implications in how the legal sector is governed or policies made defining the future of legal sector. So if we were to ask a common person who is not a lawyer, but who has a say in how a legal sector should evolve, much like any other sectors, if we were to ask a common person about what the vision should be for a journey to 2047, possibly some of the areas that a common person would be able to identify is that there should be a poverty eradication, there should be equal economic growth, there should be universal healthcare, quality education for all, gender equality and women empowerment, social inclusion and empowerment, rural development and agricultural transformation, environmental sustainability, and there could be many more, depending on who is answering the question. This would answer the observations of some of our panelists today of why FTAs also have provisions relating to gender or human rights and so on and so forth, because the vision of development always envisages covering all these aspects. Just spending a minute more on that while we are on the FTAs and the social aspects of cross commitments amongst nations. Business and human rights, as we are aware, has already achieved a scale of being enforceable by laws enacted in a few countries. So therefore, a supply chain requirement for a product manufactured in any part of the world, if they have to be supplied in some specific countries, France and England and so on and so forth, if there are violations of business human rights, the exports cannot be made, and if the exports are made, hefty fines are imposed. Now, there have been occasions when India had been pushed to have a similar BHR law. United Nations has a model BHR law already in place, but then we are very differently placed. The journey that the so-called developed nations have already made over the last 7 to 8 decades and reached where they are, we are in the process of the journey. So human rights to us possibly has to be looked at in a very localized manner. We have a very old traditional system of home manufacturing units in terms of families manufacturing traditional goods, and therefore if you apply BHR standards of the West, it does not meet the Gram Udyog vision that we have as a part of our governance. So why I flag this is that we should not simply copycat everything the West says about human rights and social aspects. It should always be localized to where we stand, what our vision is, and where we as people want to head. Now, having said the vision of a common person for 2047, what does it entail for lawyers? When I say lawyers, I'm talking about individual lawyers, law firms, anybody who is in the practice of law. The journey going forward at a very broad scale has to be an era of innovation, adaptability, and competitiveness. Building these key pillars should be able to give global leadership to the lawyers from India across jurisdictions. Competitiveness is going to be a key as we progress to meet the legal needs of Indian clients or Indian entrepreneurs or the common citizens in India within the country as well as in different jurisdictions. Emerging business models are becoming more border agnostic. Therefore, the legal profession also has to be prepared to be able to work in a border agnostic environment. And therefore, the need for increased levels of competitiveness to be able to work across jurisdictions. Walls of protectionism are a matter of the past because protectionism to the legal sector may not equal to easy access of law to a common citizen. So therefore, since the objective and the vision is people-centric, protectionism is a matter of the past. Opportunities and challenges for the legal profession, for the lawyers, need to be assessed on a global scale to contribute to India's journey to 2047 and beyond. Before I conclude, I wanted to touch on the role or how different stakeholders would need to walk the talk during the journey to 2047. As a common person or citizen, our learned Attorney General earlier in the day talked about ease of being in law. What would ease of being in law mean to a common person? It could have a certain meaning to a lawyer, but what would it mean to a person, a normal citizen? Well, firstly, access to justice, which we have been talking about for many decades now. And significant amount of work seems to have been done, or actually has been done, over the last few years in terms of bringing the courts, data around the courts, proceedings or accessibility of court proceedings, accessibility of pleadings, ease of filing, ease of participating in ongoing hearings. These developments that have, especially post-COVID, which have transformed the experience of a citizen who needs access to justice compared to what it was before. The other very significant aspect along with this is access to law. Access to justice is required when somebody has a dispute. But every citizen in this country, every person who is born in the country needs access to law from the time that one is born, right from the process of birth certificate to the last journey. And that would involve every piece of the walk, whether on the education side, professional side, family side, real estate side. So without walking into the arena of dispute or having a list, access to law is something that needs to be available to the entire population of India. This is definitely therefore an obvious area of thrust. People-centric, people-involved policy making, as I mentioned. Services sector, therefore, and including the legal services, cannot therefore be dealt with or walk the talk in isolation. So it has to be a process of constant dialogue and constant assimilation in the process of development and growth from 2024 to 2047 for the legal sector. Coming to lawmakers, Dr. Bhasin very rightly mentioned earlier in the day about rationalization of existing laws. This and much more in terms of making access to law, even rationalization of the law is a part of an easy access to law to a common citizen or to a business house or to a lawyer, any stakeholder for that matter. A lot needs to be done and obviously is a part of the initiatives which are underway. Arbitration law was talked about in great detail in the previous session. Now, arbitration law is an area where, much like any other law, insolvency, many others, where based on learning, improvisations are happening. We have amended the arbitration law many times over, and I'm sure further changes, as may be required to make India a hub for international arbitration, would also be carried out in times to come. Learned AG already informed us today, earlier in the day, about the setting up of the arbitration bar and a permanent seat in the coming future. Simplification of language, so talking about access to law, simplification of language, consistency in use of law and interpretation between what the law says and how the judiciary, the language used by the judiciary. Therefore, the need for a common word bank, the need for a common phraseology, some very simple elementary issues, but when we look at the letter of the law and the letter of the way a judgment is passed, we see glaring gaps between how that same law has been read differently, in most cases inadvertently. So therefore, bringing consistency through authenticated word banks and phrase banks is again something very important. Authenticated repository of law available to every citizen. A couple of years back, we would have said delivery of law at the doorstep, but I should now say the delivery of law on the handphone. So therefore, even the method of outreach to every citizen is very important. And before concluding on legal professions, I say legal professions with a sense of seriousness because legal profession as practitioners should not be seen in isolation, as multiple stakeholders together compositely make up the legal professions, which is responsible for enabling access to justice and access to law to a common person. This would include practitioners, judiciary, institutions, law schools, other legal service providers. All these classes of service providers and stakeholders therefore need to work together in synergy in this journey to 2047. To close my discussion, I want to just mention that the journey to 2047 is a journey of delivery, governance of delivery, and delivery of law, justice, well-being, ease of access in whichever way we understand to every common citizen. And therefore, when we talk about the different aspects of making work life or easy to operate for lawyers in the legal space in the many ways that we discussed today, we should always keep the aspect of delivery of justice and delivery of law to the common person at the center of our discussion. That would enable us to assimilate our thoughts, assimilate our discussions to the governance model and to the proposed policies or the policies that are likely to be made in times to come. We all need to walk the journey together. Thank you.
Thank you, sir, for your enlightening words. I would request DG SEPC, Dr. Abhay Suna, to kindly felicitate Mr. Manoj Kumar, Additional Secretary, Ministry of Law and Justice. Sir, kindly do the honors. Now, next in the sequence, I would like to call upon Dr. Lalit Bhasin, President, Society of Indian Law Firms and Founder Chairman, SEPC, to give the closing remarks, please.
Dr. Manoj Kumar, Additional Secretary, Ministry of Law and Justice, and a very close friend. It's indeed a privilege for us to have you here. You are now a bureaucrat in technical terms, but we still treat you as a part of the legal profession and as a part of one of the most eminent law firms of the country, which he was heading, Hammurabi and Solomon, before the government of India requested him to have a lateral entry from being a managing partner of Hammurabi Solomon to the position of additional secretary in the Ministry of Law and Justice. I have had the privilege of knowing him for I think more than 2 decades. We have worked together in the field of Society of Indian Law Firms, in the field of legal education, and how to strengthen and promote, good legal practices and inculcate the spirit of professional social responsibility. He has been a champion of liberalizing the legal services sector, a very outspoken person, who believed that India's future also, the profession, not only profession's future, India's future also lies if the legal profession is liberalized, But liberalization, he emphasized, has to first start with liberalizing Indian profession. We are now used to, as a bogey or as a it's a fashionable statement, allow foreign lawyers, foreign lawyers. No one speaks out, you see, how to liberalize the Indian legal profession. We still have so many restrictions in our right to practice. And we are talking, you see, of competing with the foreign lawyers. Dr. Manoj Kumar had rightly pointed out earlier on many occasions, why can't there be a level playing field? Those foreign law firms can advertise in electronic media, on the television, in newspapers, in law magazines. I have heard myself sitting in New York in a hotel, one lawyer saying, if you want a divorce, come to me, I'm a specialist in that. Someone saying, if you are met with an accident, you please come to me, I'll get you the maximum compensation, I am the ambulance chaser. This sort of a thing is happening in the foreign countries where legal professionals are advertising. And in India, we cannot even have a proper website. It is as a result of intervention of the Supreme Court that a limited, you see, website is permitted, just giving the names and address of the law firm. That's all. And look at the websites, you see, of these foreign law firms and all that. They have a right to have their entries in the law directories, take out of their firms brochures, and you see, circulate them at the international conferences and events. But in India, we can't do it. They can have hundreds of partners in their law firms. In India, we can't have more than 20. LLPs are still not workable here. So where is that level playing field for the Indian profession? And we talk about liberalization means only allowing foreign lawyers. But first, let us try to do something, you see, for the Indian legal profession. And I don't mind being quoted even to the Bar Council of India, that Bar Council of India has totally and miserably failed in protecting, you see, the interests of the Indian legal profession. Now they are also crying out with the bogey of foreign lawyers by bringing out some ill-conceived, ill-drafted rules which they have themselves kept in abeyance. But here we are talking, why should we be talking of foreign lawyers? This is Services Export Promotion Council. We are talking about export councils. So why we are not talking of export of Indian services to overseas? But we want to focus on foreign lawyers coming to India. Is it export of services? Am I right or wrong? Is it export? So no one talks about permitting, you see, Indian lawyers. Our legal profession is second to none. And I'm sure Dr. Manoj Kumar will affirm this. Our profession is second to none. Even our litigation lawyers are best in the country. They charge, I think, the highest fee possibly in the world. Even while sitting in London or somewhere else, they charge the highest fee. So they are second to none. But even the law firms have they have the competence, they have the caliber, they have the resources, and now they have the use of the latest technology also available to them. So why can't our law firms, you see, be permitted to have offices outside India? That is export of services. Actually, this also should have been a topic. Why India? There is an agreement. The UK government says that you can come and open your office here. Yes, on paper they do allow. I have seen it myself. I had a discussion with their Minister of Justice. They say you can come, you can open your offices here. But then I came to know that some Indian firms had tried to open their offices but they were not given the work permits. Now, how would they function without the work permits, that is the visa? You don't give them the visa to work there. This is all lip service being given. There has to be like a level playing field, and we should be discussing export of Indian legal services to outside countries, you see. If we want, we are talking of reciprocities. Reciprocity is not one-sided. It has to be both in practical terms. We should be allowed. It will be difficult in US because we have to deal with each and every state in the US. I think 49 or 50 states they have. So we have to deal with them, you see, to decide that. So that is one way, and Dr. Manoj Kumar rightly pointed out, journey to 2047, from Amrit Kal to Viksit Bharat, 2047. It's a very important journey, you see, but where the legal profession has to play a very important and significant role. When we talk of economic development, can there be any economic development without legal support? It cannot be. You need expertise of lawyers to draw up bilateral agreements, to draw up protocols, conventions, joint ventures, mergers, acquisition, everything you need legal support. Therefore, for a proper economic development, legal support is very essential, and that is where the legal profession has to play a very important and significant role, not just in the matter of earning fee. As a result of, they're entitled to earn their fee, whatever they want, but also as an issue of professional social responsibility. We have to give to the country, which has recognized us as members of the legal profession. Mr. Manoj Kumar rightly pointed out that this is a journey to deliverance, you see, from all what we are experiencing today, the difficulties. So this journey will culminate hopefully in a very brilliant way, glorious way, taking Indian economy, Indian position to pinnacles of glory. We are already on that path, but 2047 should be that culminating point, you see, of reaching our pinnacle of glory. He rightly pointed out our human rights issues may be different from human rights issues of the Western and developed countries. When they talk about countries like Asia and other countries, they have different assessment or values for human rights. But when we talk about, you see, the suppression of human rights in those countries, they think we are interfering in their internal affairs. I think there are more violations of human rights in those jurisdictions than possibly in India. Aberrations do take place in India, but those are still aberrations. That is not the rule we have. I would also like to touch upon two issues which the learned Attorney General had said, and I don't know how it will work out. He said that their government is taking steps to set up a arbitration bar. How can this be done by the government? Government can't keep on setting bar associations. It is a voluntary act on behalf of the professionals. Will it be a government-sponsored bar association? Will they select, you see, some lawyers and put them in an official, what they call arbitration bar association, and entrust selected cases only to those lawyers? I think I could not understand what the learned Attorney General was trying to spell out when he said we are proposing to set up a arbitration bar. That initiative has to come from the profession. We, the practicing lawyers, have only exclusive right, you see, to make any bar association we want. We have set up this Society of Indian Law Firms. Government is not a party to this. It is a voluntary act on behalf of all the bar associations of this country to come together and create an institution of excellence. Similarly, Bar Association of India, Supreme Court Bar Association, our High Court Bar Association, they are all voluntary organizations. Bar Council of India, of course, is a statutory body. But I could not understand how this government-sponsored bar, arbitration bar will be set up. And I would request Mr. Manoj, Dr. Manoj Kumar, just to look into this aspect as to what are the steps being taken in this regard, because otherwise it will be a very retrograde step, which will not be taken lightly by the profession, because you are intruding upon the role and independence of the profession. Either the idea is to give those arbitration matters only to some selected few they will enroll as members of that bar. I don't think that is the correct way to go about it. And we had very, very interesting sessions, as Mr. Rakesh Sharma also pointed out. Liberalization, we have already discussed. Evolving global supply chain for legal services. AI in legal practice, very important. Although my view is that AI cannot substitute, you see, the human brain, because AI can be a tool in assisting our legal professionals and particularly the young members of the bar and students in doing some research and trying to find out something. But for writing judgments and all that, you can't use AI. It will be disastrous, you see, if AI is relied upon for writing judgments and relying upon AI for that. For that, you have to rely upon real intelligence, not artificial intelligence. And real intelligence only lies here, you see, nowhere else, because each case has to be decided on its own facts. And facts of no two cases are similar. Therefore, there has to be an application of mind, not application of AI for disposal of matters. And this disposal needs to be, which I pointed out earlier in the day, we need to do something about these 5 crore cases which are pending, and they will keep on mounting and all that. And then we had role of the FTAs, of course, very important for bilateral. Recently we had with the 4 countries of the European Union, but we await now to have a formal FTA with the entire European Union. It's only with the 4 jurisdictions, 4 countries, that some FTA has been signed. With the UK, it is still in the pipeline. One of the sore points was legal services in the UK.
You actually mentioned, sir, just a while back about Indian practitioners practicing. That can be a part of this.
Yes, yes. And the last session was very, very interesting on dispute resolution, arbitration, mediation, because new laws have come in, Mediation Act has come in, several amendments have been taking place. Amendments only show that the laws, when they were originally framed, there is some deficiencies in those laws. Therefore, you need to keep on amending the laws. Take, for example, the Arbitration Act. After 1996, it has gone several, you see, it has seen several amendments and all that. And at the drop of the hat, if we don't find any solution, we bring in new laws. Now, what is the need to have a mediation act? Mediation is a voluntary, you see, solution. If the minds agree, they will agree for mediation, and eventually that will result in. Therefore, all this needs rationalization, as you very rightly pointed out, that we need to have serious application of mind for rationalizing law by obliterating, you see, the obsolete laws which are 1800 something, some early 1900s and all that. And not just to bring new laws for the sake of it, because that will help only lawyers, more dispute, more regulators, but it won't help the country, you see, as a whole. Therefore, to achieve our goals of 2047, I think this particular conference has played some very, even though minimal, but important role. And this will be followed by some other events of similar nature, not just in Delhi, but even other places. And I thank Mr. Rathore, the chairman of SEPC, for taking this initiative, along with Mr. Rakesh Sharma, who represents the legal profession in the Central Governing Council of SEPC, and last but not the least, Dr. Abhay Sinha, for their untiring efforts, assisted by Soumya Gupta here, very, very efficient, for putting in place, you see, as Mr. Rakesh Sharma said, 35, 40 speakers, we had of this, and all of highest caliber. The contribution has been significant, and it is my privilege, you see, to offer my sincere thanks and congratulations and best wishes to all the SEPC members as its founder chairman. Thank you.
So your words have filled up again like a new lease of enthusiasm and energy to take it forward. Thank you, sir.
Thank you so much, sir, for your enthusiastic words. And as we come towards the closure of this remarkable brainstorming and insightful deliberation, I, on behalf of SEPC, extend a sincere thanks to each and every one of you who have contributed towards the successful execution of this program. First and foremost, I would extend gratitude to our delegates, without whose participation the entire effort would have no meaning to it. Next, I would like to appreciate our esteemed speakers whose immense knowledge and thought-provoking inputs during the sessions has made each of the sessions so fascinating that the audience couldn't tear themselves away. We are really grateful to you for setting aside your other engagements of this weekend for this conference. And a special mention of one of our esteemed speakers who has traveled from Dubai to attend this conference. And also our overseas speakers who have spared time to join us virtually. Thank you. Next in line, I would like to thank all the dignitaries present on and off this dais who have contributed in making the program a little extra special by their presence. I would like to thank Honorable Attorney General for India for making time for this program despite of other programs coinciding with this. I would like to thank Mr. Manoj Kumarji, Additional Secretary, Ministry of Law and Justice, for accepting our request and for gracing the program at such a short notice. Thank you so much, sir. We are privileged by your presence. I would like to thank Dr. Lalit Bhasin, who is the driving force behind this entire program, who has been, sir, you have been a constant guide and you're well known for your prompt response and eagerness to serve the fraternity consistently over the years. Sir, you are really a source of inspiration for all of us here. I would like to thank Chairman SEPC, Mr. Karan Rathore ji, in being the flag bearer of SEPC. I would like to extend a sincere and special gratitude to Mr. Rakesh Kumar Sharma ji, Chairman Legal Sector SEPC, in enabling us in successful execution of this entire program and being with us throughout the day and throughout this program. I would like to extend heartfelt gratitude to our knowledge partner and also the prime partner for the program, Saraf and Partners, in extending your trust and support to us.
Did you say crime partner?
No, prime partners. Did I say so? If in case there is any fault, like we committed a crime in doing this, then a crime partner. Crime partner for the program, Seraph and Partners, in extending your trust and support. We are overwhelmed in receiving all sort of support from your team, that too at such a short notice. And a special mention of Mr. Mohit Saraf, founder and managing partner of Saraf and Partners, and your entire team, that despite of such a busy schedule, you were so prompt in responding. Special thanks to our supporting partners for the program, Society of Indo-American Chamber of Commerce.
What society?
Self. Okay.
It is Society of Indian Law Firms.
Okay, Society of Indian Law Firms, thanks for correcting. IACC. IACC and SELF, Center for Trade and Investment Law, Denton's Link Legal, Legal League Consulting, Frenaya Legal, GRC India. Thanks to our media partners, BW Legal World, Live Law, and other media houses for extensive coverage of this entire program on print and electronic media. Thanks to the venue support staff and administration. And this list would be incomplete without mentioning the effort of our DG, Dr. Abhay Sinha, under whose able leadership Team SEPC has executed this program. And the multiple hands of entire Team SEPC, whose collaborative and unified efforts has helped in the seamless execution of this program.
Yeah, to entire team.
Yes, a huge round of applause and thank you to everyone from the Team SEPC for helping us in putting up this program in such an effective manner. Thanking everyone else who has directly or indirectly contributed in this success of this program. With this, we come towards the closure of the day with many takeaways, connections, and memories.
Thank you,
one
Soumya,
and
for
all.
standing on the toes throughout the day and throughout this entire journey of conducting this program. Thank you. A big clap for
We request everyone to wait here for the group photographs, please.
Essential part of the ritual. You also come.
Yeah, Soumya, please join.
Thank you so much, sir. Thank you.
Was your speech official?
These are the scribbles. I'll send you. I can email it to you because I made notes on it.
We have all the